Oh my. So I just popped into the chat, and one of the things I saw was Candace saying, "Where's Dan?" And I'm like, that must be a prioristic chat, because I'm right here, and I've been talking for the last 5 minutes. But what I didn't do was press go live on the stream, so I've just been hanging out and enjoying my own company. But that's fine. I think I remember everything I said, so we'll just let this song repeat, and we'll take it from the top. This is Welcome from Anno Domini Beats. Welcome to the stream. I'm Dan D. I hope you're feeling fine. Together, we're fine and dandy. This is Catillac. He's a cat. He likes to hang out with me on these morning streams. You see a little bit more of Lola when we're upstairs in the attic. You're not going to get feisty. Oh, you're getting spicy, aren't you? Okay, you're going down. Today's stream will be following the testimony of Dr. Julie Harper and Dr. Tanya Werner. Not the two biggest highlights of the Sarah Booniverse, ongoing discussion. But there's a lot to pick up in a rewatch here. Julie Harper came in right after Pearl Walker's testimony. Pearl Walker's testimony, as we closed off with in last week's stream, was punctuated by a sidebar with Mr. J asking that cameras not record laptops in the courtroom, which was immediately followed up by Kevin Beck coming back with his laptop and dangling it in front of the camera like he's never held a laptop the whole trial. Suddenly there's a warning about don't film the laptops. He goes out there just baiting the cameraman, thinking that maybe that'll be a mistrial because Judge Kraynick said don't do it, and it was done. I don't know what he was getting up to. I think we might start the stream from that stupid little moment from him. And if you want to see another stupid little moment for him, watch the trailer for this. Asking Pearl Walker, you didn't have any reason to think she was a drunk, other than them's drinking all the time? No, I don't. Alright, we've got about a minute left of the welcome song. I think that I've addressed most of the stuff that I talked about before. However, it is 30 seconds earlier than I closed off when I was streaming to myself. Uh-oh. That one says stream finished. But that's the stream that is done. Okay, yeah. No, we're here. Yeah, trying to set up a mistrial, exactly. Very clumsily, like everything else the Owens defense has done. Sorry, Disney Mom, this is a new thing I'm doing. I'm a troublemaker that way. I'm going to do a fake show before the real show. But it just ends up being an extra show, so it's not like it's... But yeah, it was a trick. So this was a trick. If you hadn't all come down here, you wouldn't be here right now. Okay. We will pause out the music. We will go back to full regular volume. I think I paused it. I have not paused the music. That's too intense. This is for, building up montage. Goodbye, music. All Dan D. All right, so there is Michael Kraynick. Let me get to my broadcast screen. I'm happy with that screen. Julie Harper is not on the stand yet, so we'll take that down. And good morning. We're starting the day on end of day 4. We'll be seeing Julie Harper introduced to the stand. As always, I've got the transcripts, so when transcripts come up, I will make them active on the screen as well as read them out. Thank you for joining me. Let's get right into this. I've wasted enough time. Nope, not quite enough time. Uh-oh. Why don't I hear? Oh, there is no volume. Oh, man. I get myself all freaked out here. Yeah, I used that because having Judge Kraynick as a still frame was better to focus on, but But that's just the very end of the discussion about no laptops, and we'll get Julie Harper in here ASAP.
Dark gray suit and maroon
there
blouse.
is.
Let's go ahead and bring in our...
Stupid Kevin. Okay, that's the sidebar I was looking for.
All right, we are back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. State appearances for the record.
Dave Kestro on behalf of the state.
Defense.
James Owens on behalf of Ms. Boone.
Tony Henderson for Ms. Boone.
Kevin Beck on behalf of Sarah Boone.
All right, Ms. Boone is standing at counsel's table wearing a dark gray suit and maroon blouse.
What a maroon.
Let's go ahead and bring in our jury as Dr. Harper is here.
I think from this point on, Juror 4 starts doing the hand thing in advance, and everyone has little smiles at it. But from this point of the trial onward, not Juror 4, Juror 3 is who I suspect it is, but he's sitting fourth from the left in the second row. They're definitely getting a little slower at bringing the jury in from the point that Judge Kraynick says, let's bring in our panel.
All rise, jury's in.
God bless the great state, or the Commonwealth of Massachusetts. So help us God. All rise. Thank you for spending your
State, you
mornings with
recognize our
Dan D.
jury?
Yes, Your Honor.
Defense, do you recognize our jury? All right, thank you. All could be seated. Again, members of the jury, if you could, just raise those hands, confirm you complied with the court's instructions. Record reflect all hands have been raised. All right, defense, at this time, you may call your next witness.
We call Dr. Julie Harper.
Doom doom da doom doom da doom doom da doom. Dun, 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 dun. Bum, 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 dun, 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 dun.
I do.
Doctor, good afternoon. Could you state and spell your name for the record for us?
Dr. Julie Harper, Harper.
Thank you. Counselor, you may inquire.
Thank you, Judge. Good afternoon.
Good afternoon.
I think you've already stated your name, but just introduce yourself to the jury.
My name is Dr. Julie Harper, and I'm a licensed psychologist.
Before she gets the chance to say anything, I'm going to kind of give us a chance to just tamp it down a little bit. Initially, her qualifications, I think, are as impressive as anyone's else's should be. So it's not a qualifications issue. It's not, I think she's competent of giving better testimony. I think for whatever reason, she's isolated that if she can be a dependable defense witness, she's going to get more calls from people who are indefensible. And, you know, that's probably a pretty good business in Florida to defend the indefensible. But yeah, the beginning qualifications, I'm not going to hate on the qualifications. I think she's qualified. I think she's just chosen to represent reprehensible people.
Would you tell the jury your educational background?
I have an undergraduate degree from Oberlin College in biopsychology. I have a master's degree from University of Denver. I went on from my master's degree to earn a psychological doctorate. That's called a PsyD. That was also from University of Denver. In completing that education, I specialized in psychological assessment, which means I had extra coursework in that area of learning to administer psychological tests to other people. I completed an APA-approved internship at Washington State University, which means that I was matched, and that was my site to practice being a psychologist for a full year, and that was between 1999 and 2000.
One note there, she said Washington State. That may possibly be the reason why it is a YWCA Spokane PDF of the Power and Control Wheel. that we often see on the desk. Julie Harper was part of the case from an early stage. So it's very possible that if she was working in Washington State, that is a document she was familiar with due to, local organizations. And that may be why it was suggested to James Owens as, get your client to take a look at this, see if anything resonates.
And following that, I turned in my dissertation, which was in the passing of power in couples relationships. I then graduated and started my postdoc work in Pullman, Washington.
I've just reduced the volume slightly on the court audio because her P's are kind of popping. So,
as part of becoming a psychologist, you have to have over 1,500 to 2,000 hours of supervised work as a psychologist. The person that supervised me was a forensic psychologist. So during that postdoc time, that was my introduction to forensic work while I worked at a community mental health center.
Dr. Harper, how long have you been licensed?
I was first licensed in Washington State in 2002, so 22 years.
What type of position have you held as a psychologist?
Well, I was rehired at my internship site, so I worked at Washington State University College Counseling Center. I also worked 2 times at a community.
Lakeisha Prelow hitting the chat on fire. She reminds me of Sad from Inside Out. Oh, Sad was voiced by, oh God, she was on The Office with the dark hair, married to Bob Vance from Vance Refrigeration. Bob Vance, Vance Refrigeration. Bob Vance, Vance Refrigeration, which shows why repetition works, because I still remember Bob Vance from Vance Refrigeration, and I remember her name. Anyway, she voiced Sad, who Lakeisha Prelow is reminded of in watching Julie Harper.
Mental Health Center. The first time was in Pullman, Washington, and that was during the period of time where I was getting my postdoc hours completed, and then I stayed on after licensure.
Phyllis.
I also worked in Florida. When I came to Florida in 2005, I took a position in the Fort Walton Beach area at Bridgeway Center, which is a community mental health center. And while working there, I completed a variety of psychological assessments. I was directing the testing program. I also began working during the Department of...
And welcome to the stream, Word Nerd and Given Up. I haven't seen either of you in the chats before, but I appreciate you piping in both to help out with Phyllis and to join the Dan D community. Thank you for being here.
Juvenile justice contract work.
Hey, Paintbox.
Evaluating adolescents that had gotten into legal trouble.
Hell
and
yeah,
needed an
Charles,
assessment for
Juror
consideration
3.
of program placement. I worked in that community mental health setting, doing clinical assessments and the DJJ contract and Social Security evaluations, and continued that until about 2010. In 2010, I opened my own private practice, which is Northwest Florida Psychological Services. And in the beginning...
Love the cameraman's unforgiving zooms on Sarah. Like, oh yeah, you don't want me to look at the laptops? Fine, let me just look in her ear canal.
Of the practice, it was a combined clinical and forensic practice, meaning that I spent a majority of time doing psychological assessments to answer questions from physicians about things like ADHD, depression, to make treatment recommendations. I had the therapy patients, and I also did, again, Social Security disability evaluations, so numerous kinds of assessments. And then over time, I began doing more and more forensic work, including receiving appointments from judges to do competency to stand trial evaluations, sanity at the time of the offense evaluations for Circuit 1 in Florida. And I continued to do the Department of Juvenile Justice contract briefly, but then that it came up for bid and I discontinued that contract. What I did is I slowly reduced my clinical practice, because when you do forensic psychology, it means you have to travel. Your individual.
This is actually the same thing Michael Brannon was saying about his forensics practice. He went from treating individuals to the more he spent time in forensics, the more time he had to spend in forensics.
Individuals that you're seeing are not usually out in the community. A lot of times you have to see them in jail.
Oh, and interesting thing about Dr. Julie Harper. So they've been hustling to get her here. Like in some of the previous sidebars, you hear Owens like, "I'm trying, Your Honor. I called her. She didn't call me back. I tried her by text. I think she can be here by noon." Anyway, Julie Harper was testifying in, was it the Frederick? Well, I want to get the name right. Last name Bailey. He's was on a death penalty case in Orlando. He was a convicted cop killer that was trying to mount a defense of insanity. But one of the, kind of like Sarah, one of the things standing in the way of that defense was recordings of himself saying, "Hey, wouldn't it be great if I could get myself declared mentally incapable? Then I won't get the death penalty. Then I'll get this. Then I'll get that." So Julie Harper just got here from testifying on his behalf as an expert on the 22nd. 22nd? Yeah, because the news article is from the 23rd. If we get sick of listening to her voice, I'll take a quick break from listening to her talk to read from that news article.
So it's hard to maintain a therapy practice, and I scaled that back over time. Eventually, my practice became entirely forensic. And then in 2017, I took a job with the state of Georgia to be an evaluator full-time. I was working doing competency to stand trial and sanity at the time of the offense evaluations, and then assisting with risk assessments in the inpatient setting. I did that until 2021. At that time, my private practice was just quieted down, of course, from COVID, and I was not in full-time practice, so I wished to return to full-time practice with my own company, and I did that in May of 2021. And since then, obviously the courts are busy again. We're all recovering from the COVID era and back to full-time practice.
Now,
Disney Mom's calling for that break.
I live in Okaloosa County, and that is in the panhandle of Florida.
and is that where your practice is currently?
Another one to
Yes.
say you're going to miss out.
Is it fair to...
I'll give another pause here because I can see some people already rebelling against the sound of her voice. Maybe I'll take some more pauses for commentary just to help you guys through this. Maybe I'll put on, well, we'll figure something out. Stick with it because she's annoying, but the sidebars, I haven't read the sidebars, but I know there are sidebars. And I think this is the beginning of Judge Kraynick getting frustrated with roads that James Owens is trying to travel down in his courtroom. So I don't know. I do have a sidebar thing. So if you're watching with sound off, if you see, let me see. I thought I had. Oh, go to this screen. All right. If you see us on this screen with that text up, it means we've taken a break from listening to her and I'm reading the sidebar. So if you want to scrub ahead, this is the screen to look for, and we'll go back because it's not that good quite yet.
Say you travel the state to...
Bless you.
Is it fair to say you travel the state
Judge Kraynick never misses a sneeze.
to do assessments or evaluations?
That's correct. I travel to a lot of cities throughout Florida, as far south as like Miami, and then of course working along other
Is it
cities.
fair to say that you testify in various counties throughout the state?
Yes.
And I know that...
We'll take a quick break from Julie Harper's testimony to mention that Charles Grieve was stuck with all the freaks on the plains. Hari Krishna's zealous all the way from LA to Paris, and a rhapsody in beige polyester trying to get me to date her daughter from London to San Francisco.
Yesterday, you were set to testify in Bay County, Panama City.
That's correct. I was testifying yesterday in a death penalty case in Bay County.
All right, and when you finished, you drove here?
Yes, I did.
My understanding is you got here after midnight.
Yes.
So they're trying to give a little bit of, oh, you got here after midnight? Let's have, let's all feel bad for Miss Harper. I'll turn down the court audio slightly more. It should still be audible, but let me know if I'm getting too aggressive here. Might just make it easier to listen to.
What other counties have you testified in?
Well, I've testified here in Orange County. in Miami-Dade, in Duval. It might be hard for me to list everywhere. Alachua.
Sad part is for me, it's the exact same volume. All I'm doing is bringing down the output volume, so I can see that the bars are more in the yellow than more in the green than the yellow now. But yeah, let me know if I go too quiet. I have to listen to her at full volume regardless.
Escambia, Santa Rosa County, Walton County, Bay County, Washington.
So
And Owens is making her take a geography test. What are the different counties of Florida? How many of them do you work in? I didn't prepare any questions, so I'm just winging it.
just so the jury understands, the nature of practice is you have to travel throughout the state.
Well, I do work in cases where the person is at risk of, succumbing to the death penalty, and so those cases require repeated evaluations in different vicinities, and so I have been, traveling to work on murder cases. There are psychologists, I suppose, that do forensic work that might just confine their work to one circuit or stay, but I actually broadly travel.
You said that your practice is now entirely forensic?
That's
Is that
correct.
what you said? And you've testified about what kind of forensic work you do?
Yes, so as a forensic psychologist, sometimes I am tasked with testifying about something very specific. So for instance, a person's ability to stand trial if they're knowledgeable and can go forward with their trial process.
And that's exactly what she was testifying to. You know what? Let's take a little break from Julie to go to that. Here is my news read window. And I think I have just a little information on what she was doing. Summarize it better than she could say it herself. Convicted killer claims mental illness heavily influenced his actions. This is a story by Courtney, excuse me, Courtney Fegley. It was written on October 23rd, 2024. Panama City, Florida. Convicted killer Robert Bailey's attorneys argue his mental conditions heavily influenced his actions when he shot and killed Panama City Beach Police Sergeant Kevin Kite on March 17th, 2005. During his trial nearly 20 years ago, Bailey tried to use the insanity plea. He was diagnosed with bipolar and personality disorders, leading some to believe he was crazy. In this excerpt from a jailhouse phone call Bailey made to his friend, he explains why it'd be beneficial for him to plead insane. They can't try me if they find me retarded or crazy. You go to the nut house for 5 years, brother. If they don't find you competent within 5 years, after 5 years, they legally find you not guilty by reason of insanity. Then you stay in the nut house. If you get better after that 5 years, they let you go home, Bailey said. The court didn't believe Bailey the first time, sending him to death row. During his second sentencing, Bailey's attorneys are trying to get him a life sentence. They say there are several mitigating factors that jurors should consider before deciding on the death penalty. The evidence is going to show that he's a pen pal to many people, a comfort to many people. He writes many people. The defense is going to show that he cares about his family members, that he has a cousin that he cares for. He's changed, defense attorney Philip Massa said. The defense called their first expert witness to the stand Tuesday. Licensed psychologist Dr. Julie Harper says Bailey still suffers from early childhood trauma. They are growing up in the poorest neighborhoods where the gang violence is all around them. Their stepdaughter also engaged in physical abuse of the boys, both Mr. Bailey and his brother, Harper said. The state argues Bailey is faking his mental conditions, but Harper says that's not the case. We did a forensic clinical interview, the mental status examination, and a test called the Miller Forensic Assessment of Symptoms Test, which is to see if there's any chance that he might be feigning and pretending to have mental health symptoms that he does not. He had a 0, so he did not endorse any symptoms, Harper said. Testimony will pick back up on Wednesday. Bailey was originally sent to death row on an 11-1 jury recommendation. The U.S. Supreme Court declared Florida's death penalty unconstitutional because it was not unanimous. If jurors send Bailey back to death row, he'll eventually be executed with a lethal injection. All right, that was a news break. And let me return you to your regularly scheduled programming.
I've testified about a person's sanity at the time of the offense, meaning if they had a mental health condition that met the statute as to not being sane at the time of the offense.
And I'll give you an update on the results of her testimony in that case in about 10 or 15 minutes.
I've testified in sentencing hearings. I've been an expert witness for Department of Children and Families. I've testified in vocational rehabilitation hearings as their expert, in what's called social investigation. That's what they used to call custody evaluations. So in a numerous capacity.
Thank you, juror number 3.
And would it be fair to say that a lot of times you're appointed by the court to provide the service that you provide and you're paid by the state?
That's correct.
What percentage of your work is where you're paid by the government to do the work?
I would say that the majority of my work comes through with that court-appointed funding. Percentage-wise, probably about 90%.
Okay. Now, I realize you testify on occasion by the state, but majority of your time, 90%, 95% of the time, you testify on the behalf of the defense?
Yes, the evaluation's complete, and either side can call me for testimony, and the majority of the time I'm called by defense.
And so you make a living by traveling the state, and generally the court system, I think they call it JAC, pays your fees.
So I make a living by performing work as a forensic psychologist, evaluating individuals, most of the time that are incarcerated in a prison or a jail setting, providing consultation to attorneys who might just have questions that would need a psychological expert to explain something to them. I also do fitness for duty evaluations for law enforcement, pre-employment evaluations for law enforcement and firefighters. So depending on the work that's needed, I do those.
Doctor, how is a forensic psychological evaluation different than a regular psychological evaluation? Can you tell the jury?
Sure. So if any of us went into a psychologist's office and had an evaluation done, it would be most likely for treatment. So things like if you qualify for surgery or you're going to have treatment, maybe you've got a condition that you want therapy for. A psychological assessment is very helpful in identifying a diagnosis and then setting a course for treatment. A forensic psychological evaluation has many of the same procedures, but the aim is really different. The aim would be to answer some kind of legal question that is posed. So as an expert, I might be in the position to provide some education or experiential descriptions of something.
Shout out to Lakeisha Prelo for the comparison in the chat.
That a person might be suffering from, to people that are going to make a decision. So for instance, if it's a competency evaluation, I would educate the fact finder. In that case, it would be a judge about what is wrong with the person, or if they had any deficits at all, or if they were competent to proceed. In a situation like this, a forensic psychological evaluation might be geared more to identifying, again, if there is a mental health condition present in the defendant I'm evaluating, and then to provide a jury with education about what I found in my evaluation.
Disney Mom chimes in. Ms. Harper, how many people who come in for evaluations run screaming from your office?
How many forensic psychological evaluations have you conducted? Estimate.
So just as an estimate, it's clearly more than 4,000. I've been doing forensic psychological evaluations as far back as 2007.
Have you been qualified as an expert to testify in forensic psychologist in court as a forensic psychologist?
I have.
And you said you've testified for the prosecution.
Yes.
And you've testified for the defense.
Yes.
Is there any difference in the work that you do depending on who hires you? Which side?
Absolutely not. A forensic psychological evaluation is an objective assessment of what's going on with the person. So you should be performing the same kinds of procedures in doing the evaluation. It should not matter who's retained you. What you're trying to do is answer a question.
Next poll for Chad
Are there
is
times
Julie
when
Harper
you actually do an
objective.
evaluation and assess an individual, but then you're not actually called to testify?
Yes, many times that's the case. You will provide your feedback to the attorney, and then it's up to the attorney to decide if there's anything in there that would be useful to them, or if they're pursuing a certain kind of information for the court, they would choose to call you for testimony.
Dr. Harper, do you recognize Sarah Boone at the defense table with Tony Henderson?
I do.
When did you first get involved with Ms. Boone?
It would have been in around June of 2020. It was the first I heard of her case.
And what were you asked to do?
A comprehensive psychological evaluation of Ms. Boone.
And did you do that in Ms. Boone's case?
I did.
Okay. Were you given materials to review?
I was.
Is that standard operating procedure?
Yes.
You assess the client individually, one-on-one, and then there are collateral evidence or material that you also consider?
Yes.
Can you tell the jury about that?
Yes. So in forensic work, there are a variety of documents that are usually available in assessing a defendant. In this case, for criminal court, you would see things like witness statements. There might be body cam footage or just more information about the offense itself. Sometimes there's an interrogation video. So you would get kind of the legal description of the offense and the things that have occurred. I also will often get educational records of a person, mental health records, hospital records, things of that nature that would describe their biopsychosocial history to me.
And you were given materials as it relates to Sarah Boone to review?
Yes, I have been.
How many times did you meet with Sarah Boone?
So 9 times.
9 times. Even if you're biased going in, you're like, okay, my job is to help defendants. That's what I do. That's what I'm known for. I can imagine the 3rd, 4th visit. You're like, okay, it's just my job. It's just what I do. Suck it up. Come on, Julie. This one's weird, but I'm going to do my job. But by 9 times, you got to figure that there's got to be some sense of like, oh, she's a bad person. She's reprehensible. I can't speak on her behalf. Like, she's an expert. She has more training than I do in the field, but I feel like if I had that level of training, I'd be able to figure out from 9 visits that you're not a good person. Narcissistic, borderline personality. I don't know. I'm not a doctor. I can't say those things. I can't diagnose them, but someone who is a doctor should be able to after 9 visits, right?
Can you tell the jury what you did as part of your evaluation of Sarah Boone?
Welcome, Michelle Fournier.
We had a clinical forensic interview in which I reviewed her background history, so her early childhood. I got to give a big thanks to everyone who's struggling. You knew Julie Harper's here. You guys who've tuned in, she's on the stand right now. You're sticking around. You guys are all stars. I really appreciate it. It's going to get better. You're putting in the work. These are the reps. I've separated this stream from the rebuttal stream. That's going to be next week. Next week is all dessert. Like, you eat your liver, you get to have dessert. Next week is dessert. It's the rebuttal. It's going to be just the rebuttals, the body cam. If we're having such a good time, I might even stick around for closing arguments, but we're going to start with closing arguments on the stream after that. But yeah, this is the bitter little pill we have to swallow, and a spoonful of sugar's coming up next. I assessed her with assessments, meaning I administered 3 psychological tests to her. I reviewed her.
Oh, and Tanya Werner, she gets a lot of grief because of the fact that she's brought up in the appellate hearing, and she was a little dismissive. She's a lot of fun. I think on the rewatch of the trial, the way we're feeling about listening to Harper now, we've probably all got the same looks on our faces as Tanya Werner listening to James Owens fumble around with his questioning.
Her prior mental health records, her interrogation video, some prior information about her legal history. So she had been previously arrested. I reviewed that as well. We had an opportunity to review the transcript of her interrogation video. So there were a variety of things that would...
That's interesting. They reviewed the transcript of it rather than just the video itself.
...be considered what I did with her.
Okay. So you considered some medical records?
Yes.
And did you also consider some records from George Torres's records?
I did see his hospital records.
Now, do you consider, in doing an assessment and forming any opinions, an individual like Ms. Boone's upbringing in terms of where they grew up and what their family environment was like?
Yes, that's part of gathering their background history, so biopsychosocial information.
And did you consider Ms. Boone's upbringing in forming any opinions?
I did.
Suze Watt says, wonder if she watched the Suitcase videos. And I'm speculating that maybe they discussed the transcripts from the videos.
Can you tell us a little bit about that?
Yes, so of her history, I found it pertinent that she was raised with...
Conduit 704.
Roach.
Here we go. Here we go. Here we go. Here we go. Okay. I am not prepared, so I'm going to just pause it so that I can go to the sidebar screen. People who've been listening with the audio off can be like, oh, shit, something's happening. But don't worry, because I'm also unprepared. How far back are we here? Just as a forensic, blah, blah, blah. Come on, approach. Because Mr. J, he's let a little bit go. He's going to start to really... I think this is maybe what pissed Owens off, too, so that Owens started objecting all kinds of stuff with Tanya Werner. But I don't think he had nearly as much reasoning for it. Okay, so what I'm going to do is let the video roll so you can see the response. Because I think Julie Harper can probably hear what they're saying at the... or some of it anyway. Because the court reporter... Well, maybe the court reporter has a little mic set up. In any case, okay, so we're on the screen. I got the transcript. The court, and I will read the transcript. Here we go. Court response, Mr. Owens. I'm sorry. Court. She can't be a conduit, Mr. J adds. Court says gateway to admissible hearsay, Mr. Owens. In terms of, court says, anything that Miss Boone said to her. The question pertains to, in terms of that a father passed away when she was in high school. Court says if she's going to be eliciting statements that were provided by the defendant to her, it is inadmissible hearsay. What about materials that she may have been provided in writing? What about that? Records and whatnot. That's not pending before me right now. Right now, my understanding is that she's going to be testifying to specific statements that Miss Boone has made. 90.704 prohibits that. So the objection is sustained. You can revisit it in another way, but the question is it's phrased right now.
The objection is sustained.
I don't know how, but I'll try. Okay.
Would you have considered, as part of her family background, whether or not some of her family members had passed away early in her life?
Objection, leading, conduit, 704.
You considered the entire family background and history without going into the details of what she said or what you learned from looking at records?
Yes.
I'm sorry?
Yes.
And did you consider her relationship with her mother as part of her psychological development?
Yes.
Now, do you believe that Sarah Boone does have some narcissistic traits?
I do.
She does.
Who writes it? It's Rita Schuler says, "Oh God, he means the journal." The journal was reviewed as evidence, or at least as, I'm going to take it res ipsa loquitur, that it is true on its face and not investigate further. Oh, Julie, that's where it started you down the road.
She doesn't qualify or meet the criteria for that diagnosis, does she?
I did not diagnose her with that.
Can you elaborate on or explain how you feel that Sarah Boone does have some narcissistic traits?
Well, in meeting with her as part of the evaluation, the narcissistic traits that I identified would have to do with, as she described, being a straight A student. She reiterated about her abilities, and I felt that that was evidence that she had low self-esteem, and her coping mechanism was to identify what made her stand out, and that would be consistent with a narcissistic trait.
So that's interesting. That's almost like she agrees with Dr. Tanya Werner later, because Owens makes a big fuss about the narcissistic traits versus diagnosis.
Now, I know there's been reference in this case to a manual that all psychologists, all psychiatrists refer to. Do you have that manual with you?
I do.
And what is the name of that manual?
It is the Diagnostic and Statistical Manual of Mental Disorders.
That should be, if you're making bingo cards for watching trials, when the DSM gets brought up. As soon as it gets mentioned, that's got to be like everybody, there's several bingos that have been called. 1 second.
The text revision. So it's the DSM-5 text revision.
Now, Dr. Brannon testified earlier today, and there was some evidence relating to when you suffer from narcissism, there's a sense of grandiosity. But is that from this manual in your studies and your experience, were they
Got a lot of pages bookmarked for a lot of different trial appearances.
require excessive admiration and whatnot, that there's a reason for that?
If I'm understanding your question, there's a criterion in narcissistic personality disorder related to that.
What I'm getting to is many times you may have
Hostile
these
witness.
narcissistic traits, but really you suffer from very low self-esteem.
That's the underpinning of that criterion.
Would you explain that to the viewer?
If I'm allowed to reference the DSM, then I can explain it best.
Just don't read from it, just
All
if
right.
you need to review, if you need to read a paragraph and then explain it to the jury.
So based on the description in the DSM, if a person's self-esteem is very fragile and they have low self-esteem, they may require more outside admiration or even appear more grandiose in their abilities, because at root, they don't feel secure and confident. And so it's what we would call a defense. And so that criterion is actually a way that a person tries to make themselves feel better.
Anything else you want to say about that issue?
Well, you asked me about why I didn't diagnose narcissistic personality disorder. And again, from the DSM,
Are there criteria?
there are criterion for each disorder.
And so when you're assessing someone, they have to meet all those criteria for you to form that opinion that they actually suffer from that disorder?
Well, the first, I guess, issue is, do they have the criterion that are listed? And then the second would be, is there a different mental health disorder that would better explain the criterion that you're seeing? The criterion within the DSM overlap considerably across disorders. And so there are some helpful guidelines within the DSM to remind you of that you may have what's called differential diagnosis. So if you're considering one thing, that you also are directed to look at other things. So that happened in this case, in this instance, that the DSM guided me to also look at other things.
But just for purposes, to make it clear, you did not diagnose her as with narcissism.
He's Sagittariously
That's correct,
single.
because the DSM's description guided me that that would not be an appropriate diagnosis.
Why did you not diagnose Ms. Boone with a personality disorder?
Well, first of all, it has to be a pervasive pattern of distorted relational abilities. So basically, if she is demonstrating in a variety of settings that she...
It has to be a pervasive pattern. Anyone who's watched Sarah Boone body cam and 911 call and, well, basically her entire public Sunshine Law's life prior to her incarceration, seemed like there was a pervasive pattern of behavior.
has these symptoms. And then secondarily, the diagnosis of post-traumatic stress disorder is listed when you're considering personality disorders. The DSM guides you that if there are personality changes that are associated with the exposure to a trauma, then you should consider post-traumatic stress disorder and not a personality disorder.
Thank you, Laura.
Have you diagnosed her with anything? And we'll elaborate on that, but through your assessment, have you diagnosed her with anything?
Yes, so she has a diagnosis of post-traumatic stress disorder.
Yeah, just a good one. She's been diagnosed with one of the ones that helps explain her behaviors and doesn't make you feel like she's somebody who's a danger to society and needs to be behind bars. I didn't give her those ones, just this one.
She has symptoms of anxiety that would be consistent with post-traumatic stress disorder. So that is an anxiety.
Sarah claims post-traumatic stress disorder, but everyone who's been around her has post-traumatic Sarah disorder.
Anxiety disorder.
And you feel like she suffers from post-traumatic stress?
I do.
Now, at the time of this incident,
Frankly, that's why this channel exists. I had so much post-traumatic Sarah disorder that I couldn't stop watching. I had to see her go down for just the empathetic feeling I felt for George and trying to picture myself in a situation with that desperation. And the more I peeled back the onion, the more, it's like, how can this be rotten yet still have so many layers? Holy fuck.
we're talking February 23rd of 2020. You were aware that she did not have much family support.
Yes.
You're aware that her grandparents died before she turned 50.
Doctor, why do you administer psychological testing?
Psychological testing allows an objective measurement.
Giving up 100%. Given up says in the chat. So we're helping you cope, Dan. Being able to share trauma is one of the things that does help people cope. And I think finding that this community, and it's unique it's a community that is unique among true crime communities for the real community togetherness. Like, you can have different opinions. We can be from different sides. If anything, for, politically, we agree on, we don't want to talk politics. It's a really, really cool community to offload trauma in. And, whether that's purely from the Sarah Boone case or you've got, personal traumas you're dealing with, just being able to be in a shared trauma dump with so many people that are like-minded from around the world with varying perspectives, but some funny, some very biting, some with expert knowledge. We've got lawyers, doctors, DNA pros. It's a really good community. So the more I've created, the more I feel inspired to create. And it's, a kind of synergistic thing happening right now. But I appreciate everyone who's in the chat struggling through what's probably the least interesting part of the trial. If you're enjoying this, make sure you're watching all the rest of this coverage, because this is as bad as it gets, and I think we're still having fun.
Of what the person's symptoms may be as compared to sort of an average. So if we can see what the average range on a standardized measure would be.
Oh, a big welcome and fuck yous to Bedtime Lullabies, JLC. It's always a pleasure to see you, just like greeting Scott from across the room. Hey, Scott, fuck you. That's normal. That's what we do. Algorithm, you know, you can tell I'm being ironic. You can tell I'm being sarcastic. Speaking of the algorithm, sorry, I'm going to take a little break here. I don't know how many of you are watching with ads. I watched my show, this last week's show, the Michael Brannon and everything, on a guest account on a separate computer that I don't normally use, just because I was going to be somewhere for a few hours, just to see what ads I'd get served. Are you guys freaking rich? There was ads for like something called NetaPro, which is like all of these high-end brands, like, you know, the background of Suma's, you know, the L's and Louis Vuitton, Basalienga, fancy stuff. There was a 4-minute ad for just a property in Maui. Just this, it was like drone footage sweeping through. I don't know how well off you guys are that are watching this stuff, but, you know, congratulations to you. Good for you. It's a luxury ads that are being attached to the Dan D broadcast. So they're not afraid of a little swearing. They're not afraid of some friendly fuck yous. So I'm not going to stop doing it. Anyway, we'll get back to our regularly scheduled broadcast. That ad break was brought to you by Morgan & Morgan.
For any person, if there is an interpretable difference, that gives me clinical information. So it's not just relying on what the person has told me. I've got an objective measurement that I can compare to other people. And then I also administer psychological testing in a forensic evaluation to help.
Kel, yeah, I used to get the water bra ads, and that's the ones that I missed the most from when I switched to premium, because I don't know, like they must have realized that almost every other ad I was, you know, just skipping through as soon as the skip button came up. But the water bra ads, I was like, huh, that looks like it gives good support. That looks like a quality product. Never purchased one, but it must have looked like I was considering it to the algorithm. So I was getting those ads a lot.
Help assist me in making sure that the person is intending to put in good effort with me. In some forensic settings, a person may have a reason to present symptoms, like if they're in a custody evaluation, for instance, they might have a reason to minimize symptoms, or they may exaggerate something else. And so assessments as to the person's response to you and if they're validly participating are important.
So there are tests to see if you're faking or malingering or that type of thing?
Right, and so you would call it feigning mental health symptoms when the person is either far exaggerating a symptom they do have, or if they're pretending to have a symptom that they do not actually have.
Just like Robert Bailey, who if you were listening earlier, was talking on the phone about how great it would be to be diagnosed with a mental illness so that he could get an easier punishment in jail. And Dr. Harper, who presumably would have had access to that recording because it was part of the news reporters' coverage of the story, seemed to testify that he was incapable of understanding his actions.
Now, as it relates to Sarah Boone, what type of psychological testing did you administer?
I administered the inventory of legal knowledge, and that is
inventory of legal knowledge. She brings that up, I think, in the tablet messages with Lana, where she's like, I did some tests and now they think that I understand, being a lawyer. And it's like, it's not what the test is. The test is like, do you understand that if the judge says you have contempt of court, you could go to jail just for, not agreeing with the court's instructions, and like basic concepts of law, and not whether you're competent to be a pro se lawyer. But I remember that being one of Sarah's interpretations of this psychological assessment.
Yes, that has to do with whether or not she was validly participating regarding her understanding of the legal process. I also administered the Miller Forensic Assessment of Symptoms test.
Now, explain to the jury what that Miller Forensic Assessment of symptoms test is?
So that is also a test of feigning to identify if she's validly participating in the evaluation. So if she had endorsed psychological symptoms or psychiatric symptoms, that would be unusual or not typical.
Like saying it was a terrifying love, so to speak. That would be maybe a sign that you were feigning.
Of a valid psychiatric patient.
What were the results of Ms. Boone's test on the Miller forensic?
She validly participated. There was no indication of any feigning or malingering.
And as far as the
She got a perfect score. Another A for Sarah.
inventory of legal knowledge case, what were the results?
Again, she was validly participating,
A plus.
and she did not even come close to the cutoff. That would put her in the range of feigning.
Can you tell the jury what the purpose of the clinician-administered post-traumatic stress disorder scale is?
Yes. So that would be considered
Ramono gets a lot of ads about running a busy dental clinic. He is not a dentist.
a very useful assessment of post-traumatic stress disorder. It allows me to interview a person about exposure to a traumatic incident and then identify if there's a change in behavior that has occurred as a result of that exposure to trauma.
At the time
If you're from Oregon, doesn't that make you think of Morrigan and Morrigan?
that you administered that test, did Ms. Boone in fact have post-traumatic stress disorder?
Well,
Or tell me the results. Just
yes, so the results would be consistent with a person having post-traumatic stress disorder. I do not diagnose from one test, that wouldn't be appropriate, but it is consistent with the background and the symptoms that I had previously, taken down during my evaluation of her. So the clinical portion, when we go through symptoms, that was consistent with the outcome of that test.
And would this testing, all the testing, help you determine if Ms. Boone had a change in functioning from before the alleged trauma
Bless you.
to
Bless you.
after the alleged trauma? And I'm referring to the trauma. We're going to talk about what the trauma was, but the trauma was the intimate partner violence?
That's correct.
Okay. But would that testing help to determine if she had a change in functioning from that trauma of the intimate partner violence?
Absolutely.
And did you determine that she did suffer from trauma as a result of
A to
intimate
B.
partner violence?
That was my conclusion. Yes, that's my opinion.
Now, in considering all the available information, you don't just rely on what Ms. Boone tells you to
No.
make your decisions.
No, I don't.
The lie detector came back and determined that was a lie.
I do interview a person.
I'm going to go back just a quick second there. Because the question was actually quite well worded by James Owens, and she didn't really consider the full scope of the question. Listen to what he says.
You don't just rely on what Ms. Boone tells you.
Okay, the prior bit was based on all available information. You don't just rely on what Miss Boone tells you. All available information. So that, for that fuss that he makes about Tanya Werner later, she couldn't have considered all the available information and come to the diagnosis she has.
To
No.
make your decisions.
No, I don't. I do interview a person as part of the clinical forensic interview, of course, but
And I won't be rewinding Harper that often because I can understand you guys don't want to see the repeats, but I think that was a key little question and answer session.
Intimate partner violence.
absolutely.
And did you determine that she did suffer from trauma as a result of intimate partner violence?
That was my conclusion. Yes, that's my opinion.
Now, in considering all the available information,
In considering all the available information,
you don't just rely on what Miss Boone tells you.
you don't just rely on what Miss Boone tells you.
To
No.
make your decisions.
No, I don't.
Yes, you did.
I do interview a person as part of the clinical forensic interview, of course, but I also consider things that are reported, like in the arrest narrative, witness statements, all of the medical records. So there are a variety of sources of information, collecting data points and reviewing those to arrive at a conclusion.
Oh, well, forget everything I said. She was collecting data points. I didn't realize she collected data points. That changes everything.
So you did review Miss Boone's previous diagnoses in her history?
Yes,
Did you consider the previous diagnoses in arriving at your own?
I did. Yes.
Sidebar.
What did Miss Boone, what had she been diagnosed with prior to you getting involved?
Objection 704 conduit.
Approach.
Objection 704 conduit. Court response. I didn't realize that it was an objectionable issue that she'd been previously diagnosed. I thought that was going to come out either. I thought it came out with Dr. Brandon. I thought for sure it's going to come out with Dr. Werner and some of the opinions expressed. Because I know we took a deposition. She said, Dr. Werner said, yeah, I believe with the previous diagnosis that she suffers from anxiety or some anxiety disorder. So I thought the experts, and of course they're going to want to form their own opinions, but that they'd like to rely on the history of other experts. Sure. So that was the reason for asking the question. I didn't know it was inappropriate to ask. If you're asking her to rely and testify specifically to something that's inadmissible as to prior diagnosis, 704 prohibits that from happening. I understand. And that's what I'm taking the state's objection to be. Mr. J, yes, it's inappropriate for exploration on cross-examination. Inadmissible evidence can certainly come in if it's relied upon by the expert during cross-examination. And it certainly, I think as an expert, a forensic psychologist or psychiatrist would testify. It hasn't happened here yet. But I understand it could. So I'm not objecting, but this is the sort of thing that they usually rely upon. Like, I'm a psychologist, yeah, it's within the course of my practice to normally rely on other psychologists' diagnoses. Court, we can't just say what those diagnoses are, Mr. J, unless it's admitted into evidence already. And my understanding is that they're not doing it. A handful of pages, but I still haven't been provided them. I think it's going to come out in cross. It's just, I think under 9704, and according to Professor Earhart, pages 954, 955 in the 2024 edition, it's for me to bring out. The court says, he's correct. It's Mr. O. I got the 23 edition, Judge. I don't have the 24. The court says, well, there's been no statutory change in 90.704 statute in some time. Mr. J is correct. On that cross-examination, he's allowed to explore the basis of the opinion and go into and out of court statements. If you, as the proponent of the opinion, unless you can establish the inverse in a 403 test, it's not admissible. I've been educated.
But you would agree, and I think this is a fair question, you would consider prior...
I've been educated. Hey, welcome, Deborah.
other experts who may have diagnosed her.
Deborah Rockhill's joined the chat.
So I would definitely consider her mental health records, diagnoses previous clinicians may have arrived at the time when I diagnosed her myself.
Okay, and given the assessment that you did with Sarah Boone, and considering the totality of
Sarah
time you spent
Boone.
with her and the other records, did you diagnose Sarah Boone with anything?
Yes, so post-traumatic stress disorder, it's my opinion at the time of the offense, she had depression.
Aww.
And she had an alcohol use disorder.
Depressed.
All right. I know we've talked about post-traumatic stress disorder. I don't know if I need to ask you anything further. I think the jury probably understands that. Is there anything else you wanted to add about that disorder?
I'm not sure what the jury's already been told about post-traumatic stress disorder, but in Sarah Boone's case specifically,
Yes, get specific.
because of enduring, she specifically noted the time that she was stabbed with the knife as being an extremely...
Objection, move to strike.
Sustained.
You have viewed
Think about it, James. How are you going to ask?
some exhibits involving her being stabbed.
I think that we have had exhibits in common. I'm not sure what was admitted.
Have you seen the physical scar from Sarah Boone being stabbed in the back of the leg?
Yes, I've seen her scar.
Objection, move to strike. But the interesting thing is, remember that. You've seen the wound to the back of the leg. Because you'll notice that when Sarah turns or steps out of the well, well, I guess we won't notice that. We already saw it. When Sarah stepped out of the well to show the jury the back of the leg, she didn't need to turn around to show the back of her back. She was facing the jury. And, 99 times out of 100, when you're facing someone and you show them your leg, you're showing them the front of your leg. The front of your leg. Sorry, just trying to find the spot.
I think that we have had exhibits in common. I'm not sure what was admitted.
Have you seen the physical scar from Sarah Boone being stabbed in the back of the leg?
Yes, I've seen her scar.
On the front of the leg.
Overruled.
Oh, it stays in. Perfect. Address that on cross, Mr. J, if you don't mind.
Just generally, without getting specific, I think I've explained post-traumatic stress, but if there's something else the jury
I think I've explained post-traumatic stress. Yeah, you've done a very good job, Mr. Owens.
you believe the jury needs to know, but it's a sort of trauma that occurs as a result of one or more events.
Post-traumatic stress disorder is the psychological after effect of being exposed to a very significant stressor or cumulative stressors that make the person's behavior, thinking, and mood change. And so the change can include things like the person becomes hypervigilant, is easily startled.
Bedtime lullabies, cross chatting there, but I'll blame Margaret for that. Margaret!
Has trouble thinking, has trouble sleeping, so their body is in a state of agitation.
Welcome to the chat, Leanne.
Include changes in mood that would include irritability, difficulty relating to others, and that they might be resistant to trust easily. So those are all
They have
features.
trouble sleeping sometimes.
Yes.
Sleep deprivation is a real issue.
Oh, and I think this is where Owens goes to show his knowledge of the power and control wheel. He's going to ask a series of questions about controlling relationships here.
It's associated with things like nightmares and having trouble settling.
Now, you mentioned that you had diagnosed her with depression. Can you just give us a general understanding for the jury of depression?
So the persistent sad mood, including feelings of hopelessness, helplessness, having difficulty concentrating, sleep problems, changes in appetite, those would be typical of depression.
And Sarah Boone suffered from that?
Near the time of the offense, yes.
All right, can you explain to the jury alcohol use disorder? That's a fairly new name. That's 5 or 6 years ago. The manual came up with a different name.
It did, right. And so that would be, in layman's terms, you might call that alcoholism. It's a tendency to drink too much and then have some kind of consequence in your life as a result of your substance use.
Yeah, I think she has that.
And alcoholism can be, depending on how much you...
Beth of a Salesman says, alcohol is a shitty thing. And I would agree, unless it's, the weekend or, when you don't have to get up the next day.
drink and then
Glass of wine, whatever.
how often you drink,
That's right.
all that is something that you would consider in diagnosing?
Yes.
The many people who suffer from alcohol use disorder, I don't know how to put this.
I
Are they
bet
in
you
denial?
don't. Ooh,
I would say that that is
that's why he said that. I don't know how to put this because he didn't want to offend Sarah, but he basically needs to get in that she's an alcoholic over her objections. I don't know how to word this. They in denial? Wish they had a shot of Sarah's face on that one. 531:56.
On how much you drink and then how often you drink,
that's right.
all that is something that you would consider in diagnosing?
Yes.
The many people
Sue's what asks, when I blame Margaret for everything, would that be an example of power and control?
who suffer from alcohol use disorder, I don't know how to put this, are they in denial?
I would say that that is one of the stages of alcohol use disorder and amenability to treatment. So in denial, it's because you do not want to acknowledge that there are consequences from your use, because in doing that, you might have to reduce how much you're using. So to deny means that you feel that you can continue your use without having to change that. So you want to maintain the access to the substance.
You don't have
She wanted to maintain and focus.
a problem.
That's right.
What is the difference between traits and a diagnosis?
Well, we all have personalities, and so you're going to have coping mechanisms that include personality styles. So for instance, even though you might not be diagnosable as something, there are times when if you're upset, hurt, frustrated, you have a mood state that's unpleasant, you're going to deal with that by using some kind of coping mechanism. So traits of personality disorders might be present in the way that you deal with inner pain, things that you don't like, feeling. So some people, for instance, if they feel uncomfortable, they may cling too much or become excessively bonded to try to escape a feeling that they don't like, and that might be a dependent personality trait. It doesn't necessarily mean that they have a personality disorder, because that would have to be pervasive across like all the environments. But when stressed or upset or not feeling good, you're going to use some kind of coping mechanism, and that might be one of the criterion, for instance, of the personality disorder. You would call that a trait.
And is it your understanding that this trauma that one suffers from repeat domestic violence can cause one to be considered suffering from the syndrome, we call it battered spouse or battered woman syndrome?
Yes, so the diagnosable condition would be PTSD, or post-traumatic stress disorder. That's how a clinician would label the response to trauma. The pattern between partners, the person's coping mechanism because of that trauma, that would be what's considered battered spouse or battered partner syndrome.
Welcome to the chat, Pine Weaver.
And you're aware that that concept of being traumatized by the battered spouse syndrome or the post-traumatic stress is relevant to a self-defense case in
Yes,
a criminal context.
yes, I understand that.
Could you tell us a little bit about that?
Well, under the battered spouse syndrome, the person would experience a trauma or a situation in which they feared harm. And based on that fear of harm, they would react in a certain way that might not be understandable to other people. So their fear is based on the pattern of behavior between them and their partner. That might not be the case for another set of people.
Now, I know that Dr. Lenore Walker is the one who first uncovered this syndrome.
He just learned that from Michael Brannan's testimony.
back in the 70s?
Her research study generated the term. She was interested in why battered women specifically at first, that was what was studied, didn't leave their partner because, of course, they're experiencing traumatic events, risks to their life, but then they didn't leave. So she undertook the original research study on that.
And just briefly touch on, because I know Dr. Brannon has this, there was a 3 stages that Dr. Walker developed for that syndrome.
I think you're referring to phases that a person may go through, or the cycle of the relationship. That includes the tension building phase, in which there is the first instance that tension is building within the partner. There might be a change in tone, a signaling that there's a difference in agitation.
And then there was a change in tone, and I knew the tone.
The second is the true battering event, so something has happened between the partners that's violent in nature. And then third, there's the honeymoon phase, which is to keep the relationship intact. The batterer would engage in what's like called honeymoon behaviors, like trying to repair the relationship, apologize, essentially keep the victim from departing from the relationships.
So Sarah's story is day 1, George R'd her, and then she went back, and then they stayed together for 2.5 years, and really only got good that Sunday morning, and it was a good day. It was a great day. It was a great day because I survived, and then I, had to protect myself because I was always in fear.
So those are 3 phases.
And is it fair to say
Phase 1 was like the first 2.5 years from the moment she met George. The honeymoon phase was like Sunday morning, in between doing a chore for a sense of accomplishment and being puzzled out because she was already sick of him by the time his fractious music came on.
that psychologically the abuser, does alcohol often involved in the abuse?
Yes.
And as far as the victim that's getting abused, and you say it's a cycle, is the victim, when they go through that last stage, the honeymoon stage, are they thinking, okay, it's going to be better?
Yes, the hopefulness in that, trying to believe that the behavior has changed, that they're not going to be abused again, the hopefulness to maintain the relationship, to forgive. That's part of that last stage, phase 3, is maintaining the relationship.
I don't think I've asked this. Why would someone who has been exposed
I don't think I've asked this. You should be sure of those sorts of things, Mr. Owens, but please continue.
to intimate partner violence perceive the likelihood of a new violent event about to appear? Why would they perceive the likelihood of that violence differently than, say, a normal person?
Well, it speaks to the pattern. So any relationship will have its own special pattern, that you have things that only your partner knows about you, or certain looks that you give that mean something, and you learn that over time. So over a period of incidents, basically, the victim begins to perceive cues that would signal impending danger. Those cues could be
Like a butcher knife in the front room coffee table, which is made of glass. That would freak me out if somebody put butcher knife into a glass table. I would be amazed at their power and control over physics and the environment.
really subtle, just a change in tone or some
Change in tone, and I knew the tone.
small behavior that might not mean much to another person, but it has preceded other violent acts. So, for instance, if you're
Phil for Dom Russo brings up another great point, and it's worth, the 15th pause in the last 12 seconds. It's so much easier to take this testimony knowing that it didn't do anything, because it was so frustrating in the moment of like, oh God, get this chick off. Like, this is, the jury can't be listening. This is garbage. And, there's so much anger and frustration because, Casey Anthony had gotten off on her trial, I think same district. So, nothing's for sure except watching a trial rewatch where, you know, you can just enjoy every moment for the moment and know that the end result is the end result. And it's not changing from us watching it. It's not changing from bad testimony. It's the results are the results. Life in prison.
Her husband decides that he is not going out that night. He might put on different clothes to stay home, and that could be a signal, like abuse and violence has occurred in his stay-at-home clothes, for instance. That might not mean much to another person because
I kind of see where she's going with this. So, like, you know, if a guy dresses nice to go out when he's putting on his costume, that he's a nice person, friendly guy, doesn't beat his wife, and then, you know, has a day where he's just wearing, you know, and there's a reason they call it the wife beater, but, you know, open A-frame shirt, tank top, sun's out, guns out kind of look. There's a reason to be, you know, you could say, oh, okay, that's a bad sign. Like, you know, he normally puts on a front that he's a good guy. I could tell from, you know, the minute that he didn't get dressed out of his underclothes and just started drinking on the couch, it was going to be a bad day. But Sarah doesn't have any testimony like that. She doesn't have any authentic, you know, real, visceral memories of these events. All she has is what she studied in the textbooks and tries to pair it off with her ridiculous understanding of what normal people do and what a normal life would be. So her invented stories always have this touch of surrealism because they're not based off of even, you know, the smallest amount of normal life. Like she's a 15-year-old trapped in a 42-year-old's body.
because again, it's specific to that dyad. Those two people know those patterns. So the victim may perceive a small or subtle change in their partner as a cue because they've become hypervigilant. The body knows when it's experienced a threat to itself, and it will take note. We record memories differently when we're at risk. So these subtle cues become very well memorized by somebody who's being victimized.
Or memorized by someone who is an A student in school and just needs to have the answers. If she could study them, please, if you don't mind, please. She'd know them really well for her trial. So help me out. Tell me what the answers are, and I'll give them back to you next time I see you.
On this, and battered spouse syndrome is a subset of post-traumatic stress disorder, which you've diagnosed Sarah Boone with. When those personality changes occur and they persist after an individual has been exposed to this extreme stress, is that when the diagnosis occurs?
The changes would be as a result of the pattern. The person experiences a change like in their sleeping, in their hypervigilance. That's when you can diagnose it. So you can have a trauma or an experience of a scary incident, but it doesn't mean that you will absolutely have post-traumatic stress disorder. You have to have those reactive symptoms that would suggest that it's present.
In your opinion, and I know you've gone over this event with Sarah Boone, this February 23rd, 2020 event, is your opinion that she was suffering from battered spouse syndrome at the time of that event?
Yes, she had the patterns ingrained in her behavior that would be typical of a victim who's responding to traumatic events in a predictable way. So that would fit that.
And it's fair to say that because of the intimate partner and the prior violence, that you would have a heightened sense of when danger was about to occur?
Yes.
When a threat was about to occur?
Yes.
A threat of danger?
That's right.
Now I want to talk about placating the abuser, a victim placating an abuser. Are there predictive cues which an abuser may exhibit to a victim that result in a high level of anxiety arousal in which the battered woman may attempt to reduce through several different means? to delay the beating. Can you explain that?
Yes. So the phase of the relationship that starts with that tension building, that is a jumping off point potentially. So if you can stop the escalation, you might stay in phase one for a period of time. Phase one being that tension building phase and trying to reduce it and not allow it to escalate. So placating the abuser might include distraction. It could include substance use. It could include a change of scenery. There are a lot of things that a partner will learn to do so that they don't have the escalation into abuse.
It could include a change of scenery. I thought Georgia needed a change of scenery, so we went inside. And then I thought he needed a change of scenery, so we went outside. Well, that's interesting because change of scenery is also something that the power and control person does, I think. Yeah, dominance. Yeah, anyway.
Event, if possible, doesn't always stop it.
Now, in reviewing all of the data, all the reports, the medical records, and
Again, in reviewing all of the data, the reports, the medical records, like that's a pretty wide open statement there, Mr. Owens. Why don't you say, in reviewing the material you reviewed for this case?
whatever reports you considered, videotape that you may have watched, as it relates specifically to Sarah Boone, are her words her power?
Her words, I would say, are the weapon that she has.
The words are like arrows in her quiver of weaponry.
Explain that to the jury.
In reviewing the available videos that I
Uh-oh, sorry, Sue Swat, you made a big mistake. Sue Swat says, please never say arousal again, Mr. Owens. Now we got to go back. I need to hear him say arousal.
As it relates specifically to Sarah Boone, are her words her power?
her words, I would say, are the weapon that she has.
Explain that to the jury.
In reviewing,
Okay, you're lucky. I'll watch it on the replay. I didn't go back far enough, and I'm not going to rewind her a third time. So, her words are her weapons of choice. Just listen to the sound of her voice. Fuck you for everything you done to me. Fuck you.
the available videos that I had to review, you would see that when Ms. Boone is very stressed, when she's experiencing a high level of anxiety, she becomes...
Oh, that's very insightful. When experiencing a high level of anxiety, Sarah Boone is stressed. That's specific to Sarah Boone. Everyone else is unique. A lot of other people will experience high anxiety with no stress, but unique little Sarah Boone there, she'll get both of them at the same time.
short in her tone. You can hear that in her voice.
Yeah, I can hear it in her voice. You know what? I could tell with Sarah Boone's voice when the tone changed and when it went from, same guys to no. Sarah Boone's voice definitely changes. Very clear tone shifts that would let you know that, here comes drunkie.
Strain, sharper words come out. I think that is the
Sharper words. Fuck you. Maybe you should shut the fuck up then. Shh.
way that she would try to respond to Mr. Torres. You can hear that sharpness in her voice when she's very stressed out.
Phil for Dom Russo, the arrow holding bag is that's one of my earliest favorite substitutions for her.
Now, would you agree that victims may exhibit a range of behaviors when they're suffering from intimate partner violence?
Yes.
Self-isolation,
Yes.
suicidal thoughts,
Yes.
substance abuse,
Yes.
And there are often physical signs of injury such as bruising,
That's correct.
chronic fatigue.
All right, so now he's just going to list off symptoms of the power and control wheel. I'm going to give you guys a mini break. Just as it's enjoyable to watch Harper's testimony be ultimately useless from a, effective testimony point of view, let's tune into what she was doing yesterday in rewatch time. This is the results of her testimony from I basically asked the AI, please give me the full details on her testimony, an overview of the case, and the results of the Bailey case. So if you need to go to the bathroom, you're not interested in the Bailey case, you need a break, you need a chance to, go wash your hands, make a medical snack, this is your opportunity. I'm going to put down my own medical smoke and take one sip of coffee for the voice, and then probably spend the next couple of minutes reading this. Let me just make sure it's up on screen. Okay, you guys can kind of see it. That's just there to show that, I didn't write this myself. This is just me reading from an AI summary of the events. But when I commissioned this summary just to do my research, I was like, that's not bad. I can read that. So here we go. Oh, not quite yet. In the sentencing case of Robert J. Bailey, licensed forensic psychologist Julie Harper testified extensively for the defense to establish mitigating factors rooted in severe mental health issues and developmental trauma. The case stems from the March 27, 2005 murder of Panama City Beach Police Sergeant Kevin Scott Kite. Sergeant Kite initiated a traffic stop on Bailey's vehicle for causing a traffic jam on Front Beach Road. Because Bailey had an outstanding warrant, he shot Sergeant Kite twice in the chest to evade arrest, reportedly stating beforehand, "I'm not going back to prison. He tries to arrest me, I'm gonna pop this cop." Bailey was originally convicted of first-degree murder in 2007 and sentenced to death following an 11-1 jury recommendation. However, following a 2016 U.S. Supreme Court ruling that struck down non-unanimous death penalty recommendations, Bailey was granted a new penalty phase resentencing trial. During the October 2024 resentencing proceedings, defense attorney Philip Massa called Dr. Harper as their premier expert witness to counter the state's pursuit of capital punishment. Dr. Harper testified that Bailey suffered from severe, unaddressed early childhood trauma. She noted he grew up in a deeply impoverished, gang-affiliated neighborhood and endured intense physical abuse from his stepfather alongside his brother. She testified that these developmental traumas deeply influenced his mental state and subsequent actions. In response to older diagnoses of bipolar disorder and personality disorders, she sought to frame his psychology through the lens of chronic trauma. The prosecution fiercely argued that Bailey was merely faking or exaggerating his psychological conditions to escape death row. To directly invalidate this, Dr. Harper testified that she put Bailey through rigorous forensic tracking, including a clinical interview, a mental status exam, and the Miller Forensic Assessment of Symptoms. She highlighted that Bailey scored a perfect 0 on the Miller Forensic Assessment of Symptoms test, meaning he did not fabricate or intentionally endorse false symptoms to look mentally ill. The efforts to commute Bailey's sentence to life in prison were ultimately unsuccessful. On October 25th, 2024, coincidentally, that is the same day as the Tanya Werner testimony we're watching next. On October 25th, 2024, the newly paneled Bay County jury voted 9-3 to recommend that death penalty once more meeting Florida's revised 2023 threshold requiring at least an 8-4 split. Final judicial ruling. On July 10, 2025, Bay County Superior Court Judge Shauna Young Gay officially upheld the jury's guidance and resentenced Robert Bailey to death. Current status? Bailey was immediately returned to Florida's death row at Florida State Prison in Rayford. His legal counsel has initiated a multi-year appellate process to exhaust all remaining state and collateral appeals. So, too long didn't read. I guess, too long didn't listen. Julie Harper's testimony failed to exonerate or get Bailey off death row and was a waste of her time, just like her time in this trial. Let's go back to her testimony.
Yes.
Learned helplessness?
Yes.
Can you tell I know Dr. Brandon spoke on it, but could you tell us a little bit about that?
So learned helplessness is when you start to form the opinion that nothing's going to make any difference. It comes originally from an animal study in which dogs were shocked, and the research study indicated that even
my accent's turning into a bit of a sling blade, Beth of a salesman points out. No, you shouldn't have done that.
even when dogs were given an opportunity to escape the environment in which they were being shocked, if they were shocked enough, they just stopped trying to escape. So even though they had an opportunity to do so, they did not do that. That's
Definitely could go for some French fried taters right now, though.
called learned helplessness. It's the idea or belief that what your actions are going to do are not going to make a difference. So
Rest in peace, John Ritter. He was really good in that movie. Underappreciated for his movie roles. Famously known as Jack Tripper from Three's Company, but I think he played very understated and great supporting role in Sling Blade.
don't try.
What are intrusive memories?
Intrusive memories are an element of post-traumatic stress disorder in which you don't want to be thinking of a traumatic event, but it intrudes on something else you're trying to do, like maybe you're folding socks or something like that.
I'm a whipped dog with my ears folded back, letting you pet me.
Just doing something mindless, and that's what takes over your thought process. It's not
Thank you, Given Up. I suspected this, but I appreciate being able to read out a strongly worded version in chat than a milquetoast version that where I couch all my options and explain that I'm not a psychiatrist. Given Up says, the Miller forensic test takes 5 to 10 minutes. It's not a proper evaluation by a forensic psychologist. Interesting. She's brought it up in both of these. Like, oh, perfect score. So if it's a 5 to 10 minute test and somebody who's trying to fake it knows that it's a test that she administers to every person that she interviews because it's on the court record, you don't have to go far to realize that, oh, okay, what is this Miller test? Okay, those are the answers. Boom, not faking.
something that you're trying to think about. We could plan what we're thinking about, or sometimes if you're just having this intrusive experience, that's not what you were intending to think about at all.
Is that
All she does is lose, lose, lose no matter what. And when her hands go up, and they stay there.
one of the conditions that someone may suffer when they have this syndrome of battered spouse?
Yes.
I know there can be triggers that bring on these memories. Am I correct?
That's correct.
Are there also symptoms of this syndrome where, like in the alcoholism, where you have denial that you're in the middle of this cycle?
Well, as part of the relationship, there's an element of pleasure. Like you have early on in the relationship something that binds you together.
Oh yeah, the first date. Oh, wasn't that a magical night?
So you're remembering that, you're hoping for that, even though the repeated cycle is going through the phases 1, 2, and 3, you keep hoping for elements of that honeymoon phase, wishing that it was better. So it is like denial. You're imagining the way it used to be. You have a recollection of that person showing you positive behaviors, and you're hoping for that. I also think it is typical for victims to not reveal to other people that the abuse is going on, and it seems like denial. In other words, your
That said, Sarah was known for running around the parking lot showing everyone, "Hey, Miss Walker, look, I got a black eye." Kind of flies in the face of this diagnosis, but hey, doesn't matter. Sarah's still guilty. This testimony doesn't matter.
Workers ask you, like, are you okay? Did something happen to you? You're not likely to disclose that. That looks a lot like denial. It is a denial in public of some of the private issues that you're having in your relationship. And that's because it's embarrassing. It's revealing a loss of control to other people. It's revealing that things aren't perfect. You might even get feedback that you should leave your partner, and that's unwanted because you're already having that, concern in your own mind about it. And so, it seems like denial on the outside to hide it.
Would you
If I may please, says, how can she feel helpless when she knows 50 ways forwards and backwards of the things she needs to do?
agree many people who suffer from this, they're minimizing what is happening to them,
Yes.
and they're numbing their emotions to it?
Well, to stay present and keep that relationship, it's very difficult for a lot of people because they're experiencing physical and emotional harm. So they want to numb it because numbing it means that you can keep that relatedness no matter how bad it's getting.
Does some people
Note to self, consider "I'm So Numb" as a Sarah Boone short, using Julie Harper's testimony from this bit right here. I guess not feel.
Experiencing physical and emotional harm. So they want to numb it because numbing it means that you can keep that relatedness no matter how bad it's getting.
does some people with this syndrome disassociate?
Objection. Relevance.
Approach.
Sidebar, wasn't prepared. Give me a second. Give me a second. I'm doing my best, John. Sorry, Margaret didn't tell me there'd be a sidebar. Got to work out my accent. Got to get back to a foghorn leghorn, getting into a bit of a sling blade there. I think it's Tony Henderson. Tony Henderson's voice sometimes pulls me down from a little bit high, a little bit more intense from James Owens. I think with Owens, what I got to do is spend the beginning of my sentence thinking about what I'm saying, and then use the end of the sentence to say the words really fast. Something like that is my strategy for Owens. Anyway, let's get to the sidebar screen. Bring up the text. Sidebar. And hopelessness, danger, hypervigilant, changes. Okay, in your opinion, threat. Come on, where's the approach? Oh, geez. I was just relaxing and just enjoying your company. I wasn't following along. But I knew they were coming. Here we go. Okay, court starts with a yes, sir. And Mr. J's going to come in hot. He's had enough. Okay, we'll let the video play while I go to a live transcript read. Biddy deep. We're about 3 or 4 things where we're just asking about people in general. My understanding of discovery is that none of these apply to the defendant, and if it does, that should probably be the question. Does dissociation apply to Miss Boone? Asked the court. Because if I understand correctly, that's what we're talking about. Dissociation is battered women. They develop a defense mechanism of being able to psychologically detach from their body during a traumatic experience.
Do you agree that battered
Overruled.
women often develop the defense mechanism of being able to psychologically detach from their body during a traumatic?
Sue's what? Welcome to the Fine and Dandies. If anybody's got their... Remember, if you remember, you get shout-outs too, so you don't have to pay any more for it. You click the $sign, and I know that, how can you click the $sign and not pay? But click the $sign, and if you haven't used your monthly shout-out, you can celebrate whatever month of a Dandy membership you're on. Sue's What is a pro se client with her 3rd month of membership. So welcome, and welcome returning membership. Anyone else that has memberships that they want to celebrate, by all means, look for that shout out button. It shouldn't cost you anything. Don't do it if it costs you something, unless you want to, but don't. But you get a free one a month for every channel you're a member of. So even if you've been gifted a membership, you get a chance to get your shout out on that channel. So try it out if you've got it. We'll get back to the testimony.
Experience.
Some people do experience that.
I'm just going to list some of the
I think he's going to use the literal power and control wheel now, because he's just going to list some of the... So let's see.
symptoms that you find in battered spouse women, and just to see if you agree with these. We talked about intrusive memories and flashbacks of the past traumatic events. You agree with that?
Yes.
The severe anxiety and hypervigilance.
Yes.
The panic attacks.
That is sometimes present. It depends on how the person experiences anxiety, but some do have panic attacks.
Very low self-esteem.
Yes.
Poor body image.
Sometimes.
Disney Mom gives me a reminder, and I've wanted to try this, so we'll just try this out right now, and my apologies in advance. Alexa, play Never Gonna Lift You Up.
Feeling that they have no control.
Yes.
Sexual dysfunction.
It can be, particularly if the trauma includes sexualized attacks.
Short-term memory problems and confusion.
Yes, that's part of PTSD sometimes.
And they can actually have physical health problems, from the chronic stress and physical violence.
That's correct.
Fear,
Yes,
constant fear.
that's correct.
Did anybody's Alexas kick
Now,
in?
The abusive partner, the abuser, part of the abuse would be hitting, kicking, punching, choking, burning, and biting.
Approach.
Oh, more sidebar. Okay. Excuse me. I'm not going to switch screens just so that I can get to it. Judge, I'm going to object to relevance at this point. Again, we're going into things that aren't in evidence. There's no biting alleged. If he wants to ask hypotheticals about things that are in evidence, that's acceptable. But again, we've been down this road for a few minutes now, and they're not being asked in the form of hypothetical. There's no evidence in this case that these, like body dissociation, anything she said. Court says response. Judge, she's testifying as an expert in the field of post-traumatic stress tied to the subset of battered spouse syndrome. What people will experience in this testimony from Sarah Boone about all what she's experienced. I don't recall biting. I don't think there's been any of that either, but I'm asking questions generally. What do you look for? What do you find? The question that was asked was specific things: kicking, fighting, biting. Yeah. That's the general question. That's not specific to Sarah Boone. I didn't ask as if Sarah Boone had been hit. I know she's been burned. I know she's been choked. I know she's been punched. I know she's been kicked. I know she's been hit. Okay. Anything further, Mr. J? These things need to be asked in the form of hypothetical, and they need to be based on facts and evidence. Court says, okay, I'm going to find that it's relevant. What's your response to the improper form of the question? I don't know what he means by that. Improper form? I can ask, are these acts that are committed by the abusive partner that are common to, if you want to ask, what are those acts that may be acceptable? I didn't think his leading for me to ask is hitting a comment. I would agree with that. I'll break it down. I'm going to allow you to re-ask and revisit in another way. Okay, I think
You may proceed, sir.
Rick rolled a few people. Okay, I won't do it too often.
Court, I'm asking about common
I won't take advantage of that.
by the abusive.
But occasionally, if I've got a little song that I want you guys, everyone with an Alexa. It came up in Suma's chat about her triggering it, and I put in a comment about never going to lift you up. Oh, yeah, I've got to stop saying it too. Unless there's somebody specifically in chat named Alexa, from now on, I'll stop saying the word. Sorry, ALXEA owners.
Partner towards the victim that create this intimate partner violence or create this syndrome in the woman. Hitting,
Yes, that could be an overt act.
kicking,
Yes,
punching,
yes,
choking,
yes,
burning,
yes,
using weapons to hurt you,
yes,
a knife,
correct.
curtain rod,
Yes,
threatening to hurt you,
Threatening to hurt you? He says that the exact same way to Sarah as he asked the question here. What, he was going to end you? No, he's going to end the dogs. Yeah, me. We're talking about me here.
your children, or your pets.
yes,
Belittling and humiliating you,
that's correct.
taking your car keys,
Oh, yeah, and it's never going to give you up. Thank you, Kelly. I'll make sure that my future Alexa pranks are addressing the correct version of the song.
That would be considered a form of control, so yes,
controlling your money,
yes,
control where you go, and
Oh, controlling your money. Like, how about I have a debit card and your paychecks go directly to my debit card? Is that control?
who you see,
correct.
and who you can talk to.
That's right.
Force you to have sex when you don't want to.
Yes,
Poor George being forced to have sex with Sarah. That's perhaps one of the biggest crimes outside of his murder that he had to endure from her.
Stalking you,
yes,
slapping you,
correct.
And he's even reading it in the slapping you. This is directly from his Sarah questions, and he's not even changing it to, like, slapping the victim, slapping the battered partner, slapping you, biting you, controlling you.
You agree victims that suffer from this abuse experience feelings of anger,
Yes, that can be in some of the phases. So,
sadness,
yes,
hopelessness,
yes,
worthlessness,
correct.
intense feelings of fear,
Yes,
abusers have a tendency to have low self-esteem themselves.
Overruled.
Abusers.
Overruled.
The abuser can have low self-esteem himself,
yes,
have a desire for power and control,
correct.
have a tendency
Power
to use
and
alcohol
control.
or drugs.
Yes,
That's a great point from Tammy Sellon.
Abusers oftentimes
Imagine if she was giving her snacks and she had them spread out in front of her, and during like quiet moments of testimony there, she's sitting there crunching on a bag of chips, like the whole shebang.
have temper,
that's correct.
become jealous easily.
Rita Schuler,
Very
great
possessive.
question.
Can be.
How much time do we have left of Julie? Now, the good news is looking ahead on just the bar, like the little, mountain graph of like how long people are interested. Interest goes way up, despite the fact that Julie's here for, I'm sorry to report this. She's on the stand until 7 hours of this video. We're at the 6 hour mark. We've got at least a full hour of Julie, Dr. Julie, but the silver lining to that, and it's a fairly thick silver lining, most of it's cross. I think Mr. J is getting up. Oh, yeah, Mr. J is getting up in the next 15 minutes, maybe less. Cross is a lot more fun, and that's exactly why we're starting to see some peaks. And then there's sidebars. There's some kind of very interesting thing that happens at the end of trial, whatever it is. It's the most viewed part besides what? Well, besides last week's episode, Michael Brandon, I think. Okay, we'll just get going. Good question, though, Rita Schuler. So about an hour left of Julie Harper. I will try and minimize pauses and breaks so that it is actually just an hour. Yeah, and then that'll take us to Tanya Werner, whose testimony I think takes about the same amount of time. So if we're 3 hours in on Julie, we might be 6 hours for a full show today. That's tentative. This is the part where Owen starts flipping through documents.
The victims can suffer from severe.
I got to get this right. Oh, that's so good in the closing, too, where he just flips around. It's important, so I want to get this right. And then he wastes a bunch of time flipping papers. Okay, let me just paraphrase. I guess it's not that important.
Psychological distress.
That's correct.
Is that what Sarah Boone suffered from?
Yes.
Yes, sir.
Nobody even objected. He's approaching on his own. Oh, he needs evidence. Oh, he's not going to bring... I think the big poster board pictures. I don't know if it's Harper or Werner, but one of the doctors, Owens, starts showing the pictures. And one of... Okay. That's what it sounds like when I smash my mic with my hand. If anyone was ever wondering what that would sound like. I just forget it's there because it's not even there in the screen. I've got it green screened out. Sorry. Owens holds the poster like... Sorry about that. Oh, my. All right. We're good.
Yes.
Oh, I'm going to turn up the audio because now he's whispering and they're away from the mics.
Yes.
All he's doing is showing the same pictures, the same stupid pictures. These are like the evidence photographs. So I guess he's got to show them to her. Well, I don't know why he's showing them like this. And then he shows the other doctor the blow-ups. But yeah, these are the black eye picture, the curtain rod between the eyes, the burn mark because of the broccoli soup.
Picture of the bloody knee. Exhibit 8, picture of her black eye.
Yes, I've seen these.
Picture, exhibit 7, picture of her.
Detective Wolbefit, Cross is coming in the next 15 minutes. Maybe I'll even throw up a little timer to let people know who are getting sick of seeing Julie.
Exhibit 6, which is of the stab to her leg. Are you familiar with those?
Yes.
And I don't know if you've seen this, exhibit 5 is where she spilled some soup as a result of his behavior.
I'm not sure if I've seen this photo, but I've seen the medical record associated with that.
Of that burn,
Yes.
exhibit 4,
Yes.
agree with that? Looks like exhibit 3, she was slapped on the
Yes.
tongue. Exhibit 2, picture of bruising to Miss Boone.
Yes.
Did you consider all those photographs informing your opinions that you've expressed here today as it relates to Sarah Boone?
Yes, under the substantiation that she has indeed experienced past instances of intimate partner violence against her.
Is it fair to say that it takes time, a number of times, to visit with someone like this?
9 times to be exact.
Yes, traumatized people are slow to disclose information. You have to build rapport. You have to make sure that they experience you discussing other things without an emotional reaction. They feel easily judged, as we mentioned, have defensive denial, things like that. So you need to build good rapport in doing an assessment with somebody that's experienced trauma.
So a lot of times, they're very slow to open up and tell you about the abuse.
That is correct.
And they'll actually often lie about it.
Deny it, yes, and just say that that's not the issue or they're fine. So oftentimes I'll have an evaluation request come from an attorney who's having difficulty interacting with their client, and then ultimately it's the result of trauma.
Now, I know that you viewed everything, and I know you've seen her 9 times. Is there did you feel like you had enough time? Was 9 visits enough time for you to feel like you had enough time and information to form the opinions that you've expressed here today and given to this jury?
Yes.
That's all the questions I have.
Okay.
Oh, there we go.
Any cross-examination?
Yes. Well, I made that coming next just in time.
Harper,
Good afternoon.
so you have done some evaluation work on battered spouse syndrome for a prosecution in the past?
No.
All right. Have you done insanity evaluations for the prosecution in the past?
I have been called to testify about that.
So you understand when the government obtains a court order for their expert to come in and do an evaluation, it's for one evaluation, correct?
I believe that you're saying that the government can retain their own expert, yes.
No, man, what I'm talking about is you just went through that you had 9 visits with Ms. Boone, correct?
I did, yes.
And that was over the course of 8 different days, because 2 of those visits were morning and afternoon sessions, correct?
That's right.
And what we are trying to help you have the jury understand is that when you get hired by the government and the court gives you an order to go evaluate somebody, you get 1 crack at the apple. Is that your understanding from your past work working for the government?
No, that's not always correct. There are many instances in competency evaluations where evaluators will request additional visits if they cannot determine their opinion on the first visit.
All right?
So you get multiple bites out of an apple. Yeah, that's why that analogy kind of falls flat, because most apples do have more than 1 bite in them. Oh, you want another bite of the apple? Well, yeah. Yeah, I plan to eat the whole apple. That's why I took the first bite.
Specifically when it comes to an affirmative defense, such as battered spouse evidence and insanity, what is your understanding and your expertise?
What is my understanding of the
One.
issue? Oh,
Judge, the question...
Legal objection.
Super Kelly, is the volume reduced? Oh, yeah, sorry. I did reduce it because Harper's low, but I'll bring it back up to full. Let me know if it's too much. There we go. We're back to full.
Objection?
Legal grounds.
He asked a question about battered spouse.
Objection, legal grounds. And then Owen proceeds to just say whatever he doesn't like, but no legal grounds. Okay, let's just go back a half second. Let's see if that improves the audio for listening to Mr. J, because his questions are good. Go back 30 seconds.
it's not always correct. There are many instances in competency evaluations where evaluators will request additional visits if they cannot determine their opinion on the first visit.
All right? Specifically when it comes to an affirmative defense, such as battered spouse evidence and insanity, what is your understanding and your expertise?
What is my understanding of the
One.
issue? Oh,
Judge, the question...
Legal objection.
Objection?
Legal grounds.
He asked a question about battered spouse and
Approach.
insanity.
Oh, okay. Sidebar. Should have been looking. Abuse me. Okay. Abuse. Still Owens. Cross-exam and grounds, legal grounds approach. Here we go. I think, okay, this is where it starts getting fun, I believe, too. Put this down. If you've gone for a break, come back. Now is a fine sidebar that is worth watching. Well, I don't know. I don't read ahead, so I just know that there's ones when I'm watching the trial during the week to get ready for it that I'm like, what the hell's happening here? So I know that there's some of them that I'm super interested in, especially because the body language told me that Owens was walking back defeated after this one. Sidebar window. Or you know what? I'm just going to leave you on the full window because I want you to guys be able to see it. I can bring in the transcript in the lower corner there. Okay. That'll work, and let it roll. What are the legal grounds of the objection? It's a compound question. He asked. The question was asked relating to sanity and battered spouse syndrome, and I think that should be split up. Response, if any? Perhaps I used the wrong disjunctive or because they're both affirmative defenses. I'll move on.
Sustained.
You can rephrase it. Sustained for now.
When it comes to an affirmative defense such as battered spouse syndrome being used for self-defense or, not and, insanity, it requires a court order for the state.
Or, not and, kind of, Mr. J can't help dropping what just happened at sidebar there. I just got corrected on my grammar. So, or, not and.
To go have an evaluator go, right?
Yes.
All right. Now, what are the agreed upon criteria for battered spouse syndrome?
Well, you would evaluate if the person is indeed suffering from a behavioral response like a mental disorder. So first of all, has the person demonstrated that they've got a behavioral change? And is it in response to a violent act? Do they perceive threat where they've been exposed in the past? So a pattern of violence that has repeated.
Does control over another person in an intimate relationship have anything to do with it?
Yes, it can.
Does isolation have anything to do with it?
Yes.
And by control, I mean controlling who you go see.
Daniel
who you hang out
Siobhan's
with,
here.
So on and so forth.
Yes.
And could it involve controlling personal items of the other person as well?
Yes, it can.
So that's what I'm asking. Like in the DSM-5 TR, I believe you pulled up narcissistic personality disorder.
Yes.
And so when you do that, it pulls up and it says there's 9 criteria and 5 of those criteria must be met to make a diagnosis for narcissistic personality disorder, correct?
That's right.
Now, battered spouse syndrome is not recognized by the DSM-5 TR, correct?
No, it's not a diagnosis. You wouldn't use it as a diagnosis.
And what I'm asking is, even though we haven't written it down in the Diagnostic Statistical Manual, and I mean the, like the Ohio State University or something, is it written down anywhere? Can one psychologist or psychiatrist rely upon a recipe or a list of criteria that everyone else would be using in your field as well?
There is no standardized approach you must follow. In other words, sometimes if we have a statute, for instance, it would identify what we must investigate. It doesn't exist like that. There's no statute directing it.
And there's nothing written down anywhere that says, of these 9 criteria, these things must exist. Controlling your partner, isolating your partner, beating your partner, so on and so forth, correct?
That's right.
All right. Now, this kind of abuse can come in the form of emotional or mental abuse outside completely of physical or sexual abuse, correct?
So that is a component. You can have extreme mental abuse occur of a person, yes.
And if that person responds to that environmental stimuli of whatever it is the partner is saying or doing to them,
Welcome back,
they
LZB.
may internally view that as traumatic,
Hey, Victoria Carmen.
or they may not.
That's right.
It's entirely possible for 2 people to be in a 3.5-year relationship that has physical violence and neither one of them feel traumatized by that. Is that correct?
That's right. If they have enough supportive or positive experiences that would negate that ratio, so of positive to negative, they may feel okay.
And a man can be subjected to this sort of trauma, whether it be physical, emotional, or sexual, by an intimate partner as well.
Daniel Savon, are you eating those carrot coins for lunch today? Shh, be quiet. She's on the laptop at work.
Correct?
That's right.
And it's basically it's unique to each relationship, right?
That is right.
But trauma is in the eye of the beholder. Is that fair? Whether a negative experience traumatizes somebody is going to be in the eye of the person who experienced that stimuli, correct?
I only partially agree with you. It's a complicated answer because some of the manifestations of trauma are behavioral. So for instance, when I evaluate veterans who have returned and they may not
I'm going to stop you right there. Sarah's not a veteran.
know that they've been traumatized, their bodily responses that
Barbecue Queen. You don't have a random nickname for me, Dandy. The dandelions are a subset of the fine and dandies, and you're certainly welcome to become a dandelion. LCB very generously designed a logo, which you'll see in some of my shorts, that features a lion with a mane of dandelions and just a couple of them blowing away in the breeze. And it is a very lovely tribute to the finest and dandiest of the fine and dandy, who are lions and spreading the word of dandy in the Sarah Booniverse. So it's a beautiful thing.
include like difficulty concentrating, they can't sleep, they're hypervigilant. The PTSD diagnosis encompasses outward manifestations. So even though they don't acknowledge trauma, you can still identify it as a clinician.
But still, somebody like a homicide detective or a homicide prosecutor can go to scenes where there are dead bodies, go to autopsies where there are dead bodies, and not walk away with any trauma, correct? Whereas somebody else might.
Right, the environmental, I guess, cues for that person, and also working with law enforcement, they become seasoned to micro traumas. So the first, almost every police officer can remember the first dead body they've seen. So it's in their memory. And then they become accustomed to seeing gruesome scenes. They have an increased tolerance over time because it's part of their job. It may not be part of their intimate relationship that they have with someone else.
Now, you brought up veterans. Is something common with PTSD with veterans, something like firecrackers may set them off because it reminds them of acts of war?
That's right.
You're not suggesting to the jury today that if somebody who returns with PTSD from service and hears firecrackers is justified in going outside and just shooting bullets everywhere, correct?
Correct.
No, that's not what I said.
I'm not saying you did.
Okay.
I'm saying that's not
What
allowed.
this battered spouse syndrome evidence is helpful for is not that subjective mindset, but rather helping to explain the objective circumstances that are presented to somebody and how it might be different from somebody with those experiences. They may view something objectively different.
I partially disagree with your question because I would say that there are incidents or actual events between partners that would be a factual thing, something has happened. And then the person subjectively experiences that as, intrusive or controlling or traumatic.
It's funny how Sarah's able, the talk about veterans in the same breath as Sarah is, hilarious and sad at the same time. But she associates, well, my brother's a veteran, so I can claim false valor, or I think that's what it's called. Stolen valor. But yeah, so on the one hand, I've got a brother who's in the military, so it's like I'm in the military. And it's like, yeah, and you also have a brother who's in prison, so it's like you're a criminal.
So that is the person's felt or subjective experience. The objective part is what happened.
But again, as a forensic psychologist, you're familiar with the justified use of force instruction, correct?
I'm not a lawyer, though, so I'm aware of it, but I cannot debate fine points of that with you. I'm sorry.
I'm just helping, I'm trying to understand what you said before, because there's a subjective component, whether or not a person believes subjectively that they need to use some sort of force, deadly or non-deadly. You agree with that, correct?
I do.
And then there's also a second component that it's objectively reasonable to the ordinary person to use force, correct?
I understand what you're saying, yes.
And what I believe I heard you mention earlier about battered spouse syndrome was originally it was meant to help understand why people stay in these relationships.
Originally, yes.
Because it may not just be intuitive to somebody who doesn't understand these things why somebody who is abused time and time and time again would remain in that relationship, correct?
That's right.
And again, and I know you're not a lawyer, but if the law has evolved about retreat and not having to retreat and so on and so forth, that kind of changes some of the lens of this, correct?
Judge, I'm going to object.
Approach.
Oh, there we go again.
Check. Question withdrawn. You may proceed.
Oh, he's like, no, I don't need to ask.
All right. So you would agree that, hypothetically, if somebody is running down their partner, saying negative things about them, telling them they're unattractive, telling them things that would potentially hurt their feelings, that could be an element of control of a verbally abusive relationship.
It could.
Okay. Propping one up.
Okay, so another reason to interrupt her, and I'm trying not to do it too much so that we don't extend her time in the feed any longer than it needs to be. But this sort of combativeness to basic questions, it's the exact opposite of Michael Brannon. And it's one of the reasons I think there's still this lingering distaste. Like, you've got to agree with the basics. When he's just asking basic psychological questions that are inner training, she's like trying to think ahead to whether it's good or bad for the defendant and couch her responses rather than just being honest and forthright like we saw with Dr. Brannon.
Hypothetically saying, I'm the best thing that has ever happened to you, you'll never do better than me. Is that a potential component of the control that one in an abusive relationship might exert over an intimate partner?
Yes, to try to not encourage their partner to leave them. Yeah.
Considering gifts, hypothetically, that one partner has given to another partner.
Thank you, if I may, please.
But considering it still to be your property because you gave it to them.
And Forever Wander?
Is that a form of a potential exertion of control over an intimate partner? When you give somebody, hypothetically, a bike, but still consider it your own bike?
Great hypothetical question there, Mr. J. If you hypothetically gave somebody a bike and said it was your own bike, would there be any psychological information you could derive from that hypothetical situation? I ask you, Dr. Harper.
I mean, I don't think that's strong evidence of that. I think that it does happen in relationships and people do that in general, but.
And now the same jury that just heard her, defend Sarah like she's a veteran with PTSD is listening to her, listening to her respond to these hypotheticals about bad things that, you don't need to be psychologists to know, yeah, that's not right. You don't give someone a bike and say it's my bike.
I wouldn't say that's like really
That was actually lyrics in one of my Christmas songs too. Last Christmas, I gave you my bike. The very next Christmas, I said it's my bike. This year, I'm saving my cheer. We'll do somebody special.
specific to this.
How about hypothetically exerting control over your intimate partner's identification papers, such as a birth certificate?
Hypothetically.
So that can happen. People.
Kelly asked the questions right out of Dr. J's mouth. How about hypothetically IDs, birth certificates, and passports and stuff? Hypothetically.
Will hide things that are required for work.
Hey, Bella's
for
mom
instance,
got the
like
Thin
your
Mints.
driver's
Nice.
license or things like that.
Now, I'm asking yes or no questions. If Mr. Owens.
These are
would
all
like to
yes or no
elaborate further,
questions.
he's going to have that opportunity in a little bit. Hypothetically, if one partner destroys another partner's belongings, is that a potential example of exerting control in a relationship?
Yes.
Thank you. Hypothetically, is threatening to or actually
Super Kelly G, I like to think it's a little Johnny Fever, a little Weird Al, and just a touch of the Venus flytrap.
using legal process as a threat against your intimate partner in a potential indicia of controlling your partner. For instance, X, Y, or Z, or I'm going to get you arrested.
Yes, I would agree that happens.
Now, I assume you would agree that this cycle of violence that we've
Controlling access to food. What if a person said hypothetically, "That's my pantry, get out," and then called 911 to say he peed on the floor?
described, the tension building, the blow up, and then the honeymoon phase. You would agree that just one of those cycles could be enough to give somebody a traumatic experience if they took it as a traumatic experience.
Yes.
The defendant described her first date with Mr. Torres to you, did she not?
She did.
Oh, the first date. You know what? I've heard the first date story before, but I'm going to let you guys sit with it. I've got to do my up and stretch and get my legs moving, so I'm going to use the opportunity to get the snacks. I've been eating too poorly, so this is going to be a little PSA for just because it's funny doesn't mean you should eat sugar for your diet every Friday. So I'm having a more healthy stream. I've got some overnight oats that I mixed with a little bit of skim milk and added peaches to, frozen peaches. So I'll be eating that, as well as I've got a bag of grapes that I've chilled in the fridge just for eating on the stream. So that is my medical snacks today, some overnight oats and fresh fruit, fresh and frozen fruit. You can't eat like the way Sarah wants to eat for court. Like that's just it's a recipe down. That's how you get to, diarrhea crisis eating like that.
And at the time of this first date, they had obviously just met that night at a bar, correct?
Right.
They were not financially intertwined, correct?
That's right.
They shared no children in common.
That's right.
They did not live together.
Correct.
And after this description that she provided you, which included him smashing her phone, correct?
Yes.
Hitting her, first time she'd ever been hit in her life, correct?
Yes.
And making her crouch in like a fetal position on the porch for several hours to the point where it hurt her back, correct?
Yes.
Threatened to sodomize her,
Correct.
and she described that she was all bruised up, correct?
Yes.
After that, this is the first time she had ever met him, correct?
I believe so. Yes.
There was a second date, correct?
Yes.
Despite not having any of that intertwinement that we went through prior to this description, correct?
That's right.
Now, it is possible, under what we've discussed, right? Just that quick one date can be that buildup of tension and blow up, correct?
Yes.
But it's different, hypothetically, than saying a spouse who is financially dependent on his or her other spouse in a 20-year marriage with a house full of kids, than a first date, correct? You would agree in severity, in the intertwinement, there's a difference.
There's a difference in intertwinement. The pattern can be exactly the same.
Now, of course, there are many different reasons why somebody will stay in a relationship that, when perceived from the outside, others would say is abusive, correct?
That's
The defendant described that she felt like she was making Mr. Torres a better person, correct?
That's right.
A better father,
Yes.
correct?
Right.
A better ex-husband?
With phone calls, yes.
And she would tell him to call his children,
That's right.
make sure that he sent them Christmas gifts,
Yes.
and make sure he sent his ex-wife money when she asked, correct?
Yes.
So you would agree those are indicia or indicators, sorry.
Understand?
I know you. That perhaps she wasn't necessarily financially dependent on Mr.
Is he making fun of the fact that she kept saying one of criterion rather than criteria? So he's doing the singular form of indications. I don't know. Mr. J is very subtle with his shade. That's the sort of thing he would do.
Correct? I'm not saying conclusion, but those are indicators. If you're saying, please spend your money elsewhere, that I don't need your money, correct?
No, because even if there was money that was needed by Ms. Boone, her tendency to put the needs of her partner before her would direct her to do exactly that, like make him better, make him happy.
Sarah Boone never put the needs not only of her partner, but of anyone before herself. That is a fundamental. Yeah. Well, that just calls into question everything. That's probably why. Well, there's a lot of reasons the jury would have disregarded this testimony, but wow.
Have the availability to visit his children, send them presents, even if she's the one that needed the money.
And in her perspective, Mr. Torres needed her to do this to make him a better person, correct?
I believe that, yes.
And he'd come so far. Oh my God, I was doing so well with him.
How many years of her adult life did she describe working?
I don't think she gave it a specific quantity. We just went through a variety of her jobs.
Yeah, I agree. I don't think she gave it a specific quantity. How many of her years of life did she describe were working? How did you phrase that, Mr. J? That was pretty funny. 6/16/56.
How many years of her adult life did she describe working?
I don't think she gave it a specific quantity. We just went through a variety of her jobs that she
Not more than one.
had in the past.
And, you know, she was low 40s when she met you? 4
Yes.
years ago?
That's right.
So
So she was in her 40s when she met you and couldn't describe more than a year of work, just a variety of work experiences?
she had been 18 for probably about 24 years. Did she give you a 24, right? 24 plus 18, 42?
Oh, you said
Look-
for 24 years. And that's why I was confused. You can't be 18 for 24 years. But
Did
24 years ago, I would agree.
Oh, the math genius. You can't be 18 for 24 years. But some of us have tried. Some of us have tried. I think I was 18 for at least 7 years. I don't think 24-year-old me was much more mature than 18-year-old me. But I think by even early 30s, acting like an 18-year-old kind of wears off. Blink-182 had a good song about it. The What's My Age Again?
Did her work history kind of flesh out to be 24 years is what I'm asking?
I'm not certain.
It did
And
not.
at the time, in the apartment in 2020, she had not been working, correct?
That's right.
And had not been working for some time.
That's right.
And what she was doing was living off of the settlement that she had been.
You can be 29 for a while, but yeah, you can't be 18 for 24 years. That's what I'm saying. It's unsustainable. Like, there's a certain level of recklessness to being an 18-year-old that the fact that many of us made it to 19 is probably impressive in and of itself. But yeah, I think there's a lot of wisdom to the statement. You can't be 18 for 24 years.
Bought out of with her husband was lump sum plus $1,000 a month in alimony and $100 a month in child support, correct?
Yes.
It was Mr. Torres who would work, correct?
He worked at Ace Hardware.
When he would show up.
Right.
Sometimes he didn't show up, is what she indicated, correct?
Yes.
Because of his drinking problems.
Yes.
Did she describe to you, well, let me strike that. She did describe to you one instance, at least, where violence occurred in front of her child, correct?
Yes.
and that her child had gone to school and reported it, correct?
Yes,
And you understand as a forensic psychologist that teachers are mandatory reporters, correct?
that's right.
Did you review any DCF records in this case?
No, I didn't receive any DCF records.
Did Ms. Boone
Why didn't you review DCF records? And that would be a Department of Children and Families?
ever indicate to you at any point in time she became too afraid to let Lucas come over to the house?
Yes, there were times where she would ask Mr. Boone, so Brian Boone, to not bring him there.
And Mr. Boone was aware of this because she would say things like that, correct?
Yes,
And at different times, she told you that she would go over to Mr. Boone's house to escape the violence of Mr. Torres.
that's right.
And February 24th of 2020, the child was scheduled to be picked up by Miss Boone, correct?
That's right.
Despite everything that she was aware of and what Mr. Brian Boone was aware of, correct?
Right.
Right.
And you saw in her police interview that she swore on the life of her son that she was telling them the truth, correct?
Yes.
Yes?
Object.
Approach.
I object. Approach. All right, Mr. Owens, I didn't see that one coming. Here we go. Catching up. Mr. J was on a roll there. There we go. Intermission. A chance to get situated. Sidebar screen. Let people know sidebar is in progress. And the first thing the court says is legal objection. That's an inaccurate characterization of the facts. Oh, that's my Mr. Henderson. Got a little bit of oat on my tooth there. I don't want that to. Okay, here we go. That's an inaccurate characterization of the facts. We'll have to rewatch the video. But at the end of the video, she swears on a son's life that it was not intentional, that she did not cause the death. Mr. J, I'll rephrase. Objection is sustained. You can rephrase. Minor one.
Objection sustained.
I'll rephrase it. She swore on her son's life that it was not intentional that she ended up killing Mr. Torres, correct?
That
I object.
What are you objecting to now? Because she 100% did say that. Now, maybe that got clipped out of the interrogation video, and that's what Mr. Owens is trying to complain, like, hey, we had that redacted. But if that's the case, it doesn't mean that it can't be brought up in evidence, not presenting the interrogation for facts, but for asking a psychologist about a specific statement that was made in an official document that is relevant. Because I think those redactions were made when the state was presenting its case and before Battered Woman was part of the defense. Anyway, let's see what happens.
Approach.
Approach. Mr. J says, the quote was, I promise you on my son's life that it was not intentional, referring to the death she caused. The court says, I understand the reference, but if the statement is particular as to what she's swearing on, let's keep it in line with what it is. You can make the argument with that later. Mr. Owens, Judge, I'd like to ask that the last question be stricken by him, because that was not in the transcript. That's fine. Back to open court. Did I not press pause? Maybe they took a lot longer to say that. Okay. See, sometimes I rush my James Owens because I don't think I'm going to have enough time to say judge.
Objection sustained. Question is stricken. Members of the jury, questions are not evidence, and you're not to give them any weight whatsoever. Mr. J, you may proceed.
She's, quote unquote, swore on her child's life that it was not intentional. Just that. Correct?
before I answer, I'd like you to direct me to that part of her interview. So
I'll strike it with you.
Before I answer, I would like you to direct me to that part of her interview. Was that a particularly evasive maneuver? Now she knows that that part of the interview isn't part of the evidence, so by saying, please refer me to it, he has to move on. That's a weird little moment.
It's on video. Some of Miss Boone's diagnoses predated her relationship with Mr. Torres, correct?
Yes.
And so when diagnoses predate a violent intimate partner relationship, there is an independent cause, even though they may then later contribute to the phenomenon we see, correct?
Well, I wouldn't say that all mental disorders have an independent cause.
Okay.
Sometimes they're spontaneous or biological in nature.
Well, let's talk about hers. I mean, you're familiar with her prior diagnoses, and you went through her childhood, so on and so forth, correct?
I did.
So she was bringing some things with her prior to Mr. Torres' relationship, correct?
She had these.
Also yes or no, ma'am?
Yes, she did.
These are all yes or no questions.
You reviewed some Advent health records, correct, of hers?
Yes.
And some Aspire records of hers, correct?
Yes.
And you would agree that there are times in the Advent health records where she goes to the hospital and then leaves before getting treated, correct?
Yes.
And there is a time when she goes to the hospital where she is described, their words, not mine, as having ETOH on board.
Yes.
Do you understand what ETOH means?
Ethanol.
In a medical record, you would use that shorthand for alcohol.
Or ethanol, right?
Yes.
Drinking alcohol, not the other stuff.
Correct.
And in the records that you reviewed from Aspire, she came with complaints of depression in January of 2018, correct?
That's right.
And ethanol, or alcohol, is a central nervous system depressant, correct?
Yes.
And I know you're a psychologist, not a psychiatrist, so let me know if I'm pushing you too far and you're not going to answer. But you are familiar generally with the effects ethanol has on the body.
Generally, yes.
And you can and do make diagnoses of alcohol abuse disorder.
I do.
And in your professional life or personal life, are you familiar with the standard serving size of drinks when you're evaluating somebody's drinking?
5 ounces or 10 servings in a 50-ounce Magnum. And speaking of Magnum, Kim Stole My Fish Soap says, does anyone know if Dr. Harper was in the courtroom during Sarah's magnum opus? And Dr. Harper definitely testified at the sentencing. So it's just a question of whether she stuck around in the courtroom to see how the rest of the hearing went, or if she left after providing her testimony. She is a bit of a mercenary, so she could have just came in, took her money, okay, got to move. Next city, next case.
For instance, hey, I only drink 2 drinks a day. All right, well, are they 64-ounce mugs of beer or are they 12-ounce? So are you...
And Barbecue Queen asked, Dr. Harper didn't see the interrogation, did she? She testified that she reviewed the interrogation transcript.
Familiar in that context?
It might be a question I would ask during evaluation. What are you referring to? Is it a mixed drink? Is it a shot? Like, I try to identify that.
And do you ever ask if somebody says they drink 2 glasses of wine, well, how big are the glasses of wine?
Sometimes.
And is your understanding that 5 ounces is the standard serving of wine since it's about 12% alcohol?
I'm not sure what the standard size is, but I would ask regarding like
The standard size. I guess the standard size would be whatever you normally drink. No, it's standardized, Miss Harper.
a wine glass.
And in January of 2018, when she came in crying and complaining of symptoms consistent with depression, she had a blood alcohol level of 0.165, correct?
I believe so.
She had a blood alcohol level of 0.165. Don't believe the subtitles there. He said 1.65. So she was double the legal limit at the time that she went for treatment to the hospital for whatever this visit was for.
And in October of 2018, when she ended up going to Aspire, when she was found stumbling by police, she had a breath alcohol of 0.185.
Found stumbling by the police. Had a breath alcohol of 0.185.
I'm reacting to your description of her stumbling by police. I know she approached police for help.
Oh, way to recategorize it. You don't like the stumbling assertion. Way to defend your client who isn't your client, and you shouldn't be defending. Just answer the question, Miss Harper. These are yes or no questions.
So
Welcome to the chat, Bernice. Dr. Julie Harper doing her Sarah Boone impression, shuffling papers, trying to act like a lawyer.
So there have been 2 sets of records, but I believe you may have the same set that I received on September 27th, 24. Can you turn to page 21 of 57 of the Aspire records?
mine aren't numbered, but I will.
May I approach the witness?
Yes.
I'll show you exactly. And I think what he's going to do here is show that every time that she goes for medical treatment, and this is the medical treatment that the defense put on the record, trying to claim that she had battered spouse syndrome, or that she was a victim of battered spouse syndrome. So they went to every time she'd ever been admitted for medical treatment. So Mr. J is basically saying, yeah, is it also true that she was piss fucking drunk every time she went in, and most of the time she didn't take the treatment or the follow-up or even stay at the hospital? You all done, Miss Harper? Ready for more questions? Who takes off their glasses? What the hell just happened there? She couldn't see, so she took off her glasses and leaned in? Sorry, this is, not the most critical legal analysis, but I've never seen that before. That's... Okay, I've got my glasses on. I look smart. I'm going to look at this detail on this piece of paper here. Looking up at you, looking smart, flipping pages. Oh, what's this? That's a bizarre sequence of events. Oh, okay. Thank you for clearing that up, hairball yarn. She could be farsighted.
All right, may I first, please?
You may.
What I'm showing you is what is page 2157 on records from Aspire that was provided to me by the
Okay.
on September 27th.
But no, now she puts them on. Look at that.
At the top, you can read the first or the fourth lines.
But now she's squinting. Maybe squinting, glasses on, sees better. No squint, glasses off. Lean in, see better. I think her glasses are a prop. I have no evidence for this, but I don't think. I think they're readers. Like half, like whatever the lowest reader lens is, but not. I don't think those are prescription. I think those are fashion.
Judge, I would ask that she be allowed to read that entire paragraph.
Now, giving up's with me. Okay. The glasses are a prop. Liars love a prop. And approach the bench. Okay, what are we talking about? Yeah, they're a prop. Drink, shots, approach. Okay. A little behind. I'm going to have to pause it then. Self catch up with the transcript. Okay, that must be it. Approach. The court says, Is there something else in the paragraph that pertains to the description that she was stumbling with regard, or is there something else in the paragraph that deals with the stumbling that the expert took issue with? That is a good question. Thank you, Mr. Kraynick. Go and let's run it. Well, there's a mention she stumbled up to the officer. She had a .183 or .185. I think she talked about depression with them. She said she was having relationship problems. That's the part. I think she's going to read the part. She's complaining about relationship problems, which I think under the rule of completeness ought to be allowed to be read. Mr. J, absolutely, and he can. It's his case. If he wants to introduce the medical records that were provided to me, I have no objection to it. He can. That's how the rule of completeness works. I don't want to introduce the records. I want to be able to have her review the entire paragraph. So when I ask her questions about it, she can say yes or no. Did she complain about relationship problems? Are you going to have a problem with him going into that on redirect? Asks the court. Mr. J, no. These are records they provided, so I assume everybody's on the same page. Court says, yeah. Mr. Owens, Judge, I ain't got the records right in front of me. I mean, I asked to take a picture of the actual paragraph she's referring to. You're talking about a lot of records. If he takes one paragraph out of all those records, expects me to have it at my fingertips? Okay, I understand that, but it's cross-examination, and he's going to go to the basis of the factual documents.
You may proceed, Mr. J.
Nope, you got to hold on, Mr. J. I'm not quite done. You guys went so slow the last time, I assumed I had time. Still the court. Okay, so the court's final ruling. Okay, I understand that, but it's cross-examination, and it's going to the basis of factual documents. She had testified earlier that she relied on mental health records. These are mental health records from Aspire, and there's going to be disagreement as to how she approached law enforcement. And that seems to be belied by what is in the records. So I'm going to allow him to proceed. You can take it up on redirect.
All right. October of 2018, there was a second visit to Aspire, and that was based upon her
Welcome,
being
Peter.
found stumbling by law enforcement with a .185, correct? And that's
She
supposed to
walked
be
up. Okay. So I'd have to say,
Peter from Australia. Peter, you have a location and a first name that is, if you're new to the Sarah Boone case, you may get some grief that is completely unwarranted and unintended. So everybody welcome Pete as though he is not associated with either Australia or the Peter and Jay situation. He's just Pete. He's just Pete, and welcome to the chat. Just Peter.
no, the way you phrased the question.
Ma'am, Boone was stumbling due to her level of impairment, paren .185.
Yes, I would agree.
Is that part of the records you relied upon?
Yes.
Thank you. When you talked to Ms. Boone about that, she kind of just described an event of June of 2018 and blurring those two events, did she not?
No, she told me she had two different Baker Acts.
Did she describe it as being June of 2018?
Two different Baker Acts.
I'll have to reference my interview note to find that if you would like me to.
No.
No. I think just having those Baker Acts on record is enough for me.
Do you remember giving a deposition on October 1st at the state attorney's office downstairs?
I do.
And at that point in time, and I'll ask opposing party, you want me to?
Hey, just me?
Before I ask her about it?
I think she's got a deposition.
Do you have your transcript?
I do.
Okay.
Mr. Owens just piped up. I think she's got her deposition.
Just,
So for the record, it's page 34 that I'm referring to. Line 16 and 17.
Yes, I'm with you.
Okay. She described that as June of 2018?
That's what I said in my deposition, that she was describing her experience in June of 18.
And she described this experience as going to the hospital to find a pastor, correct?
Yes.
And ends up going to what we call Lakeside Den and Aspire now, right?
Hang on. She went to a hospital to find a pastor? Oh my God, I'm going to die from my leg wound. Just get me a rabbi, a priest. I need to say my final penance.
Yes.
And then
Hey,
what
Peter.
described was she was talking about more of the violence.
Peter Shane says, thanks, Dan. Love your work. I've followed Madam Boone for years. She's really something else. Cheers for the welcome. Much appreciated. Well, fantastic. If you've been following the case for a while, you're going to fit right in here with the fine and dandies. Glad to have you aboard. Thanks for joining the chat.
That occurred specifically regarding a significant episode of Jorge driving her roughly in the car, so on and so forth, correct?
Yes.
All right. Those were two separate incidences. January, when she came looking for the pastor, correct?
So I'm just clarifying that there's a record that we started with this conversation from October of 2018, and there is a description of her trying to go to the hospital to seek a counselor. So those are two different instances.
Right. In January of 2018, when she went to the hospital crying and signs of depression,
Bless you.
she indicated that was
Bless you.
because her husband and son had gone out of town and she was feeling lonely and sad about having lost her job a few weeks earlier, right?
There were numerous stressors there, yes.
Nothing mentioned about any problems with somebody named Mr. Jorge or George Torres, correct?
You're talking about January?
Yes, ma'am.
Whenever I want to talk over quiet, I have nothing to say. Pair like little soliloquies, like haikus or something for these moments. See if I can get AI to write me a Sarah Boone haiku in the time it'll take for her to figure out what she's doing. Not really the most compelling audio either.
So the hospital records are not referencing her relationship with George on the January date.
Now, in talking about February 23rd, 2020 with Ms. Boone, you talked to her about that on several occasions, correct?
I did.
And part of one of those conversations, at least, was about an incident that she indicated had happened the night before February 23rd, 2020, correct?
Yes.
And she indicated and told you that she had been dragged down the stairs the night before the suitcase incident, correct?
That's right.
And in part of your review of this case, you reviewed all the crime scene photos, correct?
Yes.
And those include photographs of Ms. Boone, correct?
Yes.
And were there any
Miss
indications
Beasley
from
doll.
photographs
I'll
of
look up that.
injuries on her consistent with being dragged down the stairs of carpet?
I didn't see inside her scalp, so I didn't see photos of inside, her hair follicles and this area of her head. On her outward body, there were no indications of that.
And did you ask her
There was a wad of my
how
hair
it was that
missing.
she was injured during this dragging down the stairs?
I don't think I went through specific injuries to her, no.
Do Do you agree that alcohol intoxication affects the credibility of a historian that's providing history to you?
A historian.
Or a client?
Sarah the
If they're
historian.
actively intoxicated, yes.
We had talked, well, you and Mr. Owens, had talked about narcissistic personality disorder earlier.
Yes.
And that is a recognized diagnosis in the DSM-5-TR.
That's right.
And there's 9 of those, correct? 9 traits?
Are you talking about, you're talking about the criterion of narcissistic personality disorder? Yes.
Like page 761 on your hard copy?
Thank you.
All right, she's reading again.
All right.
Was I close? I have a digital copy.
760, but that's fine.
One of the criteria is has a grandiose sense of self.
Grandois.
For example, exaggerates achievements and talents, expects to be recognized as superior without commensurate achievements, correct?
Yes.
2 is preoccupied with fantasies of unlimited success, power, brilliance, beauty, or ideal love, correct?
Yes.
3, belief that he or she is special and unique and can only be understood by or should associate with other special or high-status people, or institutions, correct?
So 3, just caveat, it says believes, not belief, but the rest of what you said I agree with is the criteria.
Grammar error, spelling.
4, requires excessive admiration.
Yes.
5, has a sense of entitlement, unreasonable expectations of especially favorable treatment or automatic compliance with his or her expectations, correct?
Yes.
6 is interpersonally exploitive, takes advantage of others to achieve his or her own ends, correct?
Is interpersonally exploitative. I agree.
7, lacks empathy, is unwilling to recognize or identify with
Hey,
the feelings
Dor.
and needs of others, correct?
Yes.
8, is often envious of others or believes that others
Rest in peace to Dom and Davian. Thank you for joining the chat, Door.
are envious of him or her, correct?
Yes.
9, shows arrogant or haughty behaviors or attitudes.
Yes.
Might even describe Sarah as uppity.
Now, you believe that she has traits of that disorder, correct?
Yes.
Grandiose sense of
Oh,
self-importance.
I got it wrong. Sorry. Thank you, Hairball Yarn. Criterion is the singular of criteria. Got it flip-flopped. That's probably why Dr. Harper just settles on using one and then talking about it's one of many. Oh, so to say one of many criterion is wrong. Okay, so you're correcting her as much as me. I appreciate it. I learned something and we took her down yet another notch. Thank you, Hairball Yarn. A criterion of evidence might be similar to a single scintilla of evidence. Could be classified as one criterion that has been satisfied towards the scintilla of proof of an overt act that was necessary to bring in this whole BSS defense.
There are indications that she feels like that or has expressed that before.
So that's a yes.
Yes.
Preoccupied with fantasies of unlimited success, power, brilliance, beauty, or ideal love.
No.
You remember going to the state attorney's office on October 1st of 2024 and giving a deposition.
I do.
And it was
Jane Crow has an interesting theory on the barefoot night. In my head, when Sarah fled barefoot to Brian Boone's, she wanted Brian Boone to take her home. That failed. So then she calls an Uber cop, which is a whole nother scene, and then she forgets her damn keys. Brian Boone has to go over there anyway.
in front of a court reporter like Madam Court Reporter here.
Yes.
And you swore to tell the truth, the whole truth, and nothing but the truth, correct?
Yes.
And referring to page 89, lines 18 through 20.
It's a pretty smart move, too. Like, well, let's just go through the 9 criteria. Singular of criterion. Let's just go through those 9 criteria. Can you confirm? Is this one? Is this one? Is this one? So then they name all 9 of them. They're all on the record. And the jury can now use their own minds to go, oh, hold on. Really? Just, you had less than 5? Huh. Which ones?
Let me know when you're ready. Are you ready?
Yes.
Did you give the following answer to the following question? Preoccupied with fantasies of unlimited success, power, brilliance, beauty, or ideal love? And your answer was yes?
I did answer yes there.
She does not, according, in your estimation, does not believe that she is special and unique and can only associate with high-status people, correct?
No.
Does not.
Wow. This is great. He's almost moving too fast. He should let that sit for a beat, because in her mind, she's not special. No. Really. She definitely seems, for how ordinary she is, she thinks she's extraordinarily special. It's one of the first things that I think struck me to Sarah, is how out of whack her belief in herself is with her lack of things to be narcissistic about. Like, when I first learned the story of Narcissus in Greek mythology, he was always described as, this beautiful, like, so gorgeous that he stared at his own reflection till he died, or, something like that. In any case, perfectly chiseled, just a good looking guy. Sarah doesn't have that. Like, what would have, at best she was like, one of the cute girls, when she was in her Nickelodeon era, but, certainly not, the most striking, oh my God, I'm so much better than all these other people. And yet everything you see of her is 100% like, ugh, you and your family, ugh.
Not require excessive admiration, correct?
Correct.
Does have a sense of entitlement,
Yes.
is not interpersonally exploitive,
Is not interpersonally exploitive. Correct. She seems almost defeated. She knows that it's like, fuck. I guess I have to say which ones I didn't agree to.
Correct. She is not.
and when discussing whether or not she lacked empathy or was unwilling to recognize or identify with the feelings or needs of others, you indicated that that might be the case, but it's not intentional.
Mr. J. Yeah, this one actually applies, but she didn't mean to do it, so I decided to give her, half marks.
In other words, she's not aware if she's inconveniencing others.
She thinks that they'd love to paint her fence. It's actually a service that she's doing, letting people in to help her. She's like a beaten dog, folding back her ears and letting herself be pet.
So there was 3 of those traits, correct?
Yes.
Not 5, which would be required, correct?
Great call again, Mr. J. So basically letting the jury know, hey, you can pick any 2 of those other ones. If they apply, then yep.
For a diagnosis of the personality disorder.
If that were the correct diagnosis, you would need 5.
All right.
All right.
During your conversations with Ms. Boone, the defendant in this case, she explained to you that cheating to her means when Mr. Torres would look at pornography, correct?
Correct.
Cheating in your
Not
definition.
a real-life woman, correct?
No, not that he was engaging in sexual intercourse with actual women.
Part of the records that you did not review were
So the testimony is Sarah believed in thought crime.
the text messages that were part of the phone extraction of her phone device, correct?
That's right.
You indicated in your conversation with Mr. Owens that some of the traits that are commonly seen in abusers would be control, jealousy, easily angered.
Those could be, yes.
What other traits just common for abusers?
being a person who segregates their victim away from other sources of support, somebody that exhibits coercive control, meaning that they would prevent the person from engaging in activities that would be independent, so restricting their ability to have independent, like life, job, money, things like that, that would be supportive of them being left, for instance. Other things would be using emotional expressions like rage to cause a physiological reaction in another person. So those could be additional descriptions.
Specifically, the materials you reviewed. I just want to make sure we're on the same page. Paperwork from prior cases involving Mr. Torres and Ms. Boone.
Yes,
Medical records for Mr. Torres.
that's right.
The medical and Aspire records for Ms. Boone that we've discussed.
Yes,
The crime scene photos from the incident in February.
that's right.
Pages 1 through 413 in discovery in this case.
Right.
A photograph of a suitcase and 2 videos involving a suitcase,
That's right.
and additional videos on that phone, correct?
Yes,
Such as baseball bat smashing the TV?
that's part of it. Yes.
And then did you review any other videos where there's conversations between Ms. Boone and Mr. Torres?
Yes.
One prior 911 call?
Yes.
Now, today you had indicated that you had reviewed the photographs from some prior incidents of violence, correct?
Yes.
When is it that you did that? Is that recently?
No, there are photos included with the
The prior case packages?
case packages. Thank you. I'm not sure what to call it. So
That's fine.
All right.
All right, and did you review any body-worn camera from those prior case packages?
no, I did not. I didn't have that.
Anything else that you reviewed that I've not covered?
Are you speaking of documents only?
Yes, materials other than your 9 visits with Ms. Boone.
All right.
Other than the 9 visits. You must have got to know her well.
Just checking with the
That's fine.
pointers I
I
prepared
just
for
wanna make
today.
While she's preparing.
I don't know if, I guess that would be part of the discovery. The investigative report is within those 413 pages.
Trapped in zipped luggage. Cell phone
Did you interview
videos
anybody
taunting.
else personally besides?
Thought I'd be able to get it in. This is a AI haiku. I just asked it to write me a haiku based on the Sarah Boone trial. And I got trapped in zipped luggage, cell phone videos taunting, life behind cold bars.
Ms. Boone.
Yes.
Who else did you personally interview?
Melissa Sexton.
All right. Anybody else?
Talk to the property manager. Talk to the property manager. Did you talk to the property manager?
No,
You didn't interview Brian Boone, correct?
I did not.
You did not interview their child in common, correct?
No,
And you didn't review the phone text messages extracted from her device, correct?
no, I didn't.
Did you review any records from the jail?
No,
And
No records.
Yes.
Whoa. Just asked for an approach, no objection. Can I catch up? He asked that in a way to try and impeach her. That's something that she should have looked at, that she shouldn't do. And we had an issue about that. I don't think that's improper for him to ask that question. Response? I'm not following. Is your objection as to the lack of review of Orange County jail records or jail records generally, using that terminology? Or is it an objection to what she did not review? Mr. Owen, I think he was implying, first, that what all she did review, but then he went into you didn't consider this, and this. When it got to the jail records, he said records, but really it was the jail medical records that we had an issue on. I don't know if you remembered it earlier. When you're referring to, excuse me, this is a question directed to Mr. J. Mr. J, when you're referring to the jail records, are you referring to anything with regard to Ms. Boone's jail records? Yes. Because I have concerns about that. I know she elicited that she's been incarcerated, but I'm trying to avoid any prejudice with regard to that. Mr. J, right. And I'm asking if she's reviewed any treatment records. But Miss Boone is the one that said that. I know that, but it's specific as to the Orange County jail medical records. Mr. J says, I can be specific. The court says, okay, let's be specific. With regard, sir, to your objection regarding Mr. J inquiring these things, you can take it up on redirect if, whether or not she's needed to look at those things. Mr. Owens says, didn't we have an issue where we agreed not to pursue the medical records? I thought we were attempting to get them in the defense. I think finally get them or was given them right before we were about to pick a jury. Mr. J complained that it was so late in the game that he was going to have to take time to review all the records over the weekend during his private personal time. And he'd ask, I think, maybe to reduce them down. I can't remember. The court says there were 382 pages, and this looks like it's item 6 of the defendant's Fifth Amendment reciprocal discovery exhibit list. Certified medical records from Orange County Jail, not yet received by the defense. The objection was filed. My notes reflect that 382 pages were provided on October 17th to the state. And I think we had, Mr. J says, that would have been after jury selection. The court says, I think it was during. Mr. Owens says, oh, it was during? Court says, it was during. I don't know what we'd finalized because I think we delivered to them in the morning on a USB drive, potentially on the 17th because that was last week, Thursday. Mr. Owens says, it's all starting to blend together. The court says, my only notes are that there's something about an intake screen on page 135 and 138. Mr. J says, so we discussed what particular pages they might seek to introduce. The court says that they were looking to introduce. Mr. J says, what I'm asking now is, did she rely upon records that are routinely relied upon by experts in her field, which would include diagnoses? The court says, I totally get that. Mr. Owens says, and that's the whole reason that I wanted the records is because I wanted her to review them so this very question would not be asked. You didn't review these records. You should have done that. That's why we got the information as soon as we could. When we got it from the jail, it was during jury selection, which was 4 days. I think it was on the 3rd day. We hadn't sworn the jury yet. We got them. We immediately gave it to him, and he complained because there were so many pages. He wanted them pared down. Eventually, we just agreed or stipulated that we wouldn't use them, but that was for the purposes of admitting them into evidence. Mr. Owens says, I know, but now he's trying to use them against me, and I was doing him a favor. Mr. J says, I had reviewed all the records. What we were discussing was what was going to be admitted into evidence. Court says, correct. I agree with Mr. J. Mr. Owens says, I'm just trying to be a colleague, and now he's using it against me. The court says, but the exhibit list was solely as to what was going to be sought to be entered into evidence at the time, and whether it was you, the whole kitty of everything that may be admitted. I agree with you that Mr. J had an issue with the 382 pages. Let's take the time frame out of it, that there were 382 pages, and the issue was culling it down. The only note I have is that an intake screen from pages 135 through 138. I don't have any other, but I recall the defense at the time, after discussing, had abandoned attempting to move them into evidence. Whether or not she reviewed them or not, I think is fair game for cross-examination. Wasn't there some talk about that, like whether she could review those? Because I was going to send them to her. You remember, Judge? I was going to send them to her, and you made a ruling, so I said, I'm not. I'm going to stop sending them to her. And I think I showed you an email. I showed you a text message that I had sent to her. It's on my phone. Well, I said, do not review in bold and capital letters. Do not review the medical records. The court says, if you want to go back and look at your phone and see if you can find that, I just can't remember. Do not look or consider the jail medical records of Sarah Boone. Oh, okay, so that was the court. That was October 17th, 1:06 p.m. Mr. J says, I can't remember the difference between the discovery issue as far as it coming into evidence or what you reviewed. The court says, here's what I'm going to do. I'll give you the opportunity to go back and confirm what it is that she hasn't relied on, so you're not ending at a weird point. But I'll leave that to your discretion. I'll sustain the objection with regard to the Orange County jail record specifically. Mr. J says, all right. The court says, okay, thank you.
The objection is sustained in part and overruled in part.
You testified earlier in the normal course of practice of forensic psychology and psychiatry, you all do rely upon the diagnoses of other experts, correct?
You can inform my opinion, yes.
And you have not reviewed any electronic communications in the form of text regarding Ms. Boone's case, correct?
No, I did not.
Or recorded phone calls of any type, correct?
Well, 911.
Other than that.
No, other than that.
Now, let's talk about the February 23rd, 2020. She told you that they didn't really have anything going on to do that particular day, correct?
Yes.
It was a Sunday, correct?
Yes.
Sunday fun
Did
day.
some chores, and then as a reward, they could rest after doing those chores, correct?
Right.
Sense of accomplishment.
She indicated to you that she and Mr. Torres did not begin drinking till about 4 p.m., correct?
I'll have to reference.
Hey, Mandy.
Page 36 of your
Good to see you
deposition.
again.
Use that.
Great, thank you. 36?
Yes, ma'am.
All right, I'm with you. Around 4 p.m.
And you reviewed the crime scene photos of this case, correct?
I did.
That included receipts for some purchases that were made at Publix on February 22nd and 23rd, correct?
That's right.
And one of those receipts was a purchase for a 1.5 liter bottle of Woodbridge Chardonnay at 12:17 p.m. on February
I love how he classes it up a little bit of Woodbridge Chardonnay.
23rd, correct?
Yes.
Did you question her about the inconsistency of them having purchased a bottle of wine at 12:17 that afternoon and not start drinking until 4 p.m.?
No.
No, that seemed normal to me. And if you take that, it's obviously not true. They would have cracked it probably the minute it got home and set, like, I think the time between it being put on the counter and the top being popped, probably less time than it took for Sarah to count fake CPR to the 911 guy. Like less than 30 seconds. Even the first attempt, the 11 seconds, was just like, this is killing me.
And did she tell you that they had any wine left over from the day before that they consumed that day?
At some point, I'm not sure if it was the day that I was going through this line by line with you in my deposition, but I am aware, yes, that there was an unfinished bottle of wine from some other date.
And then, as the receipt showed, there was 2 additional bottles of 1.5 liters of wine purchased at 12:17 p.m. and about 5:30 p.m. on the 23rd, correct?
Right.
And were you aware of approximately how much Ms. Boone, the defendant, weighed at the time of this offense, February 23rd, 2020?
Around 100 pounds.
And in the first 413 pages of discovery, I believe, was the autopsy report, correct?
Right.
And so you're aware that Mr. Torres was 103 pounds at his death?
Yes.
Do you take into account this alcohol consumption when evaluating what Ms. Boone is telling you about the events of the day?
Yes.
Oh, please explain to us how you take this alcohol consumption into account. That would be fascinating, Miss Harper.
Did she tell you whether or not she was intoxicated by the amount of alcohol she consumed that day?
Intoxicated how? Did you have trouble with your balance? You mean from being tired? I mean from the alcohol. Did you have trouble with your balance?
Please silence your cell phone.
That's the first time I've heard the person say okay back.
You may proceed.
So she did not describe herself as.
I wonder, that might have been a juror because he didn't get as mad as he normally would get. That might have been a juror's cell phone and he just kind of, he's still not happy. But I'm going to go back a half second there because I think that was something.
Please silence your cell phone.
Going back 20 seconds.
All right, I'm with you. Around 4 p.m.
And you reviewed the crime scene photos of this case, correct?
I did.
That included receipts for some purchases that were made at Publix on February 22nd and 23rd, correct?
That's right.
And one of those receipts was a purchase for a 1.5 liter bottle of Woodbridge Chardonnay at 12:17 p.m. on February 23rd, correct?
Yes.
Did you question her about the inconsistency of them having purchased a bottle of wine at 12:17 that afternoon and not start drinking until 4 p.m.?
No.
What did I do? Did I miss it?
And did she tell you that they had any wine left over from the day before that they consumed that day?
About a half a bottle.
At some point, I'm not sure if it was the day that I was going through this line by line with you in my deposition, but I am aware, yes, that there was an unfinished bottle of wine from some other date.
And then
Some
as the
other
receipt
date.
showed there was 2 additional bottles of 1.5 liters of wine purchased at 12:17 p.m. and about 5:30 p.m. on the 23rd, correct?
Right.
And were you aware of approximately how much Ms. Boone, the defendant, weighed at the time of this offense, February 23rd, 2020?
Oh, I went back a lot. Sorry.
Around 100 pounds.
That's why I lost it.
And
Sorry.
in the first 413 pages of discovery, I believe, was the autopsy report, correct?
Right.
And so you're aware that Mr. Toro
I must have
was
gone back a
103
full
pounds at
minute.
his death?
Yes.
We're coming up to the cell phone moment.
Do you take into account this alcohol consumption
20
when
seconds from now.
evaluating what Ms. Boone is telling you about the events of the day?
Yes.
Did she tell you whether or not she was intoxicated by the amount of alcohol she consumed that day?
Please silence your cell phone.
If we were playing Name That Tune, that was a 2-chord. It was like an epic intro to a heavy metal song. Ba-da, ba-da. I wish I could guess it, but it's one of those songs that just opens with a double strum of a power chord, and then it's followed by the drum just keeping tick 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 tick. Ba-da, ba-da. Please silence your cell phone. Okay.
You may proceed.
So she did not describe herself as intoxicated originally when we discussed this. So
So the answer is no. She did not describe herself as
intoxicated, right?
These are all yes or no questions.
Hypothetically, if she had told the jury that she was intoxicated at the time of the offense, would that affect your evaluation of her credibility in the history she provided?
Your 3 guess was that Back in Black? Bam. Ba-da-da. Ba-da-da. Ba-da, 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 ba-da.
No, because that was also my opinion.
Did she indicate to you, in describing the events of February 23rd, 2020, that there was any point in time she just simply did not remember?
Yes.
And what points in time were those?
Probably about from the second drink onward.
So she did not remember taking the videos of the suitcase, or the incident in the suitcase, until she was at the...
Dorr points out that some states only sell alcohol after 12 p.m. on Sundays, and that would be why the receipt is for 12:17 and not before. Interesting point. For a long time in my province of British Columbia, Canada, there was no liquor sales on Sundays. And then cold beer and wine stores were allowed to sell it on Sundays, and then the liquor stores, which were selling the alcohol to the cold beer and wine stores, then they opened on Sundays, and the cold beer and wine stores were like, assholes. We opened up whole new stores because you guys weren't open on Sundays and we could make money selling beer.
interrogation room, I guess, and then they were going through them with her. Then she recalled that.
I'm talking about specifically with you. Did she indicate that there were any portions of the night that, or day or night, that she did not remember?
And this is kind of key.
I can't recall anything specifically right now.
Well,
Hypothetically, if she had indicated to the jury that she did not remember the 9 or 10 minutes immediately preceding the first video being taken, would that be inconsistent with what she told you then?
No.
Well, she didn't indicate to you that she forgot any part of the night, right?
Right, she just didn't say that, so.
Would it affect your evaluation?
she's being so evasive here again. He's like, you know, she said that she didn't remember taking the videos. Why are you telling me that there's, you know, oh no, she remembers everything perfectly. She's got mind like a steel trap.
Of what she told you about the events of February 23rd, 2020, if she hypothetically has testified that she did not remember 10 minutes before the videos?
Not really, no, because the event and the course of events that she narrated to me occurred over several hours. So when you interview somebody about circumstances of an offense, it's the usual for someone to not remember every single minute for hours at a time. I can't imagine that anybody's memory.
Okay, we have a request to roll it back a bit, so that's not me making a mistake. This time we're actually going to do it, but Kelly says roll it back a bit, and I think this is an interesting bit of testimony. So let's go. It says that we're at 6:58:20 in the overall video. 6:58:20. So let's go to 6:56:35. That'll give us about 2 minutes back on what's going on here. Okay, going into the Wayback Machine. Doodaloop, doodaloop, doodaloop.
So she did not remember taking the videos of the suitcase, or the incident in the suitcase. And
Maybe even a little further back here. Like, she remembers, but she just didn't remember that. But she didn't do that intentionally. She accidentally didn't remember, so I didn't include it. Back maybe 35 more seconds.
Please silence your cell phone.
Okay, we'll go back from the silence to cell phones. Let's all get ourselves back in our
You may
bearings.
proceed.
so she did not describe herself as intoxicated originally when we discussed this. So
So the answer is no. She did not describe herself as
intoxicated, right?
Hypothetically, if she had told the jury that she was intoxicated at the time of the offense, would that affect your evaluation of her credibility in the history she provided you?
No, because that was also my opinion.
Did she indicate to you, in describing the events of February 23rd, 2020, that there was any point in time she just simply did not remember?
Yes.
What points in time were those?
So she did not remember taking the videos of the the suitcase, or the incident in the suitcase, until she was at the interrogation room, I guess, and then they were going through them with her. Then she recalled that.
I'm talking about specifically with you. Did she indicate that there were any portions of the night that, or day or night, that she did not remember?
I can't recall anything specifically right now.
Hypothetically, if she had indicated to the jury that she did not remember the 9 or 10 minutes immediately preceding the first video being taken, would that be inconsistent with what she told you then?
No.
Well, she didn't indicate to you that she forgot any part of the night, right?
Right, she just didn't say that, so.
Would it affect your evaluation of what she told you about the events of February 23rd, 2020, if she hypothetically has testified that she did not remember 10 minutes before the videos?
Not really, no, because the event and the course of events that she narrated to me occurred over several hours. So when you interview somebody about circumstances of an offense, it's the usual for someone to not remember every single minute for hours at a time. I can't imagine that anybody's memory could hold that much unless they have like photographic memory or something.
I'm not asking.
And let's keep in mind the fact that Julie Harper didn't come to the case at the end. She's met with Sarah multiple times. I think 9 was the number that she testified to. I believe her first contact with Sarah was in June of 2020, which means Sarah would not have needed a photographic memory to recall the events. She was immediately put into custody following the events and probably ostensibly was replaying the events in her head every night because she couldn't go to bed and she'd climb underneath her bunk to sleep, writing letters to the Torres family for forgiveness that she didn't send. So it suggests to me that if she remembered the point of time between the photograph and the videos, or forgot it, in either case, she wouldn't have needed a photographic memory, and that's a pretty key point of the night.
About hours and hours, an itemization of her day's events. We're talking about the 20 minutes of the offense. Does that affect the weight that you give her history she provided you? Just yes or no?
No.
Now, what she indicated to you was the day had been going well. It was fun and games, correct?
Yes.
Conflict-free?
To her, she said it was a good day. So
Okay.
That's what she told me.
She said it was a good day.
Yes.
Because she survived.
And there comes a point in time where the activities turn toward hide and seek, correct?
Yes.
And she goes up to the shower,
Right.
Right.
and when she comes down from the shower, that's when Mr. Torres is in this suitcase, correct?
Getting into it.
Yeah.
And she
George
goes
got
over
in the
the
suitcase.
and zips it, correct?
Yes.
And did she describe whether it was 100% zipped to you or just a certain percentage?
She said that it wasn't zipped all the way.
Okay. And still then, that was funny to the two of them at first, correct?
That's right.
And then there came a point in time where Mr. Torres was getting mad about being zipped in the suitcase.
She told me that he was getting mad. Yes.
And that, in turn, made her mad.
That's right.
Right. George triggered Sarah by saying, "Sarah, I can't breathe." That was their first attempt at an overt act. But then it was like, oh no, that's not enough. You actually weren't in danger from his words. Oh, well, his hand came out and that threatened me. I knew because it was a broken suitcase that he would be able to break out of the suitcase because it was a broken suitcase. So I went upstairs and waited for him to have sex with me.
What Mr. Torres was saying was, I can't breathe, correct?
That is what's recorded on the video.
Well, I'm asking you about what you reported her saying.
Well, what made her mad was not that he was saying he couldn't breathe. It's what he was saying that was making her mad.
Well, what else was he saying?
At the time, she said that he said something.
Great question. What else was he saying? Because besides I can't breathe, the only thing he was saying was Sarah. Sarah. Babe. Sarah.
Something that was making her mad. And so that's the extent of what we talked about at that moment.
So you didn't elaborate what something was that made her mad, correct?
Right. She said he said something that made her mad, and that started making her mad.
And it wasn't I can't breathe. So it was the sound of her own name. That's my name. Don't wear it out. I told you not to wear it out.
You didn't find it important to learn what specifically he said that made her mad, correct?
I don't agree that I didn't find it important.
I agree. I think that you didn't find it important.
Okay. Then explain. Why wouldn't you ask that question?
Correct me.
Because as a person who is traumatized is describing their experience, as a trained clinician, you will allow open-ended discussion
Are you her therapist or are you an expert witness?
of that experience. And so it's not an interrogation. You don't go asking confrontational questions at the time of their first narration.
Well, you had 9 visits with her. Did you follow up on your 9th visit?
I asked her different questions about
Did you ever ask
be
her?
confrontational.
Did you ever ask her specifically in any of your 9 visits with her what it was that he said that made her mad?
No.
She never described him doing anything to make her mad, but it was words, correct?
Right.
For people who've had enough of Julie
Once she got
Harper,
mad, she decided
she's off the
that
stand
she
in
was
10
going to
minutes.
leave him in there for 2 minutes.
That's right.
Not 3, not 1, but 2, correct?
That's what she said.
And the reason she was doing that was because she wanted him to understand how it feels to be choked and what she had experienced.
That's right.
You know, just let him squirm a little. 5 minutes. 5 minutes for what?
Did you ask her why she didn't let him out of the suitcase after 2 minutes?
Yes, I did actually ask her that.
And what did she say?
Well, she thought that he could get out himself. That's one thing. She said that when she was able to unzip it, it was not some significant thing. She was able to unzip it easily. So she said it never occurred to her that he couldn't get out.
That's an outside the court interruption. Court says you may proceed.
And you reviewed the still photograph of the suitcase as well as the 2 videos.
Right.
And did you understand what the metadata or what the timestamps were for each of those items?
I'm
Speaking
sure
of
when I review.
speaking of metadata and timestamps, very timely. Kim Stole My Fish Soap says, Brian put money in Sarah's account at 11:56 a.m. She thanked him at 12:01 p.m. and then was in the Publix checkout line at 12:16. Poor Brian paid for the wine and the bat that were part of Sarah's crime.
I saw the timestamp. Yeah,
Would you agree that 20 minutes is 10 times as long as 2 minutes?
I would.
Thanks for coming, Peter.
And if Mr. Torres had not been able to get
Check check out the playlist, Peter. If you're just joining for the first time on the Dan D Watches, I have a whole Sarah Boone rewatch show playlist where you can. We started with Frank Bankowitz and moved forward from there because that was the earliest footage I could find. But yeah, there's a whole library. Welcome to the Fine and Dandies. Look forward to seeing you in the future. And for anyone else that's just joining the stream, we only have about 10 minutes left of Dr. Julie Harper. Then we move on to Dr. Tanya Werner and her open disdain for James Owens, which is a lot of fun in retrospect. A little frustrating in the moment because he wasn't letting her testify. But now that we know the results, it's a lot more fun to see her sparring with him.
herself out of the suitcase within 20 minutes. She didn't indicate that she let him out, correct?
She did not.
She described to you, Ms. Boone being the she, that she was helpful to the police.
Yes.
Do you agree with that assessment that she was helpful to the police?
In the sense that
She wasn't fighting. She wasn't kicking and screaming. Like, she did everything she had to do to get into the big bay. So, no, I'd say she was helpful. It appears from this screenshot. It's like Mrs. Harper, Dr. Harper. It's like, where'd my chin go?
she was having conversations with them without counsel, I would consider that helpful to the police.
Do you think lying to the police is helpful to the police's investigation?
No.
Do you
Because she did a lot of that.
agree that she was not truthful with them?
Yes, I think that I would agree with that.
And when she described getting Mr. Torres out of the suitcase, she described stretching his little legs,
Yes.
and she stated to you there was no fight that day, correct?
That's right.
Just wanted him to be uncomfortable.
I need to clarify. Physical fight.
Right.
Yes.
Just wanted him to be uncomfortable,
Yes.
correct? And then there was a description of a bat and her using it to nudge, right?
Poke.
Poke. And so,
That's one of the weirdest words. Like, in all my years of using a bat, I've never used it to poke. I've swung a bat. I've hit with a bat. You know, you even do like the hands on both outsides. You can use it like a hockey stick and cross check with a bat. But when you're using a bat as a weapon, poking is, well, it's the kind of thing you do with a curtain rod, not a bat.
do we agree that that means like poking out like this as opposed to swinging it like you're a baseball hitter?
I would agree with you.
And you reviewed the autopsy report, correct?
I believe so.
Did you get an opportunity to review the autopsy photos?
Yes.
Did you question her when she said that she only poked him with the bat?
No.
Not in any of your 9 visits?
Did I question her about whether, can you just repeat the question? I want to make sure I'm answering it correctly.
Yes, ma'am.
Okay.
Fine. Did you ever, in considering the autopsy report and the autopsy photographs that you reviewed,
Yes.
when she said that she nudged or poked with the baseball bat, did you ever question her about that, given the severity of his injuries?
So to answer correctly, I did question her
What did she say?
about how she used the bat.
Okay.
And she reiterated that she poked and she gestured what she meant. So I did question her about that.
And did you have any questions about that history she relayed to you, given the other evidence in this case that you reviewed?
Just in contrast to the interrogation video. So that,
It didn't contrast to the autopsy photographs or report?
Judge, I object.
Roach.
Legal grounds for the objection? Judge, she's a forensic psychologist. She's not a pathologist. Well, she can reconstruct. Well, the injuries here are consistent with a bat being poked versus a bat being swirled. That's what he's asking, huh? I'll move on. I've got another question. All right, fair enough.
You may proceed.
Did she indicate all this nudging or poking with the bat was done while he was inside the suitcase?
yes.
She never told you that there was any nudging or poking with the bat when he was outside of the suitcase?
Correct.
She indicated that she ended up flipping the suitcase over face down.
That's right.
I didn't want him to be like that.
Did she tell you about Mr. Torres calling his brother earlier that evening?
No.
Did she ever give you a history about a loud boom occurring inside of her townhouse that evening?
No.
And you never had the opportunity, obviously, to interview Mr. Torres about these things, correct?
Of course not, no.
No other questions?
Of course not, no.
Any redirect examination?
Briefly, Judge.
Yes, sir.
The state attorney talked to you about power and control, that an abusive partner will use power and control over the victim in a intimate partner violence situation.
Yes.
Tell us about power and
Threatening
control.
someone's dogs, is that an example of someone using control?
Threatening somebody's dogs. Although there's no evidence of that on the record. I don't know why they keep bringing it up. Just an emotional thing, like, oh, he kicked dogs.
Control?
Yes.
Taking car keys from the other party, is that an example of control?
And this may be what we get into with the Jamie Komorowski if I end up doing that for tonight's ramble. Every indication that he would have been taking her keys because she was too fucking drunk to drive. And who knows if George didn't both save Sarah's life by taking the keys away from her when they were getting pissed drunk at Muldoon's, because it's easier to walk home from there. Or, you know, at least prevented her from getting a DUI or something sooner. So I think there's all kinds of reasons why George would take the keys quite reasonably from a pissed drunk Sarah.
If they're withholding, yes.
Taking a phone and withholding a phone,
Yes.
a debit card?
Yes.
Sarah controlled the phone. Sarah controlled the debit card. My card. It's his money, but it's my card. He has it.
Destroying a home, TVs, putting holes in the wall?
Yes.
That's again not facts that are in evidence. There is a destroyed TV. There's no evidence that George broke the TV initially.
Not helping pay the rent and other bills?
Not helping pay the rent or other bills. Sarah did not have the income to pay the bills on her own, so there's no way that they would have still had an active tenancy at 4748 Friends if George had not been helping pay the bills. Well, George or Brian. Brian was already paying $1,000 a month, but her rent was $11.60 a month. And given that it's about $10 for a bottle of Woodbridge, and she needs, 2.5 of those to get through a day, it's 20 times 20, so it's $400 in Woodbridge. $15.60 a month is what her main expenses are, and that's before hot water for son.
So I would say that that could be withholding, that could go under coercive control of another person.
What about violating a court order to have no
Kitten Pusher brings up a great point, and I'm going to always recommend this. So anybody who comes into the live chat, the live experience is there's three things that Dan D Court Rewatch shows are. If you're lucky enough to be here for the live, it's for the community, it's for the live chat. This will all be recorded. This will be here forever. So enjoy your friends, enjoy the conversation. There's a lot of stuff that comes up in chat that I'll see when I'm doing rewatch, sometimes just for tech issues to see, how did it sound when I transition from this to this. But I always have the live chat replay active, and you guys are hilarious in the chat. You guys have a great time. It adds so much extra context to the show, and that brings us to number 2. If you're on the live chat replay, that's when to pick up the stuff you missed when you were chatting, but it's the stuff in the chat you missed. Don't even worry about the content. You'll pick that up on the third pass. Second time, watch with the live chat replay on. Follow all the conversations that you were missing out on because you're in your own little conversations. Then the third time through, that's when you pay attention to the content, and then you'll be like, "Oh my God, I didn't even notice that." And, I've watched this 3 times. You said something super funny here and I was all into my chat. So anyway, each stream, you can enjoy it 3 times. If you happen to come in late, like Kitten Pusher has today, I recommend stick with us in live and then go back, watch what you want to on your own time. In your own time, you can rewind, you can fast forward, you can enjoy it again and again and again. Excuse me, I have to burp.
contact with the person?
Yes.
That's all the questions.
Thank you. Can this witness be released?
As far as the state is concerned, thank you.
Mr. Owens? Thank you, Doctor.
Goodbye, Julie Harper.
Collect all your stuff, ma'am. No worries. No apologies necessary.
I think this is going to be where they rest the case here. I think we've got some interesting sidebar material as well, but that is the end of Dr. Julie Harper's testimony. So, congratulations for making it this far. Yes, that's another great point. So if you're watching on replay, throw on the live chat replay. I don't edit these, and, partially it's laziness. Like, it's extra work, and all it does is take away a big chunk of what makes these watches so fun. If you edit the replay, the live chat goes, because I guess it can't sync up with the time of the video anymore. So I don't edit it. I leave it up there. I try and be transparent about, hey, it doesn't really start for 5 minutes or 10 minutes or whatever it is. But if you're watching it alone, you can watch with the live chat replay. And, sometimes stuff that becomes an inside joke 3 or 4 episodes later, you can see where it developed in the chat on the one you're watching. So I noticed that when I was in a lot of Suma's chats early, the chat was fast and furious, and, I was having a great time. But it wasn't until the second time I was able to appreciate all the conversations, and the third time that I really appreciated the content that Suma was putting out. So I did like it on the first pass and the second pass, but the third time I was really able to focus on the content. But I think the thing that makes this community so great is the community. So, take that at every opportunity. And if you have a chance to chat live, chat live. Watch the past in the past, or futuristically. Oh, and Amy, Zeitgeist, how to do that. So let's say you're watching on your phone. That's one way I know how to do it. When you go down to comments, there's usually 3 dots at the top of the comments section. If you slide over one, it'll be like, be the first to hype. You slide over one more and it'll say live chat replay. And you can click into there. You can't chat with us, obviously, because it's a recorded live chat replay. But that brings it up. It does take anywhere from 12 to 24 hours after the live goes offline for the live chat replay to become part of it. So you don't get it right away. It's the same thing with hype. You actually don't get the hype button until it's been fully processed. But anything, like if you're looking at last week's or anything that's, more than a couple of days old, it's going to have the live chat replay as a viewable part of the experience. And you just get to watch it scroll along the sidebar while you're watching your video or in the comments or whatever. If you're watching on like a laptop or computer, then it's even easier. You just have to click it down in the bottom, like in the description area, and it'll put it up on the sidebar and just track right along with the video. And it's crazy because when you're watching it, it's super easy. But when you're chatting, it seems like it's going so fast, like you can't keep up with half the conversations. It's because your own brain is thinking about what you're saying, processing replies. On the second view, it's so much more casual. It's like, oh, this is just a fun conversation. It's like sitting in a coffee shop and being able to be a fly on the wall of every table. And everyone's talking Sarah Boone. It's great. Lots of courtroom sounds. I imagine something's going to happen. Let's see if the transcript can give us a clue while we're waiting here. Threatening someone's dog's phone. Okay, thank you, doctor. Collect your stuff. No apologies.
Yes.
Oh, here it is. So he just asked to approach the bench, which means the jury's here. The court says, yes, sir. Mr. Owens says, we got some... We don't have any more witnesses left. We got some arguments to make about introducing a court record, taking judicial notice as it relates to the last question, and how George Torres violated a no-contact order. Got it? I think that probably should be made outside the presence of the jury. I agree with that. Okay. So here's what we're going to do. It's 4 o'clock. Let's just go ahead, take that afternoon break at this point in time. We can address that after we have our comfort break, and then we can address that, and you can rest in the presence of the jury if you don't have anything else. Okay, thank you.
All right, members of the jury, it is 4:01. At this point in time, we're going to go ahead and take that afternoon break. I got a couple things I got to address with counsel as well, so maybe a little bit longer, but we'll bring you back in as promptly as possible. Again, same instruction I've given you before. Please don't conduct any independent investigation or research as to the person, places, things, or charge involved in this case, and do not have any conversations amongst yourselves or anyone else about that. And we'll bring you back in as promptly as possible. Thank you.
All right.
All right. All right, and then I think this is open court for a couple more seconds before they take a 15-minute break. When they return...
Y'all can be seated.
Okay, there's 2 orders.
Let's go ahead and take a recess, a comfort break for any of us, and then we can address any argument with regard to the any other evidence that the defense may be seeking. Let's come back here in about 10 minutes, so 4:13.
Okay, I have to take
All right,
my
thank
own
you. We'll be in
break.
a short recess.
So I'll take advantage of this. I'm going to even tell my streaming software to set up an ad break here. I don't use this very often, but let's see. Insert ad. Take a break. Okay, I'm setting it up as a 3-minute break. I'll be back before that. And, you know, if you guys are in the chat, you guys know that it's going to be 3 minutes before any real content. But, yeah, and then we'll be back with the motions and then Dr. Tanya Werner for the second half of the stream. All right. So the seal from the great state of Florida. On time. $50 seconds remaining in the break. Probably put on a little music. Thank you, Sharon Touch. I hope you have a great day. Your trip to the post office goes just fine. Fine and dandy, in fact. Thank you for joining us for the first half of this stream, and for all of you sticking around for the second half of this stream. We'll be getting it going in less than, well, we're getting it going right the F now. We don't need to wait. That's what people who do live court watches do. We don't wait. That said, we do take extra time for pauses and sidebars. So, but that said, so all the time that you normally spend waiting watching a trial, that's the same time that you get back in commentary and what? What else am I offering? Commentary and sidebars. See, classified crime getting a shout out in the chat. See, Tanika's 2 cents. YouTuber Tanika, always top of mind.
All right, we're back on the record. Case number 2020, CF 2603, State of Florida versus Sarah Boone. Appearances for the state.
Dave Castor on behalf of the state. William J.
Defense.
James Owens for the defense.
Tony Henderson for Sarah Boone. Kevin Beck for Sarah Boone.
All right. Ms. Boone is seated at counsel's table wearing the same dark gray suit and maroon blouse from this morning. Mr. Owens, are there any other matters we need to address before you rest in the presence of our jury?
Yes.
Yes, sir.
Yes.
Yes, sir.
He just stands up and waits. Please speak, Mr. Henderson.
Yes, Judge, there's 2 orders that I'm going to be requesting the court to take judicial notice of under 90.202 sub 6, and the orders of no contact. I have copies of the certified copies of the orders. May I approach?
Yes. State, have you seen them?
Doesn't change my position.
Understand, but you have seen them.
I have not.
You have not seen them.
I have
Okay.
not.
Doesn't change my position.
Understood. Okay. You can bring them on up. Thank you, sir. Court has been provided no contact orders issued in case number 2019 MM5062 on or about June 16, 2019, and a no contact order in case number 2019 MM5114 issued on or about June 19, 2019. Both cases styled State of Florida versus Torres George Jr. Let me hear any argument as to the judicial notice from you, Mr. Henderson.
Judge, I think they're relevant. I think just from the testimony of Director Dr. Harper, saying that an element of control is talked about greatly by the state when I point out things hypothetically that they refer to. They refer to them as hypothetical.
Allison, the DNA doc, says your t-shirt should say global YouTuber at work with a bloody keyboard below it. Now, how much would that piss Sarah off? That said, I think I'm like a, junior varsity. I'm not quite global YouTuber yet. I've got what it takes. I'm on the way up, but this point I'm, Division 2 YouTuber at work.
However, they refer to things that they're developing on this boom. These show that they were in fact orders, and the orders were for no.
So if you can't hear Mr. Henderson, I do have the captions on. This is a waste of time. They're just introducing the fact that there's records of the fact that George Torres violated some no contact orders. If you're not fully familiar with all the nitty-gritty details of the case, Sarah was setting up a documentation tree by first setting up a no contact order with the person that was sharing a lease and had a legal right to be in the place she was, they were cohabitating. She would call the police on him and then have him removed so that she could build up a documentation record and then have him be beholden to her as, hey, George, do what I say or I'll call the cops right now and you can spend another night in prison. I'll put the fear of the police into you.
Contact. So these are elements control.
Oh, Amy,
In relation to.
please.
George Torres.
correct me. On which point do you respectfully disagree? And if it's a interesting, respectful discussion, we should elaborate on that. But I don't know what I said.
Okay. Response.
So in regards to
Oh.
the judicial notice,
You might be respectfully disagreeing with my contention that I am not a global YouTuber at this point. I suppose there is some argument for that. But in which case, I don't want to argue against the argument that I'm doing well. So I'll just take it as a compliment. Thank you.
aspect, we don't dispute that can be a substitute for authenticity.
Perfect. Yeah. Amy Zeitgeist, I will say that by saying I'm Division 2, it's no slag at all. I think that the junior colleges, I think some of those D2 schools, they're the opportunity for people that haven't been handed life on a silver platter, that, you know, have had to work for everything. You prove yourself by going to a D2 school and, you know, working so hard that the kids that have everything handed to them and, you know, start as a freshman in, you know, a prestigious school, whatever the discipline that they're taking, they have everything handed to them and they're dropped out by, you know, 6 months into their scholarship. You have a guy that, you know, has a 2-year track record of working themselves up, pulling themselves up from the bootstraps, doing the work, getting the results on the field, all of that. There's a lot of very prestigious colleges that would love to have a Division II athlete that, you know, has proven themselves, as opposed to a walk-on freshman that has all the potential but all kinds of drawbacks too. So, hey, the Heisel Swiss Miss is here. Switzerland, welcome. You've joined us at a great time because Dr. Harper has just left the stand. Thank you for joining the chat, the Heisel. We've got the Swiss Miss in the chat.
However, they're not relevant, they're not admissible. They contain statements that were made by...
And Margaret Adam testifies that I'm in Scotland. So, oh, no, I'm not. Okay, never mind. I tried to do an accent and it just came off bad. I'm trying to channel some groundskeeper Willie, but that's probably pretty cartoonish as well. In any case, I'll just thank you for supporting from Scotland. Thank you.
We're not testifying. Just because an expert relies on something doesn't mean that it's admissible. What happened during redirect with Mr. Owens was he was asking, what are the hypothetical things that we
Between famous and not famous, exactly, almost famous.
rely upon in making these determinations as an expert about whether there's battered.
I've used up about 6 to 7 minutes of my 15 minutes of fame, so this could be the remainder being used up on the Dandy True Crime retirement package.
Or not. So one of the many inadmissible things that he mentioned was pretrial orders of no contact. So it's fine. The expert can certainly rely on the fact that there may have been pretrial contact orders or no contact orders that were involved in this case, and she considered that. That doesn't make them admissible. There has been testimony, I believe, from Ms. Moon that there was pretrial no contact orders and violations of them. It's not a fact in dispute. It's just that's
Okay, God damn it. I'm a global YouTuber. I'm one of them. You've convinced me. I'm not above being corrected when I'm wrong, and it seems I'm wrong. All the evidence points to the fact I am a global YouTuber. Scratching it up at the top. I'll get one of those like my name is stickers and just put it up here. Global, till I can afford new shirts.
doesn't mean that the paperwork comes in as evidence. So that's our objection, is it's irrelevant and hearsay. Just because an expert relies on inadmissible evidence doesn't make it admissible.
What's your response to hearsay?
Judge, I think under the, as to hearsay, I think the statute takes care of that itself, because it says that the court can take judicial notice. So that's the foundationary part. And it's not hearsay, it's an order of the court. We're in a case where we've gotten in evidence of past domestic abuse. There was evidence of it, started with the state, about control. And these are things of control.
Ramono makes a great point and says to Phil for Dom Russo, Sarah worked so hard for the cell wop, and Kraynick rewarded her. Exactly. She could have easily taken any of the plea offers before. But even if she just did a simple, even a Corey Richins style defense, where the state presents its awful case, and then Sarah shuts the fuck up, they present no defense, and just let the evidence speak for itself, I think the jury gives her, okay, you're guilty. It's second-degree murder. 22.5 is what I'm supposed to give for it. Well, you didn't say anything to piss me off. I guess we'll give you 22.5. She could have even gotten that just by shutting the fuck up.
And I'm sure the state's going to, in rebuttal, they're going to come up with things that they feel either by body cam or any other evidence that shows her exercising control. This shows Mr. Torres exercising control. It is very relevant.
But how's it not hearsay? Just because it's a court record, it's still out of court statement. It's certainly being offered for the truth of the matter asserted. No contact order.
It's certainly relevant. Yeah, but how's it not hearsay? That's a good point, Your Honor.
Judge, that's why we have the thing that the court could take judicial notice of. There are certain things that court...
But the case law says you can't utilize judicial notice to get around hearsay.
Kraynick.
I know 9202 says that I may take judicial notice.
Yes.
9203 says that upon sufficient notice being provided, which the state is conceding based on their argument, the court shall take judicial notice of items identified in 9202. But my question is, the case law, as identified in Professor Earhart's treatise, specifically says in Dufour v. State, 69 7th 3rd, 235, which specifically talks about notice of judicial documents in a court file, that doesn't get you around hearsay. So what's your response?
Let me go through hearsay in my mind again.
You're fine. Take your time.
Let me go through hearsay in my mind again. He's just mentally refreshing himself on what hearsay is. Oh, that's great. None of his colleagues helping him out? Or is he having her look it up? He's having his daughter look it up. Dad, hearsay. It's like when someone else says something and then the other person testifies to it. Really? Is that simple? Yeah. No, Dad, I just learned it. I passed the bar. I know all this. Okay, but if I'm going to say this in court, it better be right.
Judge?
Yes.
I'll start this way first. One of the exceptions to the hearsay rule is business records exception. So if it's a business record and it's kept in a normal course of business, then someone can come in and lay the foundational things for the business record exceptions to the hearsay rule.
Okay, an example of that is early in the trial when they had Kayla Rodriguez on the stand. They were talking about body cams, and Mr. J says, and you record, or these get downloaded at the end of the business day, and these are constantly used in the course of normal business. So Mr. J gave an excellent example of how hearsay type evidence can be admitted as evidence because it's coming from an undisputed source, such as a body cam.
However, in this case, that would not be needed if the court takes judicial notice of it. That eliminates the necessity to do a business record in that fashion.
Do you think Henderson's daughter has the same accent Candace asks? If she does, I don't think I would do the same accent. There's no way she's as deep and gravelly. When I'm trying to separate the two accents of the more southern judge or southern members of the Owens team, I try and do Owens with lots of highs and lows. But Henderson just kind of drones on like a two-handed saw going through a piece of wood, back and forth, without ever taking any pauses.
Foundation, because the court, under the statute 90.2026, can take judicial notice of court orders. This is a court order, it's certified. I think it's an exception to the hearsay rule. Also, I think the probative value of these documents outweighs any prejudicial effect.
Any other argument?
No, Your Honor.
Any other argument state?
The fact that there was a pretrial court order of no contact between them is going to come in. I mean, on one of the body-worn cameras, Mr. Torres is like, well, you know, the court said I couldn't, but she said I could come. And I believe she testified to that during her examination. My objection is to the paper and the grounds that I've argued.
Okay, all right, thank you very much. State v. Mobley, 98 Southern 3rd, 124 by the Florida 5th District Court of Appeal, cited in 2012, says that there's a procedure that specifically needs to be followed for judicial notice, as set forth in 9202 and 9203. State is conceding that although there's not a writing, they're not objecting to the judicial notice concept. They're objecting to the evidentiary bases. I do find that it is relevant, but the problem is I have with hearsay. And the court, in relying on the Florida Supreme Court decision in Dufour, D-U-F-O-U-R v. State, 69 Southern 3rd, 235 at pinpoint 253 by the Florida Supreme Court in 2011, which states, while the court may take judicial notice of documents in a court file which were properly placed there, this notice would not make the contents of the documents admissible if they were subject to challenge, such as when a document is protected by privilege or constitutes hearsay. It is an out-of-court statement that is being offered for the truth, to wit, it is a no-contact order, and the requisite requirements for a business record under 98036 subsection A have not been met, nor has there been a certificate from the custodian of records as to those things, as required by section 6, paragraph C, and the timeliness of a certification. So I cannot accept judicial notice of these two documents, even though the state is not conceding the procedure for judicial notice. I am sustaining the state's objection as to hearsay under the grounds and the exceptions that you have offered.
Okay, so right now, James Owens, I think, is speaking, but without the mic on. So I'm going to do the same thing as I normally do for sidebars, is just speak for him. You can follow along on the transcript, but he is continuing the argument here. Judge, we do have the clerk of court subpoenaed. I don't know where they are.
Court subpoenaed.
Oh, okay. Never mind.
I don't know where they are. I assume they're somewhere in this building.
Assume there's someone in the building.
I believe they sent some message to us back before the hurricane.
Sent some message to us back before the hurricane.
We said to be continued, so we haven't gotten back up with it.
We haven't gotten back up with them yet. So it'll take us
It
to...
would take me some time to check on that. It's 4:30.
Was the subpoena still for this time period?
Yes, I believe it was a 3-week period,
Okay,
but we haven't followed back up with them. This came up
sure.
late.
I'll give you an opportunity to do that.
I don't know whether you could just go ahead and send them to home for the evening, and let me see if we could find the clerk maybe in the morning, and then we could rest in the morning, and then the state has Dr. Werner. It's probably going to take me a little bit to
Yeah,
find.
I'll give you that opportunity, absolutely.
Right now?
If you want to, sure. If you want to try to do it now or do it tomorrow, I'll leave it to you. Because I can't imagine it would take long if we're able to get a records custodian or a person to lay the foundation. I can't imagine it would take that long.
Aren't they in the building?
Yes. Third floor.
Aren't they in the building? Yeah, third floor. Immediately turns around to the glam squad. Take a break from thinking about how to pretty up Sarah and run down to the clerk's office for me.
Sure.
I suggest we go ahead and let the jury go. It's 4:30.
Okay.
I don't know how long it's going to take them to do that, but we could present that in the morning and then rest in the morning, and then they could.
All right, that works for me.
I'm not going to make some poor employee come in and do that.
Oh, Mr. J. Judge, I'm not going to make some poor employee come in and do that.
I was conceding the authenticity. I don't understand the relevance of it coming in.
Are you now withdrawing your hearsay objection?
What a sport.
Well, I still believe it's hearsay, but I think it's cured by it's public record and it's stamped and all that stuff.
I know, but no one's made that argument yet.
Yeah, I'm just helping out the defense and letting them know that it's a public record and it's stamped and they can use that instead of making some poor employee come and testify.
I don't want to punish some poor clerk.
Okay.
I won't object to them coming in, but it's a slippery slope for other records. We'll see what we do with what.
What a good
Okay.
guy.
All right. So the state is still maintaining its hearsay objection. I do find that it is relevant.
I don't make the clerk come
So then what do you want to do, Mr. J?
in. I'm stipulating to, if the hang-up for the court and the defendant is that they believe a clerk of the court needs to come in and testify, I'm conceding that issue so that person does not have to do whatever that issue is.
Okay. All right. Fine. Then based on the court, on the concession by the defense, by the state, excuse me, do you have any other objections with regard to these two non?
Judge, do what you're going to do, but don't confuse me with that shit show over there. Please. You can make all your own decisions, but don't confuse me with the defense. I ask you humbly.
Contact orders? Mr. J?
No more objections.
Okay. For the reasons previously articulated,
So that's a classy move by Mr. J. It kind of reflects, being able to see things from a 40,000-foot view and realizing that whether this comes in or it doesn't, or that he fights it tooth and nail to, the clerk comes in, testifies to it, and it comes in. He's not any further ahead or behind by fighting it. So I think this is a good move on his part. And it's only going to endear him to the judge who is getting sick of the Owens team's time wasting.
and it's relevant. The state has withdrawn its hearsay objection. Do you want these as a composite or individual?
Individually.
Okay. Madam Clerk, could you pre-mark them, and then we'll identify them, please?
Oh, FSU. This is the kind of research I do for you guys. I went a little, deep dive, looked up the Florida State Seminoles and what their record was in 2024, just to see, if Judge Kraynick's in a good mood, bad mood coming into court. 2024 was one of the worst seasons for the Florida State Seminoles on record. They only won 2 games. At this point of the trial, they were 1-5 for the season, and they were headed into a weekend game versus their rivals, Miami, University of Miami, the Hurricanes, and they got blown out by them. Only one more win the rest of the season. So tough season for Florida State, and not putting Judge Kraynick in a good mood for Owens shenanigans, I'm sure. Okay, so there's the no contact order that's going to come in. Mr. Owens gets asked to approach again for housekeeping issues. Why would he be approaching if the jury's not there?
The no contact order in 2019 MM 5062, dated June 16, 2019, has been pre-marked as AB. And the no contact order in 19 MM 5114, dated June 19th, 2019, is dated as AC. Mr. Owens, you can approach. Let's just tackle a couple other housekeeping matters that we have. You can move those in. when our jury returns into evidence, are there any other witnesses, evidence, or testimony, sir, that you're going to be offering this afternoon?
I don't believe so, but we're intending on resting either this afternoon or first thing in the morning, but we want some time to talk to Sarah Boone and explain to her, you know, why we think we should rest, not call any further witnesses, not introduce any other exhibits, just to make sure that we're all...
Oh yeah, she's not gonna like, okay, we're gonna rest now, Sarah. No, I don't rest. Why didn't you bring up this? Why didn't you test the curtain rod? Why haven't you brought up the fact that George's brother stabbed his wife in the head with a knife?
All on the same page with her about what our strategy is, so we need a little bit of time. I don't know if you want to go ahead and excuse the jury for the night and then have us come back in the morning.
I don't know if you're going to want to excuse the jury for the night, but we're going to need a lot of time to get Ms. Boone over the hump of resting her defense.
And do that colloquy with the court, with the defendant, but we do need some time with her.
Hey, Vel 73.
All right.
Vel 73, we're right at the end of Dr. Julie Harper's testimony, and we're headed into Tanya Werner's testimony. So if you want to stick with us live, the Tanya Werner testimony will probably be about 3 more hours of this stream. I guess we're going longer than I expected. I didn't think these two were going to take this long, but there's a lot of stuff to discuss. In any case, stick around with us live if you're here, Vel 73, and then there's a lot of fun to be had on the rewatch show, watching everything we went through this morning.
So then here's what we'll do. I'll bring in the jury and I'll excuse them. You can save those pieces of paper and you can move them into evidence tomorrow morning and then present. That'll work. Thank you, Madam Clerk. We'll bring the jury back at 9 a.m. tomorrow, and you can continue with your evidence presentation at that time, including but not limited to calling any additional witnesses. Court can have any further colloquy with the defense at that time. The state then can put on its rebuttal case. The state, how long do you anticipate ballparking it for the court, your rebuttal case?
I don't believe Dr. Werner will take long on our part.
But we anticipate that the Owens team are going to be fucking jerks, and it's going to take a long time before we get through her on their part. Spoiler alert.
I'm not sure how long it'll take on their part. And then there's about...
How long is that for your part?
I'm not going to hold you to it, Mr. J.
Probably less than 30.
How long do you anticipate your cross being? And ballpark it. Again, I won't hold you to it.
If his direct is 30, my cross is from...
Oh, no, another one to say. This isn't where they try and talk her out of testifying. She's already testified. That was day 3 of the trial. But they did have a significant colloquy with her regarding the benefits and negative aspects of testifying at a trial on your own defense. This is going to be basically the same thing, but because the defense wants to rest and Owens is explicitly asking on the court record for time to explain to his client what that entails and why that's the strategy. The great thing about that is it's on the record. It's, you know, so even we know what her appeal arguments are and that isn't one of them, but it helps Judge Kraynick that Owens is making these pleas like, we just have little time to explain to our client why we're going to rest our defense. Because think of like a Darrell Brooks, if he's given the opportunity to rest his defense or keep talking, what's he going to choose? And Sarah kind of got painted into a corner of having to rest her defense because I'm sure there's a lot of stuff that she's still upset didn't get brought up. All the stuff at her sentencing that she's like, this didn't come out in the court. But regardless, she was convinced to rest the case.
Okay, what else do you have to present?
And then there will be about 2 hours of videos from body-worn camera and from the phone extraction. And then reading...
Phil for Dom Russo, he very well probably did read the professional fuck you with its not the tip of the iceberg, but the full iceberg, because it is a court document. It's on the record. It's ex parte communication that, you know, I'm able to get through the public records. So I would assume Mr. J and Mr. Cacciatore got a copy of it, and Judge Michael Kraynick got to see the full unedited forgiveness speech after his sentencing was locked in.
Good bit of phone text messages into the record.
Separate and apart from the 2-hour video presentation. Okay, got it. All right. Okay, so that's going to take us in tomorrow afternoon. Are we going to be in a position for the state to rest its rebuttal case tomorrow and proceed with closings, or are we going to proceed with closings Friday morning after had the
Roberta Real, we've missed the Dr. Julie Harper testimony. We are approaching the defense resting their case, and we are about to move into Tanya Werner testimony, closing out day 4 and returning on October 24th, 2024 with Dr. Werner in 2 or 3 minutes.
opportunity to have a full, not that we would not have a full charging conference, but after having a charging conference Thursday afternoon with regard to the jury instructions?
I just don't know how long, I think all the instructions are pretty relatively simple and straightforward, except for 3.6.
Agreed. 3.6F, I agree.
That's not going to be simple or straightforward in any way.
The instruction is complicated. I agree.
And the special jury instruction on battered spouse that we're going to be requesting.
Okay.
Maybe some, there's different courts, Judge, here in Florida that have used the special instructions. There's different courts in other states that have used a different instruction. We've looked at a bunch of them, so I don't know what this court is going to be inclined to do if court would be so inclined to give a special instruction.
Big conference going on between Lauren Henderson, Tony Henderson, and Kevin Beck, enough that it caused Dave Cacciatore to look over.
On battered spouse and whether or not you want to consider one of the local courts, the Palm Beach County case that I've mentioned before with Dr. Brennan. There was a special.
Sarah always drinks her water like it's the last thing she's going to drink. She drinks it like Matt Bevilacqua in The Sopranos when he's handed a diet soda before he's about to get executed. Back a half second here. 7:46:44. Oh, of course, that's right on a switch. Okay. Well. Okay, 20 seconds from now, Sarah picks up the glass, and it looks like she's going to take a small sip, and she just keeps tilting it back.
They have used a different instruction. We've looked at a bunch of them, so I don't know what this court is going to be inclined to do if court would be so inclined to give a special instruction on battered spouse and whether or not you want to consider.
I'll have a small sip of water. Just a little tiny, just a little sip, just a little. Oh, this is so good. Doom to the last drop. Drink it down. Chug, 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 chug. Frank the Tank.
Has
Frank the
a
Tank.
draft of that been circulated yet?
Not to the court.
Okay, all right. All right, so here's what we're going to do. Okay, let's just see how long the rebuttal case takes. And then if we have to do closings Friday morning, we'll have to do closings Friday morning. I'd rather go through and spend the time to make sure that we're all on the same page with regard to the instructions, especially due to the complicated nature of 3.6F. With regard to those, the court will have Ms. Barrios email you till she just started her drive back to Kissimmee, so it might come a little bit later this evening. I will have Ms. Barrios email to you all the red line that the court has worked on so far of the jury instructions provided by the state. The defense is to provide its markup of the 3.6F and 3.6G instructions and any other defensive instructions that the defense seeks to have read to the jury.
Before 9 o'clock in the morning?
I think so. That gives the state the opportunity during the lunch hour to review them in advance of our charging conference.
I'll have it done before 9.
Okay.
I'll have it.
Yes, sir.
There was one thing, the state had filed a motion requesting a special instruction as to, I think it goes to voluntariness. I read the motion and the proposed instruction. I have no objection to it.
Okay, all right. So just so the record's clear.
Just so the record's clear, I'll read what Mr. Henderson just said. There's one thing. The state had filed a motion requesting a special instruction as to, I think it goes to voluntariness. I've read their motion, their proposed instruction, and I have no objection to it.
We're referring to the state's request for special jury instruction regarding Florida Criminal Standard Jury Instruction 3.9B, defendant's statements filed October 22, 2024. The provision that the state seeks to add to the 3.9B instruction reads as follows. Law enforcement is not legally required to ask a suspect whether he or she wants to talk to law enforcement after Miranda warnings are read to a suspect. This is, however, one of the factors you may consider whether the defendant's statements were voluntarily made.
We're still only, it feels like halfway through, Kelp. It's been longer than that. We're about 4.5 hours in, but we're really just halfway through. I don't think we're going 9 hours. Who knows? Who knows?
The state defense, state, have I read that correctly?
I believe so, without reading myself.
And defense, you have no objection?
No objection, Judge. And it's my understanding that's going to, there's already the standard instruction. That's an add-on to the standard.
It's just a matter of where y'all want it. So I will add this to the red line to be sent out this afternoon. Ms. Boone, I want to have a couple other conversations with you, ma'am. Again, I don't want to know specifics of anything that you or your attorneys have discussed, just whether or not you've had those discussions. Did you hear the court read the proposed additional language to the jury instruction about your statements?
Just now?
Yes, ma'am.
Could you please read it one more time?
I can. So just to give you some background, ma'am,
I
there's a
can.
form instruction. It's 3.9B, and it talks about how the jury is to consider
Are you talking about what happened just now? Because no, I wasn't listening.
your statements that were read to them and provided in evidence through the course of the trial. And that they're to consider the voluntariness of those statements and whether they were coerced. The state is seeking to add the following language to that instruction. Law enforcement is not legally required to ask a suspect whether he or she wants to talk to law enforcement
Great point, Super Kelly G. I'll bring this up as we're transition between the two, day 4 to day 5. Good call.
after Miranda warnings are read to a suspect. This is, however, one of the factors you may consider whether the defendant's statements were voluntarily made. Do you understand that portion of the instruction?
Yes.
Do you have any questions about it?
No.
Okay. Have you had conversations with your attorneys about the proposed additional language that I just read to you?
Not yet.
Oh. Okay. Let's go ahead and have those conversations tonight when you all break, and we can go over this tomorrow when we have the charging conference. But I'll go ahead and add it to the red line for the purposes of our discussion tomorrow.
Thank you, Judge.
Okay. Anything else, State, we need to address?
No, Your Honor.
Defense, anything else?
No, sir.
Okay, let's go ahead and bring our panel back in, and we'll tell them we'll commence tomorrow with additional evidence and testimony at 9 a.m.
Okay, so they're just bringing in the jury to say goodbye. Just came back to say goodbye. We'll be coming back to day 5, but Super Kelly G's comment is Brian Kohlberger is appealing based off of, well, let me just read it right. He's trying to say he took a plea because he was lied to. Little whispering from the Owens team, nothing significant. But this is why it's so important and, so fantastic that Judge Kraynick is putting all of this on the record and taking the time to colloquy the client. If you hear that word over and over again, colloquy, C-O-L-L-O-Q-Y. Really, is that not a Q-U-Y? Remember that for Scrabble. Colloquy is from colloquialism. Yeah, I probably shouldn't have started that. In any case, it means to ask, to inquire. So the quick colloquies with Sarah is basically just getting on the record, almost like Miranda rights. Do you understand your rights? Do you know this is one of your rights? Okay, you've had that conversation with your lawyer. Okay, but just putting it all on the record. So if 2 years after her trial and after her appeals have been exhausted, she wants to try and do some pro se appeals, this is not an avenue that she can pursue. Oh, Super Kelly G, was he asked these same questions on the record in the same manner? So this is almost a playbook for judges dealing with troublesome defendants. We know Juror 3 is going to have his hand raised. He has been following the judge's instructions. 100% right hand to God, Mr. Excuse me. Mr. Kraynick.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
I do.
Thank you. Y'all can be seated. Members of the jury, good late afternoon, early evening, I think. Again, could you just raise those hands, confirm that you complied with the court's instructions? All right, record reflect all hands have been raised. Members of the jury, it's 4:43. We're going to go ahead and break for the evening. I'm going to ask you to be back here at 9 a.m. tomorrow morning. We'll continue with evidence and testimony presentation by the defense, and then we'll proceed accordingly thereafter. I want to read you the same instruction that I've read you multiple times over the last week, and I beg your forgiveness as you hear it again.
No, we don't need to hear it again. You're not going to miss out on anything, and this is the end of a longer stream. Well, we'll skip a little bit just so we can see Sarah getting put back in chains. We don't want to miss that, but then we'll go to 5. So the audio is gone from this stream. We are ready to pick up with Dr. Tanya Werner, the focus of the probably the strongest of the appellate arguments, and that doesn't reflect strength of argument. It reflects weakness of the other 3. Sarah's got 4 main arguments in her active appeal. One of them is that there's a discovery violation during Tanya Werner's testimony, so we'll get a chance to look at that. In my first rewatch of it, it seems that Judge Kraynick is just as deferential towards the Boone defense team as he has been at any other point in the trial. I don't see any discovery violation. Definitely a little, unconventional to have Owens do a deposition live on the spot in court, but a pretty good cure to the fact of, this is new information. It's not like he deposed her 2 years ago and, it's, new information that's come up since then. Tanya Werner, I think, just got brought on by the defense or by the state at the same time that Sarah indicated that she was arguing self-defense. They didn't have any need for a witness like Tanya Werner before then. So Tanya got her single visit with Sarah. Like the state expert isn't, I guess they're only, what's the word for it? I'll forget the word. They only get one visit with the defendant when it's the state's witness. So, Mr. Beck always looks like he's having a great time. He looks like he's the guy who has the most fun when they're not working. And I'm just making little jibes back and forth. James laughing. There's one for Sarah to tell the other inmates when she gets in jail. All right, thank you for watching Court TV. She's been removed. We're going to day 5. Press and play and into the courtroom. Oh, we want to see her brought in. We don't want to miss that. Don't want Court TV music to try and take over my stream. Hold on, that's not Court TV music. It is Court TV music. Oh, it's coming from that one. Aha. Sneaky. Right. Apologies for the audio getting a little fractious there. We're back to our regularly scheduled broadcast. This is 8 minutes into the day 2 feed. Let's see. Time. There's Judge Michael Kraynick's head just coming into the picture. Bill for Dom Russo says, I have a pearl necklace for her. Interesting you bring that up. Tanya Werner has a lovely pearl necklace, and we'll see that on the stand. ZZ Top song notwithstanding, it's she wore a pearl necklace. You can see the big poster board pictures are over there by the court clerk. James Owens will be using those poster boards as part of his cross-examination. Is it the cross? I guess it's a cross because Dr. Tanya Werner is a defense witness or a state witness. Let me adjust my chyrons while we're doing that then. Let's see here. Witness is going to be Dr. Tanya Werner. You can talk amongst yourselves. I'm just doing some tech stuff here. Dr. Tanya Werner is a forensic psychiatrist as opposed to the forensic psychologist that we just heard from the defense team. Psychiatrist, Psychiatrist. Looks right. That over just above me. Okay, that's good. Okay, that'll be when she enters the room. What else do I need to change? I'll bring the dandelion back up. That's nice. We've got, the Mr. J text. Change that. It's not cross. Now it is state rebuttal witness. All right, we've got Mr. J spelled correctly, pronounced J. Sit down there. I don't think we need the subtitles for this section of testimony. I know that Dr. Werner is very loud and clear. Mr. J is also, he's never had a problem all trial, so I'm going to turn off the closed captions. What else are we waiting for here? We're 12 minutes into the feed. Start talking yet? Oh, there's a lot of conversation. This is a good time for me to check in with the chat. As you guys can watch the Owens team review their paperwork, it looks like Sarah and Tony Henderson are engaged in some animated conversation together. Owens reviewing his photographs. Unpin. If you notice, I don't pin messages nearly as much as channels used to. It's because the pinned message blocks the most recent chat, and a lot of times it just makes it more confusing for you, so I don't do it. Beth of a Salesman says, work is over. Woo! Welcome to the chat. Welcome to the weekend. Everybody's working for the weekend. Do, 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 do. Everybody. Da, 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 da. Kelp is talking to Candace about Officer Pink Cuffs. She's a lady doing her job and in charge. Bill for Dom Russo is asking, just kind of willing Sarah Boone to turn around. Don't worry, she tends to look at the camera at least once a show. At least once per episode. We've got Dorgan, we've got Amy Zeitgeist, we've got Ramono, Super Kelly G, Deborah Rockhill, Just Me. There's some great names in the crowd. If you, how am I going to, if you haven't been with us, come back because Dr. Julie Harper is gone. Kevin Beck leaning in, giving a little, see, he's just joking with the guys. Look at that smile on his face. He just had something funny to say to Mr. Cacciatore, and now he's just tickled about it the whole walk back to his seat. Yeah, he's going to be thinking about that. He's going to be thinking that Kevin Beck from Arizona, I'd like to have a beer with him. He's a funny guy. Got Mr. Henderson trying to explain the finer points of battered spouse syndrome to Sarah at the last minute here. Now, what we're going to do is call into question the no contact order. We think that's the strongest piece of your defense. Hey, Kelia. Kelia says, moi. Moi is me. If you're not français, if you're not fluent in français like I am, moi is me. But it was in reference to toi, which is you. When I say moi, I mean me. When Kelia says moi, she means her. She. I don't know what the pronoun for she is in French. Elle. Elle. All right, that was French with Dan D. Really, my Latin's a bit stronger, which is sad as a Canadian, but, you know, if it's on a cereal box, I can probably tell you. Like riboflavin, the French translation for that is riboflavin. All right, how much longer do we have to do this for? And I can't scroll past this. There's always interesting stuff in watching the body language, so I'm never, you know, we can relax in these streams. Everything doesn't have to be the most newsworthy moments, but I don't want to skip anything. I don't want you guys to think, oh shit, why did you just skip there? I wanted to see what those two are talking about. Most of the time you don't, but but yeah, if this was just 100%, you know, action testimony, it'd be a little overwhelming. It'd be like, it's too much. It's too much information. I just need to pack it down. That's a great question for me to be. Are there some parts of Canada where French is spoken more than others? So 100%. Obviously, Quebec. That's Quebec as a province has their own language police, literally language police that go into establishments.
Case number 20.
Sure, now they call it to order that I have something to say. Very quickly, something called Bill 101 came out when I was a teenager, and it basically regulates that if you run a business in Quebec, that all your signage has to be predominantly French, and not just predominantly, but measurably predominantly. Like 80%, the French has to be 80% bigger than the English text. It's weird. But aside from Quebec, Manitoba has a lot of French speakers. Basically, the further you go west, the less you have people who speak French. It's still an official language across Canada. I was born in Vancouver, British Columbia, so I'm like the least French of the French-Canadian contingents. But yeah, the further east you go, if they don't speak French, some of the East Coasters, the Newfies, they talk with such a crazy accent, you'd swear they're speaking a different language, even if it's not French.
ACF 2603, Singapore versus Sarah Boone, and after names for the record, beginning with the state.
Dave Cacciatore on behalf of the state.
William J. for the state.
Defense,
James Owens for Sarah Boone.
Think of the way, so if you want to think about how French is spoken in Canada, think of the way Spanish is spoken in the United States, but from an east to west perspective rather than a south to north. So, you know, the further you travel north, the less likely it is that, you know, Spanish is a common. But if you're in, you know, Texas, California, New Mexico, any of those border states to Mexico, obviously a lot more Spanish there, right? Where you have entire communities and whatnot. Canada's kind of like that. On the East Coast, that's where the concentration of French is. And then it just kind of peters out as it travels westward.
Tony Henderson for Sarah.
Ms. Boone, raise your right hand to be sworn, please. Do you swear?
I'll let the initial court stuff start while I go to the bathroom, and I will return.
Good morning, ma'am. Could you state your name and date of birth for the record for me?
Sarah Boone, 10-10-77.
Ms. Boone is seated at counsel's table, buttressed by her attorneys,
What's she
wearing a
wearing?
black suit and pink blouse. All members of our jury are present this morning. State, or is there anything we need to address before we bring in our panel? Defense, anything we need to address?
Yes, Judge, I intend to introduce these two exhibits that have already been stipulated to. One is, you did a market once they're introduced.
Correct.
Okay.
Right now, their ID is AD as in boy and AC as in
Defensive identification AB, Judge, which is the order dated June 16th of 2019. It's a no contact order. And then identification is an AC. And it is a no contact order dated June the 19th, 2019. And then I'd like to introduce them into evidence. And then I'd like to hand publish them to the jury.
Okay.
And let them look at them one at a time. and then I believe we're going to rest our case, but at some point, I guess you would excuse the jury because Sarah Boone needs to be questioned about.
And there may be additional motions to be addressed at that time. So yes.
Do we want to do that now before we bring the jury in?
I don't have a problem with that.
Let's do it now.
If you want to rest now, subject to those being entered and published, and we can address any motions. The court has reviewed both of the no contact orders. And that way we don't have to do a in and out. And I can colloquy Ms. Boone at that point in time, and we can proceed with the state's rebuttal case.
Subject to those, the introduction of those two exhibits just mentioned, the defense would be resting our case at that juncture.
Okay, all right. Yes, ma'am. Okay, I've been advised by the courtroom deputy that juror wearing badge 130, seat 10, cannot stay past 5:30 today. So just be advised. We'll use our time accordingly.
Is that one of the 6?
I don't believe so. Give me a moment and I can check.
Is that an alternate judge? They're not supposed to know whether they're alternates or not, though, so you can't just like, well, one of you that isn't here is an alternate, so we'll just keep going.
That is an alternate. It's alternate seat 4.
Thank you.
Sue's what? Picked up on my Bill O'Reilly.
Defense, do you have any motions?
Bill O'Reilly impression. We're doing it live. We'll do it live then.
Just out of abundance of caution, I would read new or motion for judgment of acquittal pursuant to
Oh, Mr. Beck popping up with a motion for acquittal. James Owens looks as surprised by this little motion as Dave Cacciatore does.
defense resting. I'm going to do that now while the jury is still out. I don't have any additional arguments other than what was made the other day.
Okay, thank you. Any other additional argument, Mr. J?
Just that at this point in time, the standard is whether or not a reasonable trier of fact could find the defendant guilty, and there is sufficient evidence for that to be sent to the jury.
Okay, thank you. The court recalls the arguments that were made after the conclusion of the state's case, both from the state and the defense. The court finds that a reasonable juror could make a finding of guilt on the elements of the sole charge in the information beyond and to the exclusion of each and every reasonable doubt. For those reasons, the renewed judgment of acquittal is denied. Ms. Boone, I have a couple of questions to go over with you, ma'am. You've been previously sworn this morning. Your attorney has indicated that all of the evidence and testimony of all witnesses in your case have been presented to the jury, with the exception of the 2 no contact orders, pre-marked as AB from June 16, 2019, and the no contact order of June 19, 2019, pre-marked as AC, which once the jury comes back in, he will enter into evidence and produce them to the jury for their viewing. Are there any witnesses that you wanted to call that your attorney failed to call?
No.
Is there any evidence that you wanted your attorney to present that any of them failed to present?
No.
Are you satisfied with all of your attorneys up and until this point?
Very.
Is there anything that you would like to bring to my attention at this time?
No, Your Honor.
Okay, all right. I did receive the proposed jury instructions this morning. I'll look at them during the lunch hour, and after the state concludes their rebuttal case, we can proceed with addressing those. Mr. Beck, yes, sir.
No, the defense did not receive the red line copies that the court discussed yesterday. I don't know if those were sent or not.
I emailed Ms. Barrios last night. Once we got out of court, I'll send them to everyone this morning. Just give me a moment, and I'll get those out right now.
Laura, too, is talking about purchasing refurbished. I did my
Is there anyone else?
My MacBook that I'm using right now is a 2024 refurbished Apple product, and seems great. If you're, don't need the latest state-of-the-art stuff and you still want Apple protection, you're not just buying it from some third party that says it's refurbished. Recommend. It's a good way to go if you want to spend you don't want to cheap out on it, and at the same time, you don't want to pay more than you have to. The refurbished Apple route is a great way to go. There's probably considerable cost savings from just buying it like off Facebook Marketplace, but buyer beware, caveat emptor.
The email correspondence that I have is Mr. Owens' email, Ms. Andrews' email, Mr. Cacciatore's email. Is there anyone else that they need to be sent to from the defense side?
We'll pass them around.
Okay, all right, very good.
All right, where does that leave us now? Every time I pause it, then it comes back to silent courtroom.
All right. Can we go ahead and bring in our panel? State.
Yes, Your Honor.
Defense?
Yes.
All right, let's stand and bring in our panel, please.
Mandy, 13, thank you for asking. Gives me something to say. So what's coming up now is Dr. Tanya Werner. And, well, first the defense is going to rest. Then the state is going to call their rebuttal case. And the beginning of the rebuttal case is Dr. Tanya Werner, who is a forensic psychiatrist. So she's able to testify more than just the mental aspect of forensics, like a psychologist, but also into some of the medical aspects of it. Mr. Owens is very combative with her. It's a little frustrating. It was very frustrating in the moment. It's less frustrating now, knowing that Sarah was convicted. It's a little frustrating in knowing that this is going to be part of the appeal. It's probably going to be a little cathartic if you're worried about her appeal to
State,
see
you recognize our jury?
how well
Defense, do you recognize our jury?
Yes, I do.
All right, thank you. You all can be seated.
Judge Kraynick protects this case despite this being one of the appellate issues.
Good morning, members of the jury. Welcome back to 12 Alpha in the Orange County Courthouse. If
Hey,
you could, just
JL.
raise your hands to confirm that you...
JLK Upstas, welcome to the chat. Fell asleep, but now you're here. You're here for, I think, the fun part of the stream. I think we're all going to live through Tanya Werner, Dr. Tanya Werner, a little bit here.
complied with the court's instructions last night during the break. I thank you. Record will reflect that all jurors have raised their hands. We're going to have a little bit of additional evidence presented by the defense this morning, and then we'll go from there, okay? All right, thank you very much. Mr. Owens, you may proceed, sir.
Judge, at this time, I would move to introduce defense identification exhibit AB into evidence.
No objection to AB or AC.
What was pre-marked
So A, B, and AC are the two items that they were just discussing at the end of yesterday's testimony. It's going to be the no contact order evidence that Mr. J didn't want to make a court clerk come up and testify to.
as defense AB will be received into evidence without objection as defense 19. And if you could just identify AC for the record, sir.
Judge, at this time, I try to move.
Oh, my
I would
God.
like to move,
Okay.
defense identification.
I was looking at the posters by Mr. Owens, and I mistook Mr. Henderson's head for being part of one of the poster boards. Okay, yeah, you guys can see that in your view. I was like, what the hell picture is that? What's going on down there? I don't remember a picture of black man's bald head. Oh, Mr. Henderson's bald head. All right, getting a little silly. I've been here a while.
AC into evidence.
Hearing Hearing no objection from the state, what was pre-marked as defense AC will be received into evidence without objection as defense 20.
And Judge, I would like to publish these to the jury and allow them to take their time and pass these down to.
You may proceed.
The first is Defense Exhibit 19. We'll just review it and pass it.
Okay, so he's handing the pictures directly to the jury here. They're not being displayed or anything, so it's, the paperwork, George Torres, no contact, whatever. That's what's happening right now off camera. Beth of a Salesman asks an interesting question. Dan D, what would you pick for your last meal? Give me a second to think about that. I'm going to try and come up with something clever. Got it. If it was my last meal, I would want to go to, and they wouldn't do this, it wouldn't accommodate it, but still, it's worth asking. You know those sushi bars where they have the conveyor belt? And I think they do this for dim sum too, but they put plates and the plate just comes by on a conveyor belt and you pick the ones that have something interesting that you'd like to have. I think I could milk one of those kind of experiences, meals, into a much longer last meal than your typical inmate has. I'm still hungry. You can't end my last meal. I'll have one more, just one more. Have like 40 plates all piled up. You promised me a meal. Try and think of an answer for a legitimate one. If they're like, no, it has to be something we can make in the jail kitchen. Stop doing really ridiculous meal requests after that guy. There was one guy who did it. Might be worth looking up. But there's one guy who ruined it for everyone. It came time for his meal and he asked for like 20 different things. And then he had like the hot dog and I'm full. But I guess he just made them, prepare 40 other dishes as part of some elaborate buffet that was his requested last meal. So I'll look into it. Probably embellishing a little bit, but there is one last meal inmate who ruined it for everyone. Lasagna would be good too. I could see a really nice deep dish lasagna with cottage cheese and that ricotta layer, and that could be good.
20.
Cheese toast is a simple one that's delicious too. I used to really like just a couple slices of French bread, butter it. Butter it. You want to come back up again, kid? No, I'm smoking right now. No, I'm not going to smoke and hold you. I know you'd like some attention. Okay, I'll put it out. I'll put it out just for you. But yeah, so cheese toast, butter, a little bit of mayonnaise. Mayonnaise helps get you to all the corners of the bread. And fat equals flavor. Then you've got to put that on like a hot frying pan. Not too hot, but hot. Enough that it's like browning the bread, but also melting the butter. And so you're then flipping that back and forth. And before everything's melted, you still need there to be some softness. Then you dust it with cheese. And, oh no, you need a little ranch in there too. So yeah. You get some slight browning, you put on some ranch, get that to soak in a little bit, then put on some cheese on top, then get a little bit of a crust on that. Oh, delicious. Delicious. Kat, do you have anything to say to Miss Boone? Anything to say to the fine and dandy people? Lots of cat fans in the audience there, Cadillac. Probably a little jealous of all the time that they're taking from your time. Cat used to have my attention 24/7. And all of a sudden, it's like Feline Fridays turned into Dandy Fridays. What the hell? Wah. There we go, there we go. Layout for the people. That's nice. Okay, you're going down now. I think I've got one more set of snacks to bribe you with. Get back to the people. Okay, I didn't think this would take that long. I would have prepared something. Let's just go back to, as soon as I get to it, I'm sure they'll start talking again. We'll find my haiku that I got AI to write. Can you write a haiku about the Sarah Boone, Florida suitcase trial? Trapped in zipped luggage, cell phone videos taunting, life behind cold bars. Trapped in zipped luggage, cell phone videos taunting, life behind cold bars. Read it one more time like AI would read it. Trapped in zipped luggage, cell phone videos taunting, life behind cold bars. Okay, this needs a little musical accompaniment, so we'll just get a little bit of jazz in the background here. And turn it down in advance so that...
Thank you, members of the jury.
Oh.
Mr. Owens, any other additional witnesses, evidence, or testimony, sir?
Okay, that's all we get for music. That helps speed it up.
Thank you.
Defense rests.
Or state, are you intending on putting on a rebuttal case?
Yes, Your Honor.
You may proceed, sir.
State called Dr. Tanya Werner.
Dr. Tanya Werner. Werner? All right, defense rests case in chief. Now I can pull up the witness is Dr. Tanya Werner, forensic psychologist. She starts off, she's in a fine mood. She's ready to be just like any of the other witnesses. She has no reason to expect it's going to be anything different than the other witnesses. And then it just goes downhill.
Doctor, good morning. Could you state and spell your name for the record for us?
Hey, Carolina.
Thank you. You may be seated, ma'am.
Thank you.
Good morning, ma'am.
Good morning.
Where do you work?
I'm employed at Meridian Behavioral Health Care in Gainesville, Florida.
And what services do you render there?
I'm their chief medical officer.
And can you tell the jury what your educational background is?
Yes. So I graduated with an undergraduate degree at the University of South Florida in chemistry. I then attended medical school at American University of the Caribbean. I did a residency in psychiatry at Connecticut Valley Hospital in Connecticut under the auspices of Yale University. I then came back to Florida.
If you're interested in the song that was playing just before we took that impromptu break, it is named Regulate. The band is Diala. They provide free music to YouTube creators. So if you search up Dyalla, and you'll probably bring up their page, and the song that was playing is Regulate. It's funky, it's short, got a bit of a beat. We'll come back to it if there's another quiet moment in the broadcast, but that's not now. So we'll go back to the testimony.
And did a fellowship 1 year in forensic psychiatry at the University of Florida.
And since your educational background, what have you been doing professionally?
Yes. So I'm a licensed physician in Florida. I am board certified in general psychiatry and forensic psychiatry. I was initially employed on faculty at the University of Florida from 1998 through 2015. I retired.
Special hello to NJ Linardos. Is that New Jersey Linardos? Thank you for joining the chat. And JLK Upstas says, I wish they'd have a message feature so that we could send messages, recipes. Come on, YouTube. Until that happens, feel free to use my community page. You guys can talk amongst yourselves. I opened it up. As long as you're a subscriber, you can post to my community page if you want to talk to other people in the community, share off-topic stuff, whatever. YouTube's pretty good about just feeding the Sarah Boone stuff to people on a wider audience. But if you're posting off-topic stuff and people go to the page and just sort by newest, they'll see, what are people talking about? Disney Mom posted a great recipe that she has for hard-boiled eggs. If you want to have, hard-boiled eggs with a little bit of smoke and char to them, you can scroll back a couple of months and see that. There was a flood of pet pictures we did during the Betty Broderick trial. So feel free to use my community page as your community page.
There as the vice chairman of the Department of Psychiatry and the director of the Forensic Institute. I then went to work as the chief medical officer at Meridian Behavioral Health Care, which is a community mental health center.
What is psychiatry?
So psychiatry is the treatment of mental health disorders.
And what is forensic psychiatry?
Forensic psychiatry is...
And just to clear up the record, New Jersey Linardos is not New Jersey Linardos. It's the first and second initials, so maybe a Norma Jean Linardos, but we don't need to dox anyone.
The interplay of psychiatry and the law, so anywhere where psychiatry intersects with legal issues.
Her credentials are outstanding. There's nothing, I was ready to stipulate to Julie Harper's credentials, but I think that Tanya Werner's, if I'm weighing them up on the scale, I'm already leaning towards her.
What is the difference, if any, between a psychiatrist and a psychologist?
So a psychiatrist has gone to medical school.
Kintu
where
Sukuroy
a
has joined the
psychologist
chat.
has not.
And as a licensed physician, are you able to prescribe medication?
Yes, I am.
In the course of practicing medicine as a psychiatrist, do psychiatrists prescribe medication to treat mental disorders?
Yes, we do.
And when did you begin your work as a forensic psychiatrist as opposed to working at the faculty at the University of Florida, or was that concurrent?
In 1996, in the state of Connecticut, while I was doing my training at Yale University, I testified for the first time as an expert witness in the state of Connecticut.
And over the course of your career, have you done forensic psychiatric evaluations?
I have.
Approximately how many?
Thousands of times.
Thousands.
And does this include on matters such as competence?
Yes, it
Sounds like she's competent as well.
does.
And does it, just explain briefly to the jury, what does that mean, legal competence?
So competence is, do they understand the legal process? Do they understand who the different players are in the courtroom, who's on their side, who's not on their side?
And that is the kind of questions that are asked on the legal aptitude test, or whatever it was called, that Dr. Julie Harper testified to, that she'd taken her understanding of legalities. It's like, do you know what the prosecutor's role is? Oh, is he there just to make sure that, I get snacks? No, he's trying to put you in jail.
What they're charged with, what the possible penalties are, what the possible plea options are.
And have you ever done any forensic evaluations about insanity?
I have. I've done.
This is a little dig towards the fact that Dr. Julie Harper just testified in the insanity case the day before. Juror doesn't have any recollection of this. I think this is just Mr. J, getting a little of his own snark out. And you've done this too? Okay. I bet if you testified in the Bailey case, you wouldn't have testified the guy who told his friends how it would be good if he got diagnosed as mentally incompetent. You wouldn't have testified that he was not lying, would you?
Sanity at the time of the crime, and also I've been appointed by the governor of the state of Florida to do sanity for execution.
And have you ever been involved in working as a forensic psychiatrist involving the subject matter of battered spouse syndrome?
I have.
Can you describe your experience in that area for the jury?
I've been asked to do evaluations by the prosecution and defense several times with regards to, and it's come up in different cases, criminal cases with regards to intimate partner violence.
And does all violent episodes within a relationship result in something that we are describing as battered spouse syndrome?
No.
And I see there is a book in front of you. What book is in front of you?
Yes. So this is the Diagnostic Statistical Manual, and this is the 5th edition text revision, which is the
She has the book too.
most current edition.
Is battered spouse syndrome in there as a diagnosis?
No, it is not.
And where, if anywhere, does it fit into any of the categories within the DSM-5 TR?
It would come under one of the trauma categories, most specifically under most likely post-traumatic stress disorder.
Can you describe for the jury what post-traumatic stress disorder is?
So this is a disorder that's recognized under the DSM for individuals who have suffered a traumatic event, and then they have re-experiencing of the traumatic event. They have different symptoms besides re-experiencing, such as hyperarousal, and also avoidance of triggers or symptoms, things that would trigger a response to it.
Are there any agreed upon criteria within the relevant forensic psychiatric and forensic psychological communities about battered spouse syndrome?
There are.
And what would those be?
So it's again, having experienced a trauma, repeatedly, violence within an intimate relationship, and then having symptoms secondary to that, avoidance, so tiptoeing around, trying to avoid recreating the violence.
And if a person experiences an environmental stimuli, something happens to them, another person does or says something to them, is their subjective reaction what is defined as whether there's trauma present or not?
I'm not sure I understand the question.
Let me rephrase it.
You can rephrase.
You described there's a difference between experiencing a violent relationship and whether or not that person is going to experience trauma from those behaviors they witness and experience. Is that fair?
Yes.
Now I've lost my train of thought in the question. Is it fair to say that an experience that a person has, whether or not that person believes it's traumatic, is a subjective?
Super Kelly G points out that Dr. Werner was not asked, did you drive here from Pensacola? Do you travel around the state? Have you ever lived in Milton, Florida? Where did you grow up? Are your grandparents with you until you were in your 40s? How's the jury supposed to know this witness without asking those kind of foundational questions?
Experience.
Yes, each individual is different, and so each individual is going to take that experience differently.
Can hypothetically a couple be involved in a violent relationship for a number of years, even 3.5 years, and battered spouse syndrome not necessarily apply to either or both of them?
Yes, that's correct.
Can you explain that?
So again, each individual is different. So one individual may develop the symptoms of battered spouse syndrome, and one individual may not under the same exact circumstances, just depending on their makeup and what they've experienced in their background and their biological makeup.
And is there a cycle of violence that is sometimes used to describe battered spouse syndrome?
There is.
Can you describe that?
There is. So there's the initial, there's kind of a tension buildup section where you feel the kind of tension building up, and the individual can feel kind of the incident coming, and then there's the actual incident of violence. And then following the incident of violence, there's a honeymoon phase, what they call the honeymoon phase, and that's the third phase, where the individual who created the violence attempts to make up to the victim and recreate kind of the relationship and pull them back in.
And her description of this suits so much better with what we've seen the evidence, or what we're going to see the evidence with the rebuttal case especially, of how Sarah does this. How Sarah instigates the violence, how Sarah instigates the honeymoon phase. Oh, please come back. Please, need hugs now. Love. Not pursuing after noon.
And then it starts all over again, where you feel the kind of tension start building up again to the incidents of
Look what you made me do.
violence.
Does abuse have to come in the form of physical or sexual violence?
No.
Can you explain your answer?
So it can also come in ways of coercion. It can come in ways of control.
Like controlling a cell phone or controlling a debit card that has the other person's paycheck on it.
Such as financial. So if an individual controls another individual financially,
Such as requests for a super hug.
or controls their ability to drive or go out, their ability to be around their other family members or friends, kind of isolates them from other individuals, controls their ability to work, so controls their ability to make money or access to funds. So they can control them in any number of ways.
And that's a great point too. So Super Kelly G says it's great that she confirmed what the other two experts said and then was used to prove that Sarah was the aggressor. It proves that she wasn't biased to make Sarah look innocent. That she wasn't biased. Exactly. She's, yeah, those are legitimate diagnoses. I'm an expert. I can testify to those. But also as a expert and someone who's met her once, I could say, almost to quote Joe Pesci here, but everything that last witness said is bullshit.
Is this kind of about like an inequitable power dynamic in the relationship?
Yes, absolutely.
Can a man be on the receiving end of emotional or physical or sexual trauma and potentially experience, strike that. Can a man be on the receiving end of verbal, harsh words, physical violence, or sexual violence and end up having the syndrome of battered spouse syndrome?
Yes, it crosses all boundaries, and we see it in all types of relationships, whether it be heterosexual or homosexual relationships. We see it cross all boundaries.
And can this element of control come from controlling personal items such as identification papers?
Yes, absolutely.
Can control potentially, hypothetically, come from partner A gifting partner B an item, but still considering that item partner A's because he or she paid for it, even though it was a gift?
Bicycle. Yes. Bicycle.
And in this particular case, were you asked to do an evaluation of Sarah Boone?
Yes,
Do you see Ms. Boone in the courtroom today?
I do.
Can you point out where she is and what she's wearing?
She's sitting at a table there wearing a dark suit and a pinkish top.
May the record reflections identify the defendant?
Record will so reflect.
Pinkish.
What date did you have an evaluation of Ms. Boone?
It was early in October,
yes,
I believe
Ramona.
October 2nd.
good time to bring that up. Ramono says, a new notice has been posted in response to Sarah's appeal. No details available yet, just saw it on Reddit. I saw it myself on Just a Lazy Gamer, who'd posted almost essentially the same thing. There's an update and there's no information regarding the update, but there's an update. So they've at least acknowledged the answer brief. It's going to be hilarious to see how they respond to it, because I didn't even understand Sarah's appeal until the answer brief came out. Reading Sarah's appeal, the more I read it, the more confused I got. And I was like, what the fuck are they talking about? And then I watched a bunch of shows and I'm like, okay, well, and then it didn't make sense. And I'm like, it's because they're experts. Maybe if I just read it online with my friends with a fine and dandy chat, I'll figure it out. I still didn't know. And then I read the answer brief and I'm like, that's what they're arguing, and that's why they're wrong. This all makes sense now. It's all coming back to me now.
And this was at the request of the state of Florida
Yes, it was.
and subject to a court order?
Yes.
And who was present for this evaluation?
The defense and the prosecution.
All right. Tell us about the evaluation with Ms. Boone. What do you do first?
Tell us about your evaluation.
So I met with Ms. Boone at the jail in a conference room. Again, the prosecution was there and her attorney. I met with her for approximately 2.5 hours, just under 2.5 hours. I introduced myself and explained that the interview would not be confidential, that I would be coming to court if asked to share my opinions. And she agreed to participate. I then start out with just general information, so getting to know her, date of birth, kind of background
10-10-7-7.
information, who her parents are, childhood. I go through her educational background, her work background, her marital background. I go through health, psychiatric background, any substance use issues. I do a mental status examination.
Can I stop you there?
Yeah.
Elaborate further on that.
So a mental status examination is just questions to determine kind of memory and cognition, kind of how their thought process is, how they're thinking. Are they able to kind of fluidly think through processes?
All right, go on after that.
And then I transitioned from there into walking through the incident that happened with her.
All right, what did she indicate occurred on February 23rd, 2020 to you?
All right. Is it all right if I refer to my notes just a minute?
Just, if you need them to refresh your memory, please do so, but don't read from them. Just let us know.
So she had a difficult time recalling what time they actually woke up that day. Initially, she said in the morning, and then she said she wasn't even sure that it was in the morning. She said that they both wanted to drink, but that she asked that they could clean the house first instead, and that they did some vacuuming and cleaning. They had a half a bottle of wine left over from the day before that they drank. She felt about 4 o'clock in the afternoon. They drank that out on the back porch. And she described that they had kind of 2 beach chairs out there and a dartboard, and that they kind of hung out there a lot on the back porch, spent time out there. They did a puzzle out there. And completed that, and then did some kind of artwork. She felt like he was getting frustrated thinking about his life, that he had lost his job. And so she encouraged him to call his daughters, although she knew that that they did not like to talk to him when he was drinking. So I'm not sure why she had encouraged him to call them at that point, because they were already drinking. And she also at some point encouraged him to call his brother, because she wanted him to explain to his brother that he had pulled her down the stairs the night before, although that didn't happen. He didn't explain that to the brother, and according to her. And Then at some point, they went and got another bottle of wine and some cigarettes from the grocery store and continued to drink. And then they were inside the house, and then he, I guess, tagged her at some point and said, "Tag, you're it," which indicated that they were going to play hide and seek. And she said she went upstairs and hid in the shower and waited for him to come, and he never came upstairs. Excuse me. And so she eventually
Have a sip of
came
water,
out of the
Tanya.
shower to look for him. And as she was coming down the stairs, she said she saw him slipping into a suitcase, which was on the living room floor, that they had put out because they were going to donate it.
Have a sip.
And, sorry.
Seriously, drink it.
And so she went downstairs and indicated that she had found him, and they were kind of laughing. And she zipped the suitcase up. And they continued to laugh, she said, at that point. And they were having a good time and laughing and enjoying themselves and having a good time. And she said, and then she became angry. And she said she remembered what it felt like when he was choking her. And she became angry.
What did she do after she became angry?
I'm going to refer to my notes at this point.
Have a sip of water. I can feel it.
Remember, you just,
Just listening to you put a scratch in my own throat. Meanwhile, Sarah's chugging down water like it's the last, like it's Water World and got the last clean water. A good time to throw on the music.
She said that she shook the suitcase and that she lost control of it and it flipped.
And then what happened?
Then she said that he stuck 2 fingers out.
And Mandy makes a good point, and let's reinforce the timeline here because we do have evidence on the record at this point of the trial, and obviously at this point of time. The timeline is neighbors hear the crash down the stairs at around 11. Sarah's phone says 11:03. A photo was taken of a suitcase at the bottom of the stairs from the POV of someone standing over it, photographing in a downward direction. 10 minutes after that, or approximately 10 minutes, I think 11:12 p.m., begins the 2-minute, 22-second, 24-second video. Sarah, I can't fucking breathe, babe. Sarah, babe, I can't fucking breathe. And then 10, 11 minutes after that, Sarah. That's the timeline of events, but let's go back just a half second here and listen to how Dr. Tanya Werner was relayed this timeline of events. We'll go back to 20 seconds back so that appreciate it in full.
She said that she shook the suitcase and that she lost control of it and it flipped.
And then what happened?
How strong do you have to be as a 98-pound weakling to shake a suitcase so vigorously that you lose control of it and it flips? Now, the one thing that is, from a physics perspective, makes sense. If it's a suitcase with one of those handles that comes out, that creates a fulcrum, and you can get leverage using the extended handle and the wheels. And I could totally see her taking George for a nightmare ride around the basement main floor, where she's got the handles and she's like running them in circles and laughing, thinking they both were laughing, but she's laughing, and then loses control of it and it flips over. Back again. Abrupt.
She said that she shook the suitcase and that she lost control of it and it flipped.
And then what happened?
Then she said that he stuck 2 fingers out and her son's baseball bat was sitting there and she picked the bat up and hit his hand.
Then what happened?
And then she went upstairs and waited for him to come upstairs.
All right. Alcohol. Can you tell us what you know about the effects as a medical doctor of ethanol or alcohol on a human body?
Yes. So it causes intoxication, as we all know.
Get her a Dr. Pepper. She's got cotton mouth real bad. Somebody get her a spigot to drink from? Anything.
And it causes disinhibition. It works on the frontal lobe of the brain and allows us to do things that we wouldn't normally do. It disinhibits us.
And in the course of your practice, have you ever come across a diagnosis of alcohol abuse disorder?
Yes.
And what is that?
Well, alcohol abuse is an old disorder. So we used to use alcohol dependence and alcohol abuse. It's now been combined in the DSM-5. In the DSM-5 TR, it's alcohol use disorder.
In considering what a patient or a client or somebody that you've been asked to evaluate by a government entity, do you take into account?
Earlier in the chat, Mandy asked, am I crazy or am I hearing the Magnum bottles of glass clinking together? I just heard what you may be thinking about. And if anyone's wondering, just, go back about 5 seconds in your own feed or whatever. I thought I faintly heard glass hitting glass. It could well be, somebody sitting in the gallery with a Snapple or, something like that. But it's one of those little subliminal sounds that if the jury is hearing the sound of Magnum wine bottle on Magnum wine bottle, it's got to plant a seed of, oh yeah, that's probably a sound that was heard many times in the Boone house.
That person who's relaying the history to use a consumption of alcohol at the time of the history that they're given?
Yes.
Why is that?
Because again, it affects their behavior and their actions.
Does alcohol have any effect on a person's memory?
It can.
What, if any, relationship is there between acute alcohol use or acute alcohol intoxication and battered spouse syndrome?
Sarah thinks she has acute alcohol use. Like, no, it's not gross. I'm just acute alcoholic. I have a few, I'm just pixie-like. I'm a manic pixie girl. No, acute alcoholism. Yeah, acute.
It can affect your memory, it can affect your reactions, it can affect your response to different things.
Does the disinhibitory nature of alcohol strengthen, weaken, or have no effect on battered spouse syndrome?
It would depend on each.
Owens is going crazy with his note-taking. You can see he's ready. Like, the cross-examination is going to be fierce. He hasn't been this animated all trial.
Each individual again.
Generally speaking, it is important as an evaluator to get as much information as possible before rendering an opinion, such as diagnosing somebody with something out of
He's writing a letter like
TR
it's never
or
been
battered
written
spouse.
before.
Yes.
In this particular case, did you require any additional information to reach your conclusion about the relationship between battered spouse syndrome and the events of this evening?
I based my opinion on the information that I had. Certainly, if there was more information, my opinion would be subject to change.
And what was your opinion?
My opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
And specifically talking about...
Judge, people could roast bench.
Yes.
All right, here we go. Sidebar. What is the legal objection, sir? I don't know if it's a legal objection, but Dr. Werner evaluated Sarah Boone at the Orange County Jail on October the 2nd. 2 days later, on October the 4th, I took a deposition, and on several of the issues, she said, I've not formed opinions, as to whether or not I think she suffers from this or that. Couple of them, she said she was convinced that she suffered from alcohol abuse syndrome. But on issues like post-traumatic stress, issues like battered spouse syndrome, I think a couple more issues. She said I would need more time to reflect. Since I just saw her 2 days ago, I would need more time to review my notes. She said it would probably be a couple more hours that I would need to spend on it. And I said, well, can we agree between the lawyers that if she forms any opinions that the defense would be notified? I was not notified. Okay, Mr. Owens. That she'd form this opinion, Mr. J. My expected answer from her is that based on Sarah Boone, what she said about events, that battered spouse syndrome is inapplicable because Mr. Torres and her were laughing. Then it was her who decided to get angry and would not let him out of the suitcase. That's all I'm trying to establish with her. Mr. Owens says, I understand, but we had an agreement that she changed her opinions, that you would let me know. And we agreed that I could retake the deposition. Court says, give me a moment. It was an agreement, Judge. I'll show. That's what I'm pulling up right now, Mr. Owens. It was mentioned in several pages. It's more than. Court says, do you have specific pages in the transcript that address the agreement? Starts on page 38. Line. Well, I start to ask on line 17, but then she responds on line 21. But it goes on for several pages after that. This pertains to adjustment disorder, if I'm reviewing this correctly. Well, it keeps going on, Judge. Like I said, several pages. I know. I'm on 41 right now. Specifically, page 41, line 15. This is from Dr. Werner. So she's saying, I'm assuming that's Boone, she's generalized anxiety disorder. And I'm saying I want to review it more to see if I think it's more of an adjustment disorder to being in the correctional setting right now and the stressors that she is under as opposed to general anxiety disorder. Mr. J on line 22 then states, I'm going to just switch views for you guys. See. I'm probably going to lose a little bit there. We get a little profile of her and have the, I think this is an extended transcript anyway. So there we go. Now you can screen, try and catch up. Okay, so on this topic, if something new comes up, then we can address it. But if you have other topics to disclose or to depose her on, I suggest we move on. Moving on to line 42, line 1, Mr. Owens says, I agree. Mr. Warner, just let the state attorney know. And I know if you may be, we are short on time. So if you review notes on the weekend, whatnot, formulate any other opinions, just let the state attorney know and we'll address it. Witness says, absolutely. Mr. J says, I think it's page 46. I think the problem is she didn't answer the question that I'm trying to answer. On page 46, court says line 1. Mr. Owens says, just to read 46. Court says, okay, let me just read 46. Give me a second. Okay, this will probably help me catch up. I mean, unless I'm missing something, it's lines 13 through 15 that she identifies as, unless I misunderstood the question or the answer, it's in the depot. Mr. Owens says, I would have to look through my notes to see if she fully met the criteria. Court says, but the answer is no. Question, line 13, page 46. But you don't believe she suffers from post-traumatic stress disorder, in your opinion? No. Mr. Owens, look at line 19. Court says, I'll have to go through my notes, back through my notes to see if she fully met the criteria. I'm sorry, hit the wrong button. Line 17. Can you explain why you don't think she suffers from... No, I didn't say one way or the other. I would have to look back through my notes for that. It's something that you may in future. This is a little tough. Hold on. Let me just pause it. I'm going to. Okay. A couple of things that make this one a little challenging is the court is reading from the transcripts and the court, Judge Kraynick, isn't doing voices. So I'm getting thrown between when he's quoting the different stuff that the different lawyers are saying. Should I say it in a Judge Kraynick doing a Judge Owens impression? And I think the answer is yes, but that's what slowed me down. Okay, give me a second. Let me have a sip. And this is how it's going to be now. For the Tanya Werner, I think there is as much sidebar as there is testimony. So buckle up. All right. Buckled up and ready to go. Line 17. Can you explain why you don't think she suffers from... No, I didn't say one way or the other. I would love to look back through my notes for that. Is that something you may in the future give an opinion about after some more time reflecting your notes? I may. Okay. Owen says 25. Court says, okay. That's something you will let me know about if it changes? Yes, okay. And then, just for the record, that's 46. Line 25 through 47. Lines 1 through 2 of the deposition of Miss Werner, Dr. Werner, Mr. Owens. She did go all the way through on several. Court says, okay. Well, the only issue right now is the PTSD, the opinion on PTSD. So what I don't hear is a legal objection. Mr. Owens, we had agreed. I don't know if I can find the right page, but we had agreed to retake a short deposition. Maybe if you give me more time, I can find it. Well, Mr. J said, I will agree to a short deposition if her opinion changes between now and the time of the trial. I relied on that because she would not be pinned down. If you give me a few minutes, I can find it. You want to let the jury go out? I think we're going to have to at this point in time. Mr. J, do you have anything to add just for my own edification at this time? Again, Judge, what I'm trying to establish with this witness is, regardless of whether Boone had PTSD, A, B, C, D, or XYZ, or anything else, snarky, that it doesn't matter based on what Ms. Boone specifically told her about the incident. I'm going to pause again. I want to give this a full. All right. Mr. J's getting frustrated with Mr. Owens. Again, Judge, what I'm trying to establish with this witness is, regardless of whether Ms. Boone had PTSD, ABCD, or XYZ, or anything else, that it doesn't matter based on what Ms. Boone specifically told her about the incident. That's all I'm trying to get out. The answers went divergent from the question. I don't think I'm violating any agreement because her opinion has not changed. I was only able to speak to her for 2 minutes yesterday, and I just asked her about specifics of does this apply given what she stated about the event. And that's not something new from the deposition. And now I'll go back to live. Court responds. Okay, all right. Let me remove the jury for a moment. Thank you. Oh. And then he'll come back. Members of the jury, thank you so much for your patience. I have a matter I have to discuss with counsel outside of you all's presence. It may take a little bit more time than just our conference up here. We don't want to have you all hanging out waiting for us to figure out what we're going to do next. So I appreciate your patience. We're going to excuse you to the deliberation room at this time. Please do not conduct any independent investigation or research into the persons, places, things, or charge involved. You do not have any conversations amongst yourself or anyone else about those things, and we'll bring you back in as promptly as possible. Thank you. Jury's exiting. Jury exited. All right, that's what's happening. Wow, I ripped through that. I didn't need to pause it at all. I assume everyone's just talking over themselves because some of them are super fast, but then, yeah, there's plenty of them that are plenty slow. We have time for a whole nother. So she's even getting frustrated. I saw that look, Dr. Werner. She's like, Jesus Christ. We get on with it. I was told I had 20 minutes with the state. I guess I'll just read my notes. Can't go ride a bike, so I guess I'll just read a book. Nice of them to provide her with a book to read while she's on the stand. Yeah, she's sick of this. Ready to move on. I don't blame you, Miss Werner. I don't blame you. What is taking... Did I really get through the chat? That got through a lot of it. Okay, we're going to even skip ahead a little bit, because I read the part where he excuses the jury.
Obviously, that creates an issue. Think about it, process it.
Okay, that was the open sidebar. That's what I'm skipping to. It's basically the sidebar moves to open court as he excuses the jury.
Just an adjustment disorder to being in jail.
There we go. All right, let's move to open court and Mr. Owens' complaint. So this is basically a super long complaint, and it does get litigated in the appellate argument, and that's why it's kind of interesting from a hindsight point of view here.
Thank you.
But
Mr. Owens, if you...
this is the most meat that Owens left on the bone of the appellate argument, which is that Dr. Werner's opinion had changed since the deposition. So remember, it's only been 15 days. And her answer, there's nothing crazy about that answer that she just gave. She's just like, yeah, I don't think this applies. Well, you didn't say that when I asked you before. Okay, because, I met her and we talked for a couple hours and you didn't ask.
You can find me that portion of the transcript that we were addressing as to additional opinions and other depositions and anything in Dr. Werner's deposition that you believe we need to address regarding this opinion as it relates to PTSD.
Well, and Judge, it applied to every opinion she was going to express. It started on page 37, line 24. As it relates to Sarah Boone, do you have any diagnosis as it relates to her? And then 38 is when she started talking about a generalized anxiety disorder, and that she was not for sure whether Sarah Boone had a generalized anxiety disorder versus if it was just an adjustment disorder to being in jail. And then she also mentioned in that same answer that Sarah Boone had some narcissistic personality traits, and that those were my two major diagnoses. And then I questioned her further about that. She explained again on line 17 about general anxiety disorder versus the adjustment disorder, and that I hadn't had time to fully formulate that opinion out. Line 21, I need time to go through my notes and think about it and process it.
Page. We're still on page 38?
38, line 21. I need time to go through my notes.
I'm just going to admit being a man here, but I am very distracted by the fact, okay, so in your view, it's not there. My own view, I've got Shelby Andrews' legs just poking in the frame here. And, they're just legs. They shouldn't be distracting me, but they're distracting me. Yeah, anyway, show you what I'm dealing with here.
Think about it, process it. But I had other depositions, as you're aware, yesterday, so I had to prepare for those and go through that. So I have not had time to process on my notes. And I said on line 39, well, doctor, I'm trying not to inconvenience you. We're set for trial October 7th for jury selection. Line 6, I anticipate your testimony would be until a little later. So we could discontinue the deposition and then reset it when you've got time to review. Because obviously I'm not going to want to take your deposition and you have other opinions that are not going to be covered. And then I asked, looks like Mr. J asked what
Dor says, so other than that, Ms. Lincoln, how was the play?
your position.
Cold.
He said, conducting discovery after the jury trial starts is completely unacceptable to me. So that's my position. If she needs to issue a supplemental report, or if there has become a need for a second deposition, then we can address that. But it would be my position that we need to get this done, because the state doesn't have any appellate rights once a jury is sworn and jeopardy attaches. And I say on line 23 of page 39, well, you obviously understand my position. I'd like to finish the deposition today as well. But if she is holding out that she may have other opinions and other diagnoses after she has had more time to think, review the paperwork, then obviously that creates an issue. And then she said, but if that happens, I can bring that forward, and then you can add to your deposition at that point, if my opinions change after having reviewed further.
Gotta remember that line. I can bring that forward. 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 I'm bringing that forward. Yeah, no, I want to be able to bring that forward. 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 Forward.
And I referred to Mr. J. Page 9 of 40, Mr. J says, I think we plow ahead. This is our time with her. Court reporter's prepared to give us a transcript by the end of the week. Something needs to be amended.
End of the weekend.
End of the weekend. If something needs to be amended,
Judge Kraynick not letting anything go. Weekend. You don't get a week.
then she can A, issue a report. B, if we need to take a deposition, an abbreviated deposition on the limited subject matter she is not prepared to testify about on today, then we can do that. But the notion of halting a deposition today,
That wasn't
is set
me.
for 3 hours, and then doing a 3-hour deposition during trial, especially after jeopardy is attached, is not what the state would do. Then I respond on page 40, line 23. I'm not suggesting that, Mr. J. I'm suggesting what you just said at the very beginning, which is let's finish. But if she has some supplement, then I would want to take a brief second deposition as it relates to any new diagnosis or opinions. Mr. J responds on line 4. Okay. What I'm understanding her to say is right now, there has been a previous diagnosis of an adjustment disorder in some of the records, and she just needs to review her records to see if she thinks that is the best diagnosis that she would give as opposed to a generalized anxiety disorder. And then the witness says, you essentially flipped that, Mr. J, upside down. You got that backwards. So we go on to page 42. Line 1, Mr. Owens, I agree. And Dr. Werner, just let the state attorney know.
Okay, but we're skipping a massive portion of 41
Okay.
that addresses specifically opinions
Let me go back.
as it relates to generalized anxiety disorder.
Okay, the witness starts on line 15. So she's saying she has the generalized anxiety disorder, and I'm saying I want to review it more. Because Sarah Boone had disclosed to the doctor that she had been previously diagnosed with a generalized anxiety disorder. And so the Dr. Werner was considering that admission, but she was saying, I want to review it more to see if I think it's more of an adjustment disorder to being in jail, Judge, to being in the correctional setting right now, and that the stressors that she is under right now as opposed to a generalized anxiety disorder. So Mr. J says on line 22, okay, so on this topic, if something new comes up, then we can address it. But if you have other topics to depose her on, then I suggest we go on. And then page 42, line 1, that's when I say, I agree, and Dr. Werner, just let the state attorney know. I know that you may be, we are on short time. If you do review your notes over the weekend or whatnot, and formulate any other opinions, just let the state attorney know, and I will address it.
We'll address it.
And we'll address it.
We'll address it.
Line 7, the witness, Dr. Werner says absolutely. And then, do you want me to continue reading, or?
If there's portions you want to highlight for me, I mean, I have the transcript, I'm following along with you.
That was the general understanding that we had about all diagnoses, all opinions that she may have.
You want me to go on reading? What I want, Mr. Owens, is quite apart from what's probably the best thing you should be doing as a defense. I want you to shut up right now and rest this case so we can all go home. But please continue reading the transcript that I have in front of me.
And so she starts talking about the mental status exam that she gave her, and then she page 43, line A, she said,
Just take a quick break here in James Owens' reading of the transcripts to send out. There's a lot of people in the chat that seem to have various personal issues of great personal import to them. So let's just take a moment to send out some healing vibes. Everyone who has energy to give to others, just put it out there. Put out your good energy to the dandy, the fine and dandies that are here in the chat that need a little bit of good energy in their lives. If you've got it to spare, take a second. I'm going to do my stretches while he does his talking. If you've been sitting here watching this stream since I started this morning, you haven't gotten up to stretch, now's a good time. Don't let the blood pool. Get up and stretch a little bit. Do some squats. You'll see me doing that for the next couple of minutes here.
she said she has narcissistic personality disorder traits. Or I asked that question, you know. That's how she answered. She goes through a little bit of that.
She goes through a little of that, then I lost my place, Your Honor.
And then paraphrasing, she talks about the grandiose
Paraphrasing because I lost my place.
component or criteria that she met. And then on page 45, I asked her what other criteria, on line 1, would tend to indicate that she was a narcissist. And the answer by Dr. Werner,
I'll be right back.
I didn't say that she was. I said that she has narcissistic traits. And that was the examples. That
Judge,
was,
excuse me for interrupting, but can we lasso this back into?
I understand that's what the depo reflects, but the non-objection which led to objection pertains to an opinion specifically about post-traumatic stress disorder. And as this time, no opinion is being referenced, nor does the call of the question pertain to narcissistic personality traits or a diagnosis of narcissism. The question pertains to PTSD.
all right, page 46. Line 1, question, okay. Do you feel like she suffers from post-traumatic stress disorder? Line 3, answer. She didn't give me criteria with regards to that. She
Thinking about putting
having
that
fear and
pizza
anxiety
in, so I'm going to pop
of his
upstairs. We'll be
family,
down in
fear
a
that they would come into the
couple
jail
minutes. I
or
know
have
this is a
someone
lot of
else come into
bullshit,
the
so
jail
sorry
for
that
her.
you guys have to
Talk
watch.
about
But I've been
that.
watching all morning, so I get a break too.
And she spoke about, you know,
Take a
having
minute to go put it
recollections,
in, and then
remembering
I
abuse from
need
George
11
during the
minutes to take it
evaluation.
back out again.
Question 13, line 13, on 46. But you don't believe that she suffers from post-traumatic stress disorder, in your opinion? Answer, line 15, no. I would have to look back through my notes to see if she fully met the criteria. Question, line 17, can you explain why you don't think she suffers from post-traumatic stress disorder? Answer, line 19, no. I didn't say one way or the other. I would have to look back through my notes for that. Line 21, question, is that something that you may, in the future, give an opinion about after some time reflecting and reviewing your notes? Line 24, answer, I may. Number 25, question, okay, and that's something you will let the lawyers know about if that changes? Answer, line 2 of page 47, yes. That's specific to the post-traumatic stress disorder.
Okay.
So at the time of this deposition, when I asked her specifically,
So what's the legal objection? What are the legal grounds of the objection?
I would not take that deposition, Judge. When she said, I have not had time sufficiently to answer these questions, these diagnoses, these opinions, if this wasn't set for a definitive date that you had already told me it's not going to be continued, I would refuse to take that deposition. But under the promises from the state,
What
I
are the
would be
legal,
notified of
what are
any
the
change.
legal grounds of your objection? I'm familiar with the background. I'm familiar with the time frame. I'm familiar with all the dates and the depots and the coordination and everything we had to do to get this all teed up before trial. What are the legal grounds of your objection? I understand the backdrop.
I mean, I don't know if there's a legal ground other than we had an agreement as attorneys, as parties, that I would be notified of a change of opinion and I would be allowed to take a second deposition. That's the only thing I know to object to.
Okay.
Because I was not given that opportunity, which was an agreement between the parties.
Response.
Judge, I don't appreciate the implications that they're making. What I would proffer with this witness is, we spoke yesterday. I asked her if she had any change in her opinion about any of the diagnoses. She said no. And I asked, well then, my position, my understanding of her position is that it doesn't matter whether she had PTSD or not, because what Ms. Boone said at the time was that she zipped Mr. Torres up into the suitcase. They were both laughing, and once he was already secured in the suitcase, she became angry and then did all the things that she did.
You get shit sorted out, or no, we're still outside the jury's presence. Okay. In case you're curious, this is the pizza that's part of the lunch menu here at Dan D True Crime Headquarters. Pizza spinaci. Spinaci. You can't say things in Italian without using your hands.
My expected answers from the doctor based on a very brief conversation yesterday and this morning was that if I asked her whether or not PTSD or BSS had anything to do with this particular case, that her answer would be, it doesn't matter because of what she stated
Hey,
happened.
Cora Brooks.
I'm not asking her about her diagnosis of PTSD. I'm not going to be going into narcissism. I'm not going to go into whether or not she ever delineated the difference between adjustment disorder or anxiety, because my understanding of what she told me was that none of this matters. None of this matters because of what she said to us during the evaluation.
But the question was, and I may have to ask Madam Court Reporter to read it back, but my memory of what the question was is, have you formulated an opinion with regard to PTSD?
And my expected answer was, it doesn't matter because of what she said during the evaluation.
Okay.
Just doesn't matter. It just doesn't matter. It just doesn't matter. For people who aren't familiar with that phrasing, the movie Meatballs, starring Bill Murray, used the phrase "it just doesn't matter" to help the loser campers win in the big campground versus campground games. Little Rudy Wanamaker or something. Just doesn't matter. It just doesn't matter.
Unfortunately, that was not the answer that came from the witness. The answer was a definitive no.
Attorney's fault.
I'm not casting blame. I'm just going back over of what was asked and what was said. Okay.
Yes.
Judge, and that's his position, that post-traumatic stress disorder, that doesn't apply in this case, and that he, I'm sure, reflected
Judge, that's his
opinion to
position.
the expert. But that doesn't mean that that's my opinion, that post-traumatic stress does not
Okay,
apply.
that's irrelevant for the purposes of this argument.
Well, their discussions and him feeling like it didn't apply.
Okay, as an officer of the court, he just told me he spoke to the expert yesterday and the opinions hadn't changed. And the opinion that was offered at the deposition was, I'm not sure. And based on what he had proffered as to what he expected the answer to be, the answer was not going to be any different. It's not applicable, it doesn't matter, because of what she told me. That's unfortunately not the answer that was given. So what is it that you're asking me to do at this time, Mr. Owens?
I'm asking,
There we go.
I don't know if we need to proffer the entire testimony.
Okay, so this is key. This is where it goes from, just a bunch of bullshit. We'll wait till it gets to something important. Judge Kraynick is saying, okay, what do you want me to do? So this is his opportunity to ask for a remedy, whether that's to have an objection on the record, whether it's to ask for testimony to be stricken, whatever it is, this is Owen's opportunity to remedy what he's complaining about. Let's see if he takes advantage of that opportunity.
This witness, because opinions and diagnoses have apparently changed. I think I have a right to take a second deposition. before she testifies.
What other opinions, Mr. J, if any, are going to be offered by Dr. Werner?
May I just proffer?
Yes.
All right, you've been present for all this hearing, yes, doctor? Yes. Am I
Oh, just go straight to the doctor. Okay, getting spicy. Let's go, Mr. J.
misrepresenting any of our conversations?
No.
All right. And so if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of the case as the defendant relayed them to you, what would be your answer?
That it's not related to the incident as she reported it.
Okay. And if I ask you, therefore, if there were any prior instances of violence, would that change your opinion? What would your answer be?
No.
And if you reviewed any other materials...
And Rita Schuler, yeah, you're in my head. I'm just seeing your question in chat, and I think we're already addressing it. But I'm curious to know if after today, does this help with understanding the defense appeal make any more sense? Pay attention now, because this is exactly the part that at least is going to, I think, make it clear that the defense doesn't have an argument. But if you read the answer brief, you can at least understand what their argument is. And then the answer brief also very clearly explains why it's not valid. It could have been valid, but for factors that weren't engaged. One of them is Owens not taking advantage of the remedy opportunity. Another is him not asking for, stricken testimony. He complained about it, and then it's like, no, well, I just don't think it's fair, Your Honor. We had an agreement among men.
or materials, would that change your opinion based on what she told you about what happened that evening?
No.
That's it.
Judge, number one, she's given a legal opinion. Number two, it's a discovery violation.
What is the legal opinion?
That post-traumatic stress disorder doesn't apply in this case.
Dr. Harper testified it did, and that's what experts do.
That's what experts
I would like to have
do.
known that, and that was going to be her opinion before today.
That's not a change in testimony. That's
Where is that a change in the
So you're
deposition?
going to have to read the whole transcript. I asked.
No. This is a
He shuts that down immediately. Judge, you're going to have to read the whole transcript. No. No. Mr. Owens, there's a lot of different ways we're going to go down this rod. That's not one of them. And yeah, I said rod, not road, because I'm trying to get my southern in. I know that from Pet Cemetery. You don't want to go down that rod. Don't go down that rod.
what experts do.
I would like to have known that, and that was going to be her opinion before today.
That's not a change in testimony. That's
where is that a change in the
So you're going to
deposition?
have to read the whole transcript. I asked.
No. This is a 87-page transcript. You're objecting. You have the burden to establish your objection.
Give me a minute. I'll read through it. and
Give me a
find
minute. I'll read it.
Where I asked her.
Fine, Judge. You're not going to read the 87-page transcript. I'll just quickly read it here, and then I'll ask you.
I mean, this isn't the first time I've looked at this deposition. The state provided it to me when we had the hearing on whether or not battered spouse would be permitted. And the state provided specific highlights for me to look at. At no point in time did the defense say, look at this, look at this, look at this, in her deposition when we had that hearing. So other than what's being provided to me right now,
Problem is, Mr. Kraynick, he's not listening to you because he's reading an 87-page transcript in 23 seconds.
and what's been testified to this morning, I don't know what opinions she has. All I know in coming into today is what the basis of her opinion was, specifically with regard to any of the statements that Ms. Boone had provided, which was the whole crux of the state's motion to prevent battered spouse from coming into evidence.
Judge, if you look at page 66.
Impressive. You got to page 66. Let me know when you're there, Judge.
Hang on. Yes, sir.
Page 66, line 20, question. Okay, so other than the couple of hours that you intend to maybe reflect on your notes and anything else, any other work that you intend to do on this case? Answer, 23, no, sir, not that I'm aware of. Line 24, question. And you've expressed all your opinions, at least generally here today. Answer, page 67, line 1, yes, sir. Question. Then I go into fees.
Super Kelly G posits, maybe if Owens wore his glasses in a proper place on his head, it would be easier to see through the frames.
Then on 67, line 7, question. Just double dog sure.
If you want to know what we're talking about, on a previous episode of the Sarah Boone Trial Rewatch show, we noticed that Owens wears his glasses probably about an inch above his ears. If you're watching right now, you'll see Kevin Beck is also wearing glasses that appear to be hooked around the ears themselves, which I think is the normal wearing position. But Owens has a couple of marks in his head. If he's not wearing glasses, you can kind of see where the glasses go. He's probably been wearing glasses up there so long, he's built in a little indentation.
You admit that you have no other opinions other than the ones you've expressed here today.
Oh, and so Rita Schuler, I will opine, I don't think she did anything wrong. So I'll just be real clear, and that maybe will make it easier to watch the testimony going forward. I think Owens was looking for something that could be an appellate issue and basically knows that the case is lost at this point and was trying to get an appellate issue on the record. So he's, there's not many kicks at the can left, right? The state isn't calling any more witnesses, I don't think, after this one. So this is his kind of Hail Mary pass kind of opportunity to get something on the record that might be an appellate issue in the future. And there is a rule that says, if you testify, you do a deposition. The deposition, you answer all the questions the other side says. And then through motions in limine, you decide what comes in or what stays out of the actual trial. And that's decided by the judge on, case by case basis. And we've watched some of that in previous episodes. I think here it's just so close. So she said, I don't know. And then in this case said, oh yeah, well that's a trait of this. Your opinion changed. That's a change, huh? That's a change. You're not allowed to change. And while technically it's true, you're not allowed to change your testimony, or if you do, it's impeachable or whatever. And again, I'm not speaking this as a legal expert, just my understanding. It is grounds for, hey, what are you doing? But then Kraynick does, I think he goes above and beyond, if I may please, above and beyond in remedying the issue. He offers an on-the-spot, hey, ask her anything you want outside the jury's presence, and we're going to watch that. Ask her anything you want, James. What, here in court right now? Yeah, right now. This is your chance. Ask her anything. So right off the bat, that's great because there's no surprises. He can ask her everything, set up the questions he wants to answer, and if she answers them differently than how she had them in court, clearly that's a change of opinion from her deposition to her testimony and would be grounds. But if he thinks that there's something he didn't ask, and that's what it's really going to come down to, is he just asks a catch-all question at the end of the interview. Is there anything else that you know about Miss Boone that you might testify about? No. If you do think of anything else, will you tell us? Yeah. And that's what he asks at the end, and that's what he, at the end of the day, that's his sticking point. I asked her if she had any other opinions. But you can't just, oh, well, I didn't know I had that opinion, but now that I've been asked the direct question, do you think she possesses 3 or, 5 narcissistic traits? She can at least opine on it. That doesn't mean, just because you didn't ask that question, it's not her fault. So long answer to a short question, Rita Schuler, I don't think she did anything wrong.
That I've been asked about. If I'm asked something else, that I'll offer it. Number 12. Question. And you've been provided all the resources you need to rely on and express your opinions.
Be right back. I'm getting my pizza.
Answer. I have based an
Be slicing it. It'll be like 2 minutes.
That I've been provided. If there's other things out there to be provided that may or may not change my opinion. I believe it's a discovery violation because I should have been notified there was going to be a change in opinions here today. And we had an agreement that I was going to be allowed to retake the deposition and not be ambushed in the middle of the trial with a new opinion.
What new opinions are different based on what Mr. J proffered the testimony is going to be?
I'd have to ask Madam Clerk to reread the question and the answer from the expert. It's been so long now.
Madam Clerk, or Madam Court Reporter, are you able to reread the portion of the proffer as to what Mr. J asked of the witness? Absolutely. Of course.
Somebody get kicked out?
Court's going to step off for a moment while Madam Court Reporter is able to provide that readback.
This is what the finished pizza look like. All right, so I got back just in time for them to say goodbye. Court reporters picking up the transcript. Oh, so this is where they're going to really outline exactly what the issue is with what Tanya Werner's original testimony is based and compared to what her testimony was today. So skipping ahead, saving our time. It's took almost exactly 15 minutes.
CF 2603, State of Florida versus Sarah Boone. State.
Dave Castro on behalf of the state.
William J. for the state.
Defense.
James Owens for Ms. Boone.
Kevin Beck on behalf of Ms. Boone.
Ms. Boone is seated at counsel's table wearing the same clothing from this morning. Madam Court Reporter, have you had the opportunity to review the transcript as to the proffer of Dr. Werner's testimony? Yes. Okay, you may proceed.
I think this is going to be the court reporter. Yeah, so it's a little quiet. I'm going to put the captions up on screen and make sure that the captions are visible on my final screen layout here.
Doctor, answer, yes. Question, am I misrepresenting any of our conversations? Answer, no. Question, all right, so if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of this case as a defendant relayed them to you, what would be your answer? Question, that it's not related to the incident as she reported it. Question, okay. And if I ask you, therefore, if there are any prior instances of violence, would that change your opinion? What would your answer be? Answer, no. Question, if you reviewed any other materials, would that change your opinion based on what she told you about what happened that evening? Answer, no. Question, all right, that's it.
I don't think that's the very beginning.
Dr. Etker's Ristorante Pizza Spinaci.
What was asked was to read back the proffer.
I thought I was asking to go back to the very beginning when the question was asked.
No. So they spent 15 minutes. Court reporter prepared, read back the proffer, and then James Owens says, "No, I thought you were going to go back to the beginning of the transcript."
Asking her response and my objection to it.
What was specifically asked was to the proffer, because the question before the court was whether the proffered opinions are at odds with what was testified to during the course of the deposition. There's the question that was asked and the answer that was given affirmatively provided an opinion as to PTSD. I think Mr. J admits that. Mr. J has advised the court that's not what he was hoping the answer would be. That the answer was supposed to be something different, as identified in the proffer, which is why I had Madam Court Reporter read back the proffer. So the question Mr. Owens posed to you is whether the proffered opinions that Madam Court Reporter just read back to us are different than what was provided in the deposition.
Yes.
How so?
Yes.
She tended to explain in the proffer some legal reason why it did not apply in her opinion. That was not discussed in any way in the deposition.
Okay. My question is specific as to opinions. Her opinions were as to battered spouse syndrome or post-traumatic stress disorder and their relationship to the case based on the defendant's responses. The answer is not related to the incident as the defendant reported. Those are the opinions, as I understand them based on the proffer, as it relates to battered spouse syndrome and post-traumatic stress disorder.
Flip those pages, James. You'll find it. Shame Sarah didn't organize your documents in between the break. James Owens is like alchemy. He's trying to conjure up the page that's missing by flipping the other pages fast enough. Where's the one I need? Come on, make it appear. Make it appear. Forward 3, back 7, forward 3.
I think I'd refer to page 46. Line 13 was the question, but you don't believe that she suffers from post-traumatic stress disorder in your opinion. Line 15, the answer is no. I would have to look back through my notes to see if she fully met that criteria. Question 17, can you explain why you don't think she suffers from post-traumatic stress disorder? Line 19, answer no. I didn't say one way or the other. I would have to look back through my notes for that. Question number 21, is that something that you may, in the future, give an opinion about after some time reflecting and reviewing your notes? 24, I may. 25, okay, and that's something you will let the lawyers know about if that changes. That's on page 47. Line 2, yes.
Yeah, you just read that in the sidebar before the break.
That's fundamentally, substantially, materially different from what she's testified as it relates to post-traumatic stress as it applies in this case.
In the proffer?
Excuse me?
In the
Welcome, Greg. Greg's late, but good news, Greg, we're going late. I thought this was going to be a shorter one by whittling it down to just the 2 witnesses. But I forgot about how much substantial commentary we're able to digest together about the impact of both these witnesses. Julie Harper, for the amount she gets discussed in the case, was really only on the stand for a short amount of time. I think it's the fact that she shows up again for the sentencing that cements her position in Sarah Boone lore. But I think Michael Brannon, on the rewatch, much more interesting testimony. I'm much more interested to find out more about Michael Brannon based off of watching his testimony. And then we have Tonia Werner here, who barely has been able to testify. She's gotten in about 10 or 15 minutes. It's all this complaints about her testimony that is the feature of today's show.
proffer? She's not rendering unless I misunderstood the proffer, she's not rendering an opinion on PTSD and whether or not Ms. Boone suffers from it.
Well, she led me to believe that she was trying to decide whether or not Sarah Boone suffered from post-traumatic stress. Now in the proffer, they're claiming that post-traumatic stress does not apply. I don't know what the initial question was. We haven't had that read back. When it was first going on, when a question was asked, and I believe she rendered an opinion And I, again, like that to be reread back, what the initial question was, what the response was, because it didn't, I know I objected, I can't even remember it now, but I know I objected because I knew it was inconsistent.
I know I
You asked to
objected.
approach, and then you explained that the question was, it was not something that was framed in the deposition. Multiple times I asked you for a legal objection. And it wasn't until right before or right after we sent the jury out that you provided some legal objection. You know, Madam, if you want Madam Court Reporter to go back and read the question that led us to where we are right now and the answer, I'm totally on board with that. I have a memory of what it was, but nothing like.
Before she does that, can I get the first question of the proffer if BSS or PTSD has
Before.
reread that so I can.
Let's just reread the entire proffer, just so that it's a clear soup to nuts, alpha to the omega, what the.
Okay, chat, you got to help me with these. How many of those two phrases, how many of you are familiar with that? I think I've heard soup to nuts. I don't quite understand what soup to nuts as a cliche is representing. I just don't. I think I've just heard the words together, but don't. Alpha to the omega, I get that. That is sort of like the beginning, the end, and everything in between, the alpha and the omega. And is it just a translation of soup to nuts? Just so it's clear, soup to nuts, alpha to the omega. It's funny, too, that I get the alpha to the omega reference, but have trouble with the soup to nuts one. We all learn in different ways.
You know, Madam, if you want Madam Court Reporter to go back and read the question
Thank you,
that
Suze.
led us to where we are right now.
Suze what? Classy. Soup to nuts is formal dining. First course, soups. Nuts is the last course. When do you have D's nuts? Final course.
The answer, I'm totally on board with that. I have a memory of what it was, but nothing like.
Before she does that, can I get the first question of the proffer?
So soup to nuts, beginning to end, alpha and omega, beginning to end. And it's like two analogies. It's like, okay, if you don't get the super literary alpha to the omega Latin references, then you've obviously had a lovely meal that started with a fine soup and finished with some lovely nuts. These nuts.
Proffer if BSS or PTSD has any, can you reread that so I can.
Let's just reread the entire proffer, just so that it's a clear soup to nuts, alpha to the omega, what the proffer was. Madam Court Reporter, if you could be so kind. Yes, ma'am.
If I had to guess, I would have thought soup to nuts meant some sort of ashes to ashes, dust to dust thing, and that soup somehow becomes nuts. But
Yes, Roger. Answer, yes. Question, am I misrepresenting any?
thank you, Hairball Yarn. Alpha and Omega are Greek, not Latin. The smart crowd we've got here. It's a lot of, if not A students, they're the B students that, you know, had other fun things to do and still were getting good grades. I think there's a lot of B+ students here.
Of our conversations? Answer, no. Question, all right. So if I ask you about battered spouse syndrome or
SKR's going live tonight.
the facts of this case.
Super Kelly G, give me more information about that, because that will definitely impact the time that I decide to go live, if I decide to take the night off even. Maybe I'll do a Saturday night live and I can come in right after SKR finishes.
As a defendant relay them to you, what would be your answer? Answer, that it's not related to the incident as she reported it. Question, okay.
All right, I have SKR's live reported at 9:30. Is that 9:30 Eastern Time, 6:30 on the West Coast?
And if I ask you, therefore, if there are any prior instances of violence, would that change your opinion? What would your answer be? Answer, no. And question, and if you reviewed any other materials, would that change your opinion based on what she told you about what happened that evening? Answer, no. Question, all right, that's it.
And then if she could go back to the initial.
So Owens is really grasping at straws here. I feel like every time I can chirp in with a comment, he's going to start talking, and I don't want to delay this too much. We have somebody who is authentically Greek in the chat. Yasu. Yasu. Why is this happening? Okay, well, I'll just do an Owens impression until Mr. Owens comes back, because even Judge Kraynick finally ends up going, Mr. Owens? Is that really right? No, we just did that. I've lost my way. Sitting here holding the rest of my pizza like a waiter, just with the hands in the servers. Okay, no, maybe that is all just waiting. Mr. Owens? Number one, that question and answer, she gave a different opinion than what she gave in her deposition, which is subject to the agreement.
Oh, I was waiting on you. Please, go ahead. Sorry. Pay no attention to me.
What was that?
Go ahead. My
Okay, something just happened there, and I was too busy doing my own thing to fully appreciate it. 15209. It seems like everyone in the court was just waiting for Judge Kraynick to address them. And he's like, oh, no. You do what you got to do. Because I think he was waiting for the court reporter, and the court reporter was waiting for him. Let's see what happened here. Let me just rewind the silence so we don't miss any of that coverage of silence that was on immediately before the part that we're reviewing. Okay, I think we're about 10 seconds away. What the hell happened?
Are you ready now to go report?
Oh, I was waiting on you. Please, go ahead. Sorry. Pay no attention to me.
That's exactly it. Oh, I was waiting on you. No laugh from Sarah, though. She's, her humor for this trial has passed.
Go ahead. My understanding is it was the question and the answer right before Mr. Owens asked to approach.
Question, what was your opinion? Answer, my opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
Can you read that for me one more time, please?
The answer.
Both the question and the answer.
Question, what was your opinion? Answer, my opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
May we please have the previous question as well?
Question, and in this particular case, did you require any additional information to reach your conclusion about the relationship between battered spouse syndrome and the events of this evening? Answer, I based my opinion on the information that I had. Certainly, if there was more information, my opinion would be subject to change. Question, what was your opinion?
Mr. Owens?
Number one, that question and answer, she gave a differing opinion than what she gave in her deposition, which, subject to the agreement we had, I should have noticed. Number two, with the proffer, it seems that she's going to find that post-traumatic stress disorder did not apply to the facts as related by Sarah Boone. And that is an opinion that I needed to know about. And I asked throughout this deposition and at the very end some general, if you have any new opinions or anything new that differs from what you've said here today, please notify the lawyers or words to that effect. So it's an evidentiary issue. I've got a right to be prepared for the trial through discovery to know what the witnesses are going to opine. And this is a discovery violation based on two things. One, her initial answer to the question that I objected to, and then two, the proffer is a new opinion. It's a discovery violation. I ask that the witness be stricken.
Any response?
Judge, I think it's clear from my original question that the intent that I stated was the intent of my question, to get the answer that I intended to get, was what the question was intended to elicit from the witness. As far as the discovery violations and continued attacks, I'm just not I'm not convinced he understands what the answer means or what it's going to be. The answer isn't going to be Ms. Boone didn't have.
Not convinced he knows what the answer means. Mr. J has had it with James Owens.
PTSD, hence, therefore, battered spouse syndrome doesn't apply in this case. Mm-hmm. What I believe she's going to say, and what I believe I've been saying she's going to say, based on our conversations, was irrespective of whether anybody believes Ms. Boone had BSS or PTSD, it is irrelevant because of what Ms. Boone told her.
Irrespective is a great word. Anyone who uses irregardless, substitute irrespective if you want to sound smarter.
Happened at the time of the event. That is not a discovery violation. She was specific in saying, if you have any questions you want to ask me, I'll give you an opinion. That is exactly what she said on page 67 of the deposition in response to a question that starts at line 7. Question, just double dog sure, you admit that you have no other opinions other than the ones you've expressed here today. Answer, that I've been asked about. If I'm asked about something else, that I'll offer it. They didn't ask about the interplay of the facts with the relevance of the syndrome. That's them, not the state.
Any other argument?
The totality, if you read that deposition and all that we talked
I
about.
specifically asked you, Mr. Owens, to point out for me
What?
excuse me, I specifically asked for you to point out specific portions of the deposition that are at odds with either A.
James Owens is not afraid to interrupt the judge, which is crazy to me.
A, the opinion that was previously given, or B, what was proffered to. You have provided me pages 45, 46 of the deposition relating to specific opinions on whether or not Ms. Boone suffers from post-traumatic stress disorder. Are there any other portions of the depo that you would like to point out for me? I am not going to read an 87-page deposition and continue to waste our jurors' time as we try to find a solution for the situation that is now before us. If there are specific portions of this deposition that are at odds with the opinions that have been proffered and or provided so far, I would ask you to direct my attention to them.
Well, the ones that I expressed.
Other than what you've already identified.
The ones that I expressed and that.
Other than the ones I've identified. The ones I expressed, like, why would you repeat it immediately? You talked over me, Judge, so I'm going to say it again. The ones I've already said.
Just the understanding that we had that she, in the pages that I had talked about previously here today, in the pages that I referred to about our agreement, that she was going to let me know if there were any opinions that she had in addition to the opinions.
This is Judge Kraynick's poker face position when he doesn't want to give off his emotions. He doesn't want a read. He puts his hand in front of his mouth, and then he just dead eyes stares you like, okay, I asked you to tell me anything that you haven't told me that you want me to consider for this decision. And all you're doing is repeating yourself now a third time.
She gave in the transcript.
Okay. All right, thank you. All right. Any other argument, Mr. J?
Nothing.
Okay, thank you very much. All right, the court has had the opportunity to listen to the proffer as read back by Madam Court Reporter, the read back of the opinion that was previously offered, the portions of the deposition which have been highlighted by the defense specifically pertain to opinions by the defendant as to whether or not the defendant suffers from post-traumatic stress disorder. That opinion is not being offered. The opinion pertains to the relationship of battered spouse syndrome and or PTSD as it relates to the facts of the case as the defendant has relayed them to you, and that they are not related. However, the deposition is identified by the defense, identifies that if there were any additional opinions, that there would be notification. So the court at this point in time, as there has been an alleged discovery violation in accordance with binding precedent by the 6th District Court of Appeal, which is binding on this trial court in Young v. State, 369, Southern 3rd, 1243.
369, damn thing fine.
At pinpoint 1248, the court is now going to conduct a discovery violation or discovery Richardson hearing. State any other arguments with regard to the elements of a Richardson hearing?
No, sir.
Okay, thank you. Any other arguments with regard to the elements of a Richardson hearing, Mr. Owens?
Mr. Owens doesn't know what's happening right now. Hold on. Richardson's coming for a hearing? I don't even know Richardson.
No, other than I understood she did give an opinion about post-traumatic stress in that initial series of questions.
Okay.
And I remember giving a lesson on Richardson hearings, and I don't remember too much of the lesson. But basically, there's a few different factors. When a discovery violation is alleged, the judge is bound by appellate law to have a Richardson hearing, which kind of investigates, not kind of, does. Basically, was there a violation? Kind of on the same slippery scale as an overt act. If, there's the barest scintilla of a violation, you consider it a violation. Then you consider the scope of the violation. Was it inadvertent? And did it materially affect the defense's ability to prepare for the case? And that's going to be the one aspect that actually sticks as far as Judge Kraynick goes on this, is that it's possible to argue if James Owens knew that she would say this, that he might have a different line of questioning, which is why he offers the chance for an in-court deposition so that Owens can prepare exactly whatever line of defense he thinks is necessary based off of the deposition that we'll watch him. He does it on the fly.
All right, the court, again, reviewing the proffer and the opinion, finds that the state's violation was inadvertent based on the proffer by the state, which was agreed to by Dr. Werner as to the conversation they had last night, as to the opinions and whether or not that they had changed. However, I do find that that violation is substantial with regard to the opinions based on the testimony in Dr. Werner's deposition that any other additional opinions would be notified to the defense. As it relates to the third category, the effect on the defendant to properly prepare for trial. Although the questions in the deposition as highlighted by the defense so far do not address the opinions being currently offered, I do find that it had some impact on the ability for the defendant to properly prepare for trial. As it relates to the opinion that was previously provided as read back, specifically, my opinion was that she did not give enough information to diagnose her with PTSD at the time of the evaluation at the jail. What is your position, if any, with regard to that opinion now that the jury has heard it? Mr. Owens. Because my question is, do you want it struck?
Key, right here. What's your answer? Struck or not struck? Struck or not struck, Mr. Owens? 5
On
seconds.
that issue, we'll will address it on cross-examination.
So you do not want it to be struck, and you do not want a curative instruction.
Well, I'm going to question her about post-traumatic stress, so it's going.
No. This, if you've been hanging on for the stream, waiting to learn about the appellate argument, right here. One of the issues wasn't preserved for appeal because when Owens had the opportunity to ask for the evidence to be struck, he did not take it. You can't refuse a curative motion and then claim that you were harmed by it. You can't invite a misapplication of the law in your trial and then appeal your case on the fact that that it happened when you had the opportunity to object to it. You can't just oh well, we could object to that, but we're going to let it in so we can appeal it later. That's not allowed.
Come out through my cross from the deposition about what she said, and then it's inconsistent with what she said here today, so I'm going to want to rely on that question or that answer.
Okay, all right. Ms. Boone, have you been paying attention to the questions and answers and the readbacks of both the proffered testimony and the opinion testimony?
Yes.
And are you on board with the strategy not to seek to strike that opinion?
Yes.
Thank you. With regard to the proffered testimony, I'm going to permit now in open court, and I will oversee the deposition for you, Mr. Owens, to inquire as to those opinions.
I'm sorry?
With regard to the proffered opinions, the court will oversee a deposition now,
I'm sorry.
and you may proceed.
Now?
Yes,
Yes.
with regard to the proffered opinions.
I love the way he says yes there. It's one of my favorite moments of the whole trial for just such a simple thing. But now? Yes. So we're going to go back and enjoy that one more time. 204. Because, yeah, Owens has no idea, like, I argued I didn't expect to win. You did win, and now do your deposition. Now? Yes.
With regard to the proffered testimony, I'm going to permit now in open court, and I will oversee the deposition for you, Mr. Owens, to inquire as to those opinions.
I'm sorry?
With regard to the proffered opinions, the court will oversee a deposition now, and you may proceed.
Right now?
Yes. With regard to the proffered opinions. And I believe that will provide a cure for the discovery violation under the Richardson violation based on your request not to strike the prior opinion. And since you're going to utilize that on cross, I find that the prejudice is limited. But with regard to the new opinions, I will give you the opportunity to depose her now, curing the prejudice at that point in time. You may proceed.
Dr. Warner,
Yes, sir.
good morning.
Good morning.
Dr. Warner, good morning. It's too late for a first impression, James, but nice try.
At some point, the state attorney notified you that you were to come today.
Correct.
Did you and the state attorney have a discussion about your testimony?
Yes.
When was that discussion?
Briefly last night.
So y'all talked on the phone last night?
Yes.
Have y'all had any discussions since the phone conversation last night?
Briefly this morning.
And how long was the phone conversation?
Less than 5 minutes.
How long was the face-to-face conversation?
Less than 5 minutes.
And just for people who they're unaware of the court process, I'm only moderately aware myself, but the deposition is just your chance to sort of surface facts to the top. The jury's not here. Usually you depose a witness outside of the court, but this is an on-the-spot remedy that's being given. But it allows you as the opposing side to both surface information that you've been wondering about, that you want to get an answer on the record, but also to help you prepare for the questions you're going to eventually ask in court, because you'll know, okay, when I asked her this, she said this. So then I'll ask her this, lead it into this, and then I can ask her about this, and I can challenge her based off the answer that she gave earlier. So that's what Owens should be doing right here. I think Owens, this is again just my opinion, but I think he's on the spot, and I think he's just asking conversational questions to not look like he doesn't know what he's doing in conducting a deposition.
Did y'all discuss that your testimony would be that you did not have enough information that you gathered from Sarah Boone to form an opinion as to whether or not she suffered from post-traumatic stress disorder?
Correct, that my opinion hadn't changed.
I'm sorry?
Yes, that my opinion hadn't changed, that I didn't have enough information.
Okay. And did the state attorney speak to you about that it didn't matter whether you had an opinion if you didn't feel like the facts that Sarah Boone had given you as it relates to the facts and issue in this case, that you didn't, if you didn't feel like post-traumatic stress even applied, then you could answer that way?
Correct, that was my opinion, correct.
But did he present that to you initially for you to form an opinion about it?
No, my opinion was that it didn't apply because of the way that she described the incident to me.
Was that your opinion back when I took your deposition?
Yes,
When did you form that opinion?
when she described the incident to me.
Just a heads up, I did a little scrubbing ahead, and it looks like she's still on the stand for 3 more hours. Now, an hour and a half of that is the lunch break, so still an hour and a half. In any case, I may make an executive decision to cut the stream off at the end of the Mr. J questioning, and then we'll start off the next stream with the cross-examination and the rest of the rebuttal evidence, which will take us from the 4-hour mark of this stream right to the 9-hour mark of the stream that we're in. So that's 5 hours plus commentary. That in itself is probably, 6 to 7 hour stream. So that's enough for next Friday. We'll see how it goes, but brace yourself. We could be leaving in as soon as 2 hours.
Why didn't you let us know that was your opinion at the time that I took your deposition?
You didn't ask me about that, sir.
Do you remember me asking you any other opinions that you may have as it relates to this case?
You didn't ask me specifically about that.
I understand that, but you're saying you formed that opinion prior to the deposition, correct?
Yes. The state attorney and I discussed that on the way out of the jail, as a matter of fact.
After the deposition?
No, sir. After the evaluation.
Okay.
On the way out of the jail.
All right, and I asked you, were there any other opinions that you may express at trial after you had discussed that with the state attorney prior to the deposition? Is that correct?
Yes.
And so you were aware that I didn't want to be ambushed at trial. I wanted to know any and all opinions that you may be expressing in the Sarah Boone case.
I didn't know what specific information you wanted, sir. That's why you had a deposition. I answered your questions. I don't know what all information you want me to provide to you.
So because I didn't ask you specifics, you felt like you didn't have to respond specifically.
No, sir, I answered all of
What a weird question right there. Because I didn't ask specifics, you felt you didn't have to respond specifically. Yeah, ask general questions, get general answers. What did you think was going to happen there, Owens? Because I didn't answer specifically, you thought you didn't have to answer specifically?
your questions. And as I said, I'm happy to answer any questions that I'm asked. I don't know what questions you want me to answer.
But you know that this was a central issue in the case. Did you not? Your opinion
Yes.
is relating to a central issue in this case.
Correct?
You're aware Sarah Boone's on trial for murder.
That's
And you had this opinion when I was taking your deposition, and I was asking you specifics about any opinions that you may be expressing in the trial of Sarah Boone, and you did not disclose it.
Well, I told you that I would answer any questions that were asked of me. I have a number of opinions. I know that I don't feel that she's suffering from major depressive disorder. I didn't offer that opinion either. I have a number of opinions.
That's all the questions I have.
That's it. That's it. Look at her eyes, too. Really? You spent an hour and a half to argue for a 12-minute deposition? I don't believe he even asked her the question that he is upset that she didn't answer. Like, You didn't ask me about battered spouse. And then he doesn't ask it again. That's it. No more questions, Your Honor.
Mr. J, anything else?
I'm just making sure he doesn't want to inquire.
Mr. J is like, I'm just making sure. I don't even remember this. Maybe I do from, just subliminally. But I think Mr. J is trying to help out Mr. Owens. Like, you just made this whole fuss over not being able to ask this question. Maybe you want to ask it for your deposition.
This is your opportunity, Mr. Owens.
Because that was more just about.
Inquire about what?
This is your opportunity.
Inquire about what? Yeah, okay, so I'm on point. Mr. Owens has no idea what's going on. Is still Richardson here? I'm representing Sarah Boone, Your Honor. Who's this Richardson fella?
To inquire. You are conducting a deposition. This is your opportunity and your only opportunity to cure any prejudice that we've identified with.
Talking almost like Owens is a child. You are conducting a deposition. This is your opportunity and your only opportunity. And this is why I think, again, the appeal has no legs. Like, I think when they look into the meat of the transcripts in the case and see this kind of like, oh, the lawyer was given a lot of opportunity to cure this, and he seems to have squandered it.
Conducting a deposition. This is your opportunity and your only opportunity to cure any prejudice that we've identified with regard to those proffered opinions as it relates to the relationship of battered spouse syndrome and or post-traumatic stress disorder as proffered.
The problem is now, Judge, is I've got my expert, and we weren't aware, you know how in these type cases, the experts are allowed to listen to the testimony of the other experts and read the depositions of the other experts. Dr. Werner, were you given the opportunity to read Dr. Harper's deposition?
I was.
It was.
I mean, that's standard operating procedure in these type cases, and now I'm taking a deposition on the fly, and then I haven't had a chance to speak with my expert about those opinions and whether or not that would change her opinion. It just puts me in a very difficult situation, but if I'm ordered to continue the deposition, I will.
That's your decision.
If I'm ordered to continue the deposition, I will. Look at him gripping the podium like he has no idea what's happening right now. He's like lost in the weeds and trying to figure it out on the fly, and maybe that is, the best well, no, it's an argument maybe for ineffective assistance of counsel that he didn't know how to respond in this situation.
It's not an order. I'm just saying that this is the opportunity to cure that Richardson issue. You asked previously to strike the expert. I am disinclined to do that. The case law says that is an extraordinary remedy, one which I am not going to permit.
He was also offered the opportunity to strike the testimony and said, no, Your Honor.
Dr. Werner, you realize you're in a courtroom.
Yes.
And we're waiting on the jury on.
I'm going to start asking her the Dr. Harper question. You realize you're in a courtroom? Yeah. You realize you're under oath?
The trial of Sarah Boone.
Yes.
Are there any other opinions that you intend to express in this trial that you have not disclosed to me in the deposition, or you have not disclosed here today under oath?
I'm happy to answer any questions that I'm asked.
Are you refusing to answer my question about any other opinions that you intend?
I love the, not quite an eye roll, not quite, but disdain, all kinds of disdain. Like, you refusing to answer my question? No, I'm telling you, if you want to know about my opinions, ask me about the issues. Don't just ask me if I have any opinions. Like, should I start alphabetically, chronologically? I like breast milk.
To express here today as it relates to Sarah Boone, who was on trial for murder
Sarah Boone.
in the second degree.
Judge, I'm going to object. The catch-all
Sarah Bruin. Sarah Bruin. Bruin is a bear. Drunky the bear. Sarah Bruin. Sarah Bruin.
vague question that Mr. Owens wants to ask this expert witness about any and all opinions she may or may not have, 99 out of 100 attorneys would come in here and say, that's not how you do depositions with expert witnesses. You have to ask specific questions. Anytime you ask a question like that of an expert, the expert is always going to say, please ask me a specific question. And that's what she did then. That's what she's doing now. It's unfair and vague to ask somebody, tell me every opinion you have.
There we go.
Judge,
Yes, sir.
we're in the middle of a trial. She's fixing to testify. She's had conversations with the state attorney.
Judge, we're in the middle of a trial. You think of a more condescending thing to say to a judge?
She knows what she's going to be asked in terms of opinions that she's going to express. That's why she's here, to help the jury understand the science that relates to the law and express opinions. I mean, for me to ask, we're playing hide the ball here? In the middle of a
Playing hide the ball here?
trial?
I disagree that there's any hiding of the ball. There's been a proffer that's been read multiple times as to the scope of the opinions regarding to battered spouse syndrome and post-traumatic stress disorder and its relationship to the facts of the case as the defendant represented them. And the answer is they are not relatable to the incident as relayed by the defendant. That is the opinion that have been proffered.
All right, can I continue with my deposition?
Yes, sir.
Dr. Werner, do you recall expressing that you wanted more time to reflect as to whether or not Sarah Boone suffered from post-traumatic stress disorder?
Yes, that I was going to review my notes to see if I had enough information in there to support or negate that.
All right. What additional information would you need for you to express an opinion that she suffered from post-traumatic stress disorder?
So she did not give me information regarding the presence of intrusive symptoms. She didn't give me information regarding persistent avoidance. She didn't give me information regarding alterations in arousal or reactivity.
Anything else?
Yeah, I'm not surprised, but Sarah Boone was probably uncooperative for her interview.
No.
Would you agree you failed to ask her those questions?
I asked her if there was any other important information that she felt like she needed to share with me at the end.
Zing! She asked the same question that Owens asked her. Is there any other information? That kind of catches it all. Back at you, James Owens, 3-point back.
End of my evaluation, and she said no.
So a catch-all question.
Correct.
Just like you asked me at the end. That's why we're here now. She's so much smarter than Owens. She knows that she did that and he just walked into it like walking the dog.
Are there any other personality disorders? Isn't that what you do as a psychiatrist? You diagnose an opinion, express opinions about whether people suffer from personality disorders?
Correct.
Are there any other personality disorders that you have formed opinions about Sarah Boone that you intend to express?
No.
So, narcissism, you did not find.
I found narcissistic traits.
In terms of your opinion that she suffers from narcissistic personality disorder.
No, sir, I said narcissistic traits.
Okay. So you don't have an opinion that she suffers from narcissistic personality disorder.
Correct. She displays narcissistic traits.
You expressed an opinion that she suffers from alcohol use syndrome,
Alcohol use disorder.
alcohol use disorder.
Correct.
Is that still your opinion?
Yes, it is.
Anxiety disorder. Is it your opinion she suffers from the anxiety disorder?
No.
Do you recall in your deposition indicating that you felt like she suffered from either anxiety disorder or adjustment disorder?
That's correct.
And you've changed that opinion now?
I have, I'm leaning towards the adjustment disorder secondary to her legal situation.
So you haven't formed an opinion as to whether or not she suffers from general anxiety disorder or adjustment disorder?
Correct.
You agree that she suffered from trauma as it relates to the domestic violence history that she expressed to you from the intimate partner violence with George Torres?
Yes, as reported by her, yes.
As
Do
reported
you
by
have
her.
anything to dispute that?
No.
In your opinion, does she suffer from any form of psychosis?
No.
Oh, did I miss? Barry Adams make it rain? Barry Adams?
Is it your opinion that Sarah Boone suffers from acute stress disorder?
Barry Adams. That's 5. That's 10. He didn't stop there. 20. Dan D. True Crime Gift Memberships. All courtesy of Barry Adams. Thank you, Barry Adams. If your name is Michelle Fournier, Jewel Von Mayhem, Red That Sun, Red That's me. Red That's me. It's like figuring out license plates sometimes reading names. Red That's me. Ace 125 21. It's Not Fair. Tracy Clifford, MC Shan, Cajun Nana, Anne Fran Mitch, Cassandra 2, Carolyn Blitt, Vancy Makes Me Dancy, Yancey Makes Me Dancy, Paintbox Tunes, who was in the chat earlier. That'll be a nice surprise when they come back. West Coast Mesh Fighter, Flagrant Contravention. Short King Reacts, SKR himself. Going live in a couple hours, just getting a notification that he's received a gift membership to Dan D True Crime. Well, congratulations, Short King. Welcome. Choose you. California violinist, Pam Adams, and Mrs. Kravitz, Lenny's mom, here in the chat, final recipient of that very generous gift membership, the package of gift memberships from Barry Adams. Thank you, Barry.
No.
Is it your opinion that Sarah Boone suffers from intimate partner violence?
Yes, I think that there is enough history of the volatile relationship between the two of them.
Because of that, do you believe that Sarah Boone suffers from battered spouse syndrome?
She may meet the criteria for that.
May.
So
It's possible?
Yes.
Is that your opinion?
Yes.
Definitively, you can't say?
Definitively possible.
There's a history of her having that, yes.
So you agree she suffers from battered spouse syndrome?
Yeah.
I believe we've covered anxiety disorder, narcissism, battered spouse syndrome, and alcohol use disorder. Are there any other opinions that you intend to express as it relates to that or any other psychological condition of Sarah Boone?
No.
That's all the questions I have.
Okay, so did that solve it? Did you get everything on the record you wanted, Mr. Owens? Because that was your deposition.
Any other arguments at this time?
No, Judge, just the one I've already made.
Okay, all right. The court has conducted its Richardson hearing and made its findings. The court, as previously identified, will not strike the expert, as that remedy is quite draconian, and I will not do so based on the questions that were asked as highlighted by the defense and the opinions that were offered. The specific areas for which opinions are being offered were not inquired into, but the deposition did leave it open that I'll ask questions about any other opinions that I'm asked about or anything else that I'm asked during the course of the trial, specifically page 59, 22 through 26 on 1, page 60, lines 11 through 25. So in the abundance of caution, the court has permitted that in-court deposition. Anything else, sir?
No, sir.
State, anything else?
No, sir.
All right, let's go ahead and bring back in our panel and we can,
Before we bring the jury back in, may I approach Mr. Cacciatore on a completely unrelated matter?
does it need to be on the record or?
Yes, it does.
Okay, go ahead.
We would concede that Detective Copsell and Detective Lowen are not testifying again since they've been here in court this morning.
They're still under defense subpoena.
Okay, so this is interesting. Kevin Beck has probably, at Sarah's behest, been asked to say, why is Kepsel and Lowen in the gallery? Why are they sitting there? They're still witnesses. We could still call them.
I
We have
asked,
not,
excuse me, I asked Mr. Henderson if you guys were calling Detective Kepsel again, and he said no.
and we're not, in our defense, our direct defense, is there a possibility that based upon the information the state is going to present today or this afternoon, that we may want to receive or seek rebuttal, and possibly through these witnesses? They're under subpoena, and I'm sorry, Mr. Henderson's not here. I've just noticed her presence. Out of an abundance of caution, I think that
I've just noticed her presence. So this is 2 hours into the morning. Maybe she's just entered recently, but if she's been here since court has started, it would be pretty crazy to think that they didn't notice that they were sitting over there.
we need to clarify for the record that they're here listening to.
What's your base? Well, we're off the record. There's no jury here. That's fine. You all stay where you are. What's the basis for your sir rebuttal?
We don't know because I don't know what the state's going to place in a rebuttal. But if
That doesn't
in fact-
answer my question.
We're doing it by the fly. We haven't thought of our sir rebuttal, but we know we could have one possibly.
What's the legal basis of a sir rebuttal?
Judicial discretion as to the fairness of the proceeding that the defendant is pursuing.
Okay. Anything else, Mr. Cacciatore?
No, Your Honor.
Okay. The rule of sequestration is still in full force and effect. Detectives Lowen and Kepsel, good morning. I'm going to ask you to be excused from our proceedings and not view them and not have any communication amongst yourselves about testimony that has been previously given or any questions that have been asked or answered, and just keep your separate ways as it relates to this case and any questions or testimony that you intend to give, may give, or have give, and to comply with any instructions that were provided to you by the state regarding the rule of sequestration. Thank you very much.
It's another stupid battle. If that was one of Sarah's things, then, so she won little battle on the hill. Lowen and Kepsel shouldn't be in the courtroom. What did it get you, Sarah? What did it get you?
Anything else, Mr. Owens, we need to address?
No, sir.
Anything else, State?
No, Your Honor.
All right, let's bring back in our jury. You can continue your inquiry, sir.
So now the jury comes back. They don't know about any of this. For all they know, there was just a court matter that had nothing to do with the case. But they will notice the tone change because now Tanya Werner has no patience for James Owens. And there's a very, look how high up on his head those glasses are when Sarah bops up back out of view. Well, you can see the mark. Or no, that's not the mark. That's his glasses. But yeah, they don't rest on his ears. A lot of finger licking. Bless you. Owens has got his DNA over every page of Sarah's discovery there. Sarah's more aware than James is.
Jury's entering.
Little smile. There, I fulfilled my role as part of the legal team. They're so lucky to have me here, unshackled.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury? Yes. I thank you all. You can be seated. Members of the jury, thank you again for your patience. We had some issues I had to address with counsel outside of your presence, and we're going to continue the state's rebuttal case this morning. Again, if you could, please just raise your hands to confirm that you complied with the court's instructions during the break. Record reflect all hands have been raised. Mr. J, you may continue your inquiry, sir.
State would move to strike the last response as non-responsive.
Approach.
That's a wild way to start. Any response? I disagree. I think that's the one where we talked about where that I'm going to be able to use it to impeach her with the statements that she made in the deposition versus the statements she made today. If I'm referring to the correct response, which response is it? Mr. J, the last question I asked in front of the jury, she gave a non-responsive answer. Court, was that your opinion? My opinion was she did not give enough information to diagnose her with PTSD at the time of evaluating her at the jail. Mr. J says, well, the question before that is what's relevant. Court says, what else did you rely upon? Mr. J, no, I basically asked the same thing that my proffered question was asking. Then she gave this non-responsive answer that caused all this. The court says, I'm going to overrule your request. The question was your
objection's overruled.
What was your opinion?
All right.
The answer-
Irrespective of whether anybody has an opinion about whether Ms. Boone was suffering from PTSD or BSS, irrespective of that.
Irrespective. Not irregardless. Irregardless makes you sound dumb. Irrespective makes you sound smart.
Based on your evaluation of Ms. Boone and what she relayed to you about the facts of the case, does PTSD or BSS have any relation?
Objection, that's an asked and answered.
Overruled.
No.
And what particular part of her statements about the incident is that?
Fletcher Boy has a new hero in Super Kelly G, and the dude abides.
The whole part where she's describing the part about playing hide and seek and that they were having a good time, they were laughing. When he got in the suitcase, when she found him, they were enjoying themselves. She zipped him up. They were still laughing, you know, having a good time. All of that isn't consistent with her having a feeling of she had imminent risk or imminent, you know, there was an imminent risk of harm that she needed to protect herself.
Can we approach the bank?
Yes.
Another approach. Getting frustrated. Legal grounds of the objection. Judge, I don't object to expressing what are the legal grounds of your objection. You just said I object. What are the legal grounds? It's an improper response to a question in which the ultimate issue of fact is being asked by the prosecutor. It's an improper answer to the ultimate issue of fact is for the jury, not for her. Response? This is no different than an expert saying insanity applies or doesn't apply. It's their expert opinion on that portion of the law, and it's permissible. I do not believe that just because, says the court, even assuming that the answer embraces an ultimate issue, that didn't mean it's objectionable. I'm not saying she committed homicide. It's not saying that she's negligent. It's not saying she's punitive. It didn't go into any one of the specific elements. Mr. Owens says she's not expressing a medical opinion. She's not expressing a scientific opinion. She's expressing an opinion as to whether or not her behavior, her conduct, her statements constitute an imminent threat. That is the province of the jury. She didn't say that. Yes, she did. Mr. J, this is the exact same thing as the doctor saying that somebody didn't appreciate the legal consequences or did. There's an interaction, the intersection of the law in psychiatry when this testimony comes in, and it's not objectionable. Think about what she just said. She's ultimately telling the jury that there was not an imminent threat. That's a question for... Court says, essentially telling the jury and telling the jury are two different things. What specifically did she say, Mr. J? Mr. Owens says, she mentioned, I don't know... We can have a court reporter read it back, but it's a critical issue, Judge. It's about the issue of fact. Whether this psychiatrist, based on a history of my client, gave her 4.5 years after this event, and whether or not I believed as an expert, no. That defense doesn't apply because she was not perceiving an imminent threat. But the question didn't ask about a defense, unless I missed something. Mr. J says, I agree. It's just absolutely no different than if an expert. I think to reread the question, reread her answer. This is a critical issue about guilt or innocence that she's expressing. Court says, are you able to reread it for me? Judge, I'd ask that it be done outside the presence of the jury. To the extent possible, if I have Madam Court Reporter come up here and do that, I will do that. Court Reporter says I'd have to disconnect. Court says it's going to disconnect everything. Okay, all right. I'll take them out. Members of the jury, I have something I have to discuss with counsel outside of y'all presence. Same instruction, please don't conduct any independent investigation or research on the persons, places, or charge involved. If this reminds you of anything, it's probably because the speech was sponsored by Morgan & Morgan. Morgan & Morgan, they get their ways into every true crime podcast. Morgan & Morgan, thousands of lawyers, and who knows, maybe you'll get a good one. That ad was not paid for by Morgan & Morgan. Court says you can all be seated. Thank you, Madam Court Reporter, when you're ready. And then the questions and answers will be read back. Okay, I was going way too fast. I wish I knew when I had time to really express my inner Owens. Sometimes I'm just rushing through it, trying to get to the end before it brings court back into session. Other times I have lots of room to really let the impression land.
Members of the jury, I have something I've got to discuss with counsel outside of y'all's presence. Same instruction. Please don't conduct any independent investigation or research on the person, places, thing, or charge involved, and don't have any conversations among yourselves or anyone else with regard to that, and we'll bring you back in as promptly as possible. Thank you.
Disney Mom going off. I'm going to read this, Disney Mom. If you don't mind, I'm going to read it in my dramatic letter tone. Little unhinged, not suggesting you are, but I think there's some real passion behind your words here. Dear Tanya, I can't stand you. Those are fake pearls. Those are fake pearls. Your ponytail is ridiculous.
When you're ready.
Aren't you a bit old for ponytails? That outfit, ... Get that at Sears 20 years ago? I bet you have garlic breath. If you want to get out any more frustration, Disney, by all means, type it in. I'm doing free super chats all day. I don't have super chats. The reason for that, if you've been interested in super chatting and just like, oh, he hasn't qualified for it. I qualify. I just would rather have people give it as gift donations. So don't let that stop you from doing a troll. Like I've been in other people's chats and people buy the cheap super chat just to troll the person. You guys can just do it for free. If you guys, have something, I won't always say all of them, but you're not paying me, so I don't have to give you a refund. But by all means, if you want to put in some troll comments in the chat and just say, free super chat, and then put what you want said, do it. And then, but be classy. Buy a gift membership, just a single, $1.49, cheaper than any super chat. Just buy one. Share it, and then I'll do troll super chats. I don't mind. I'm Gen X. Nothing bothers me. Where are we now? What are we even waiting on? Everyone's reading. I feel like I should be reading something. Are we waiting for the jury? No, okay, so he excused the jury so that he can get the read back from the court reporter. Okay. Oh, no, I'm not suggesting, Fletcher boy, I'm not suggesting troll me out of, trollishness. I'm just out of humor. Beth of a Salesman is great for it. So in our It was in the Betty Broderick live streams. At some point, we were just going over the guidelines for the channel, and it's respect for Sarah Boone is optional. Number one. Number two, respect for chat is mandatory, and then number three was like use emojis if you can. I've switched number three. I can't even remember what it is now. In any case, Beth pipes up with, I thought that we were supposed to be disrespectful to members.
Read it from the question.
Like, okay, you're
Answer the
grandfathered in,
question,
Beth. We need a
objection,
little
just have
disrespect in here. Keep us on our
the- We
toes.
can buttress it.
But Beth of a salesman is grandfathered in on the disrespect. And then we happen to be watching
Go ahead.
where Chelsea is saying the,
Mr. J, question, all right?
okay, we're just getting the read back. I can talk over it.
Whether Ms. Boone was suffering from-
Is that normal? Fuck you? Like, is that what you say?
Irrespective of that, based on your
I see Scott when I come into work. I don't say, hey, fuck you, Scott. How's your day? That's not normal. That's not how normal people talk. Not malicious. Not malicious.
Owens' objection was asked.
Speaking of that, too, the interrogation. I just put out a new short.
The witness
It,
question.
did you realize there's a part in the interrogation? And really think, where
Answer.
Sarah says, I killed George. Now, of course, it's before, or it's right after she says, I'm not going to say.
They were laughing
But almost every other case, I'm not going to say what y'all want me to say.
themselves,
She catches herself, but this one time she says, I killed George.
having a good time.
So I just trimmed out the part before when she says I'm not going to say it and left it. Anyway, it's in a short that's set to Nirvana's Lithium. I kill you, I'm not gonna cry.
Any other argument,
I
Mr. Owens?
like it, I'm not gonna cry.
That invades the province of the jury. That's a decision whether or not she had imminent risk of harm or perceived an imminent threat is a question for the jury. This expert can express opinions on science, on medicine, but not on the ultimate issue of fact, and explain to the jury that this defense doesn't qualify.
Shout out to Crafting on the Floor. I believe that's the channel that's run by Hairball Yarn. If you're into crafting and floors, or both, check out Crafting on the Floor.
That you should rely on me as an expert, and I'm going to make the decision for you, ladies and gentlemen of the jury, by telling you that under the facts expressed to me by Sarah Boone, she was not perceiving an imminent threat at the time.
Besides crafting and floors, you can get kitty videos and medieval educational videos.
Response.
Judge, it's not an objectionable opinion. It's not an opinion on the ultimate issue. It's an opinion upon the applicability of a particular set of evidence that the testimony that the defense has offered, called battered spouse syndrome, to kind of help explain a portion of the justifiable use of deadly force or non-deadly force instructions. She's not up there saying Ms. Boone was unjustified in doing what she did. She is not saying that justifiable use of force doesn't apply. What she is saying is, in her opinion, based on the facts that she relies on, given by the defendant herself just a couple of weeks ago, that this particular set of testimony and evidence that has been offered through their expert, Ms. Dr. Harper, doesn't apply. This is no different than one expert coming in and saying, well, yeah, you can know that the defendant was sane at the time despite his mental illness because he ran from the police, he hid, he concealed evidence, so on and so forth. And therefore, because of those facts, insanity doesn't apply. And a defense expert may come in and say, well, insanity does apply because my client, after stabbing her mother to death, called 911, was speaking unintelligibly and singing, and greeted the officers at the door with a pair of knives and wouldn't drop the knives and was incoherent for 12 hours after the offense. Therefore, based on those facts, the expert says, well, insanity does apply. It's not becoming a lawyer, it's not becoming the juror, it is explaining a particular type of expert testimony, and it just happens to disagree with Dr. Harper's. And Dr. Harper came in and said that BSS does apply and that She was in constant fear, and the reason she's in constant fear is because of all the past episodes and whatnot. It's permissible testimony, Judge.
Any other argument, Mr. Owens?
That's totally wrong.
Everything he just said is
One of
BS,
the
Your Honor.
claims, Dr. Harper came in and said BSS does apply. That's true. But he just got through saying and trying to get the witness to say BSS, it's not to be regarded. Post-traumatic stress is not to be regarded. It doesn't even come into play. Post-traumatic stress disorder, battered spouse syndrome does not even come into play because at the time she was facing, according to this witness, no imminent risk of harm. Therefore, you can discount everything you hear, ladies and gentlemen of the jury, about battered spouse syndrome.
How does that have anything to do with whether or not it's an improper legal opinion under 90.703?
It is. It's the ultimate issue of fact
It
in
is.
this case. Because
Good
self-defense has been
good
alleged by
argument.
the defense. And the issue for this jury is whether or not Sarah Boone had the right to defend herself with force, deadly force or non-deadly force, based on her beliefs and impressions at the time, whether they were reasonable under the jury instructions, under the special jury instructions that are going to be applied for battered spouse syndrome, under the jury instructions, under justifiable use of deadly force, whether her perceptions about the threat was imminent and whether it was appropriate or reasonable to act the way she did.
Amy Zeitgeist has just opened a bottle of 19 Crimes wine. It's a dark red and seemed appropriate to the moment. So a toast to Amy Zeitgeist and a toast to the chat from her wine chalice.
This expert is trying to say that she was not facing imminent risk of harm at the time.
Thank you both for your arguments. Court is going to overrule your objection, find that it is not an ultimate issue of fact as addressed by 90.703. The court specifically relies on Dinkins versus State 976, Southern 2nd 6.
Dinkins versus State, which now I will know forever is a sexual battery case because I'm so childish. When I was reading the answer brief, the case law that was cited to help support one of the cases was Dinkins versus State or State versus Dinkins. And I just, as soon as I got it out, it was like, oh, okay, that's fun, sophomoric, maybe even juvenile line of joke, but I'm doing a serious read. So as soon as I said it's not funny, don't think about it, I kept thinking like it had to be Dinkin, like, it's not that funny that it's a sexual battery case, but I think to have a guy whose name is Dinkin in a case that hinged on whether he committed a sexual battery was, at least, I don't know. I'm immature.
60 at pinpoint 661. In that case, a psychologist testifies in the instant case in Dinkins, the psychologist's opinions were not legal conclusions. The psychologist did not opine on the defendant's guilt or innocence. Rather, the psychologist opined only as to whether the victim was, quote, mentally defective, end quote, and capable of consent to intercourse. Although the opinions did go to ultimate issues in the case, Florida law, expressly provides that an expert witness may render such opinion. See section 90.703 Florida statutes, which provides that testimony in the form of an opinion or inference otherwise admissible is not objectionable because it includes an ultimate issue to be decided by the trier of fact. Thus, the jury had the power to accept or reject the opinions and was not bound by such. For those reasons, your objection is overruled.
Madam Court Reporter, I'm just going to ask you to read the question and answer to the jury, and I have no further questions of the witness.
Okay, thank you.
I'm sorry?
He is going to have Madam Court Reporter read back the question and the answer, and then he is going to have no other questions for this witness.
I object.
Basis.
I object.
It was asked and answered.
Overruled. There was a pending objection. I'm allow the state to re-ask it so it's clear based on that objection.
Judge, it's 11:30. I'm going to be at least an hour for my cross-examination.
We're going to begin your cross-examination after we're done with the state advises the jury in open court that there are no more questions.
I don't think we're going to do especially because he just asked like that. We're going to end the stream before the cross. That'll give you guys full 2 hours in between this stream ending and SKR's stream beginning. So we will do everything right up to James Owens Cross, and then we will put him off till next week so that he can be the little bit of medicine that we take at the beginning of our stream next Friday. And then we get to watch the entire rebuttal case of videos, body cam, 911 calls, maybe even some closing arguments. All next Friday on the Sarah Boone Trial Rewatch show with a fine and dandy chat. Even a few dandelions.
Let's go ahead and bring back in our panel.
Yes, Fletcher boy. The news from, and thank my chat for bringing it to me, but that SKR has a scheduled live for 9:30 p.m. Eastern, 6:30 Pacific, so just a little over 2 hours from now. If you are trying to plan your evenings, this would be a good time to get something done in between end of my stream and beginning of that one, because the SKR streams are worth strapping in for. And further to that, I'll be putting off, like if he goes late, unless I go at 2 in the morning or something, I'll probably just do a Saturday afternoon impromptu ramble. And we'll do the Jamie Komorowski phone calls from prison. I've never reacted to phone calls from prison before, but they seem like they're good guys about little reaction commentary. I built a playlist that has some of her prior material. I can't find any body cam of the night it happened, and maybe that's for the best because it's some pretty brutal footage. For me, it's not as much about the case and the crime, which is the death of the bride who was on the back of a car that she plowed into at 65 miles per hour
Defense, do you recognize our
in a
jury?
25 mile
You may
per
be
hour
seated.
zone.
Thank you. Members of the jury.
It's about the importance of not drinking and driving, and if you do get caught for it, accepting your punishment and really thanking God that you got pulled off the road before you killed somebody and ruined your entire life. So that'll be fun. Watch that. But yeah, if SKR goes late, then look for just a fun Saturday afternoon one we'll do.
Again, if you could raise those hands. Juror number 2, back right, he gets it. All right, thank you all very much. Record reflect, all hands have been raised.
Juror number 3, position number 2, up early with the hand. Everybody having a good laugh, especially Kevin Beck. He loves to laugh. Oh, the captions make it hard for me to find a scrub moment. Okay, so just listen to the audio and you'll see that the juror I suspect is known as juror number 3. Very quick to answer Judge Kraynick's hand up question here. And you'll be able to tell how quickly he puts it up by how quickly Kevin Beck starts grinning.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury? All right, you may be seated. Thank you. Members of the jury, again, if you could raise those hands. Juror number 2, back right, he gets it. All right, thank you all very much. Record reflect, all hands have been raised. State, you may proceed.
Request to read back the question and answer.
Madam Court Reporter.
I object. Hey, Meowgarita, perfect timing because we're only going to be here for a minute. We're about to leave, giving everyone a chance to get ready for an SKR live tonight, so we might see you in that chat. Thank you for popping in. Great Suma and Meowgi all last night. Check it out if you haven't seen it. Suma and Meowgi did a great stream together. Thursday night, Suma and Meowgi.
Whether anybody has any opinion about whether Ms. Boone was suffering from PTSD or BSS, irrespective of that based on your evaluation of Ms. Boone, what she relayed to you about the facts of this case, does PTSD and BSS have any relation? Mr. Owens' objection asked and answered. The court overruled. The witness, no. Question, in what particular part of her statements about the incident is that? Answer, the whole part where she's describing the part of about playing hide and seek. They were having a good time, they were laughing. When he got in the suitcase, when she found him, they were enjoying themselves. She zipped him, they were still laughing, having had a good time. All of that isn't consistent with her having a feeling of she had imminent risk or imminent risk of harm.
No further questions.
Any cross-examination?
Yeah.
You may proceed, sir.
All right. We're not going to let him proceed because we have that kind of power. Tough luck, James. This stream, just about over. 2 minutes and 34 seconds remaining. We used up 11 of them talking about how much time there is. SKR goes live tonight. Check that out if you're a fan of the Short King Reacts. He was gifted a membership today. Thank you to Barry Adams. Barry Adams gifted 10 or 20 memberships. Bedtime Lullabies gifted 5 memberships. I missed that earlier. Oh my God. Shout out to Bedtime Lullabies. 5 gift memberships early in the stream. Sue's What? Member. 3 months celebrated today. Hairball Yarn, member 2 months celebrated today. We had a lot of fun. I hope the music's going. Let's see. Oh yeah, that's the screen. Go back to, there we go. Okay, the music's staying. This is your time to say goodbye. It's my time to say goodbye. Looking through the romper room looking glass, I see Hairball Yarn. I see Meowgarita. I see Adriana. I know you're here. You're probably on the rewatch crew, but I know you're here. I see the Hizzle, the Swiss Miss from Switzerland. I see you out there. I see Rudy Schuler, Deborah Rockhill. Looking fine and dandy in fine and dandy land. My dandelions are out there. LCB, she made the logo. That's a dandelion, that's for sure. Fletcher Boy, I'll see you in the SKR chat. Deborah Rockhill, she's celebrating 3 months of Dandy True Crime membership. Leanne Sherman, thank you for coming in. Leanne Sherman saying a little goodbye for the chat. Maybe we'll just let this play out as well. This one's called Good Energy. If you've got a membership to celebrate, now's the time to do it. Now's the time to do it. I'm paying attention. Candace, 4 months of membership. Candace, who informed me, educated me. I've been to Vegas many times, and she was talking about if you go there, you got to go sightseeing. And I'm like, what? Like the Grand Canyon? She said, Grand Canyon sucks. All due respect to the Grand Canyon. You got to come to Zion. She showed me pictures of Zion, and my God, the Grand Canyon sucks. Zion looks fantastic. Ada B's been a member for 5 months. She's got the Pro Say. You'll be upgrading to a 6-month badge. I think you're going to get your LWAP. You're going to be locked in. Rita Schuler, 4 months, also got the Pro Say. That's right, Fletcher Boy. Going to the funk. This is Diala, Good Energy. It's in the hip-hop and rap funky category. No attribution required, but that doesn't stop me from giving the credit where credit's due. Some great people out there. They deserve recognition just like anyone else. And I appreciate the fact that they don't force you to do it. Like, there's a guy whose tracks I've used and he's got the Creative Commons license. You just have to cut and paste a little thing in the description. So that's, that's reasonable. It's not asking too much. But I really love people who, when it's the least I can do, that's what I want to do, the least. And still, be good. But if you're offering me a way that, just use it, don't even give me the attribution, then I just want to go above and beyond. Elizabeth wants me to play that funky music, white boy. Play that funky music, white boy. Lay down and boogie and play that funky music till I die. Okay, I think we're gonna close it out with Give My Regards to Broadway, because I never imagined I'd be singing for a global audience as a global YouTuber, but, you know, it's a new day, it's a new dawn, and here I am. Give my regards to Broadway. Have jazz hands. The ramble is pending. If SKR goes long, it's a Saturday ramble. Whenever I wake up. Can't plan it now. Give my regards to Broadway.